Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This police unit is trying to box him in, but instead he just crashes into the tree, and away he goes. But let me widen out. I don't know how far this will take him. Yeah, he's basically cornered.
All right, welcome back. I'm still eating my lunch. All right. We're almost ready. Hang on. Apparently the seats aren't working. Have to bounce all the seats. What did I have for lunch? Grapes and cheese. It was just a snack. All right, let's turn that down just a little bit. Okay, bouncing all the seats. We're coming back. Hang on. All right, here we are. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Now the seats are working, and we can give away... yes, Camilla Juliana. First chatter on the screen. You just got massive loads of points. Congratulations. All right, I'm back. It was a short lunch. It was a very short lunch. Shorter than most. But we're back, and then we're ready for the long haul. Excuse me, the long haul this afternoon.
Hear ye.
Hear ye. Let's see. I need to search for Thurston County Courts 4. There we go. I think they're live right now, which is great. So we can just jump there when we are ready. Looking good. All right. Welcome. I did just go to lunch and came back. It was very short. Thanks for being here. Thanks for being here. I did run to the post office because I got, and I'm sorry, Paul Mac, I apologize. I didn't get your message until after I had opened it. So I can't open it on air. But this is probably one of the coolest things I've ever received. Got an incredible message here from Paul Mac. Message written with love. The item inside made with love. The story behind it is incredibly touching. And that's all I'll share. No, just kidding. Of course, I'm going to show you what it is. Of course. Look at this. Let's go full screen for let's go this one and that one. That way you can see better. She sent me a puppy. A puppy that she made out of a Recovery Addict shirt, which is just incredible. This is a full-on, huggable, lovable puppy that that has all the court... Look, go full screen here. It's got all the courthouse colors. It says Recovery Addict on the side. It's got the front, the logo, the exclamation point seat on the front that we have on the pocket. Just a beautiful, beautiful little pup. Gorgeous, extremely well made, hand stitched with pride, stuffed perfectly. This was right how I didn't have to do anything. It came out of the box like this, just like eager to go. Just gorgeous. I don't know. I didn't know you could do something like this. First of all, I mean, this is a well made pup. Look at that. So, Paul Mac, I don't know if you make these for other people. You mentioned that you'd made some, and the reason for that. But this is something people will want if you don't already. This is absolutely amazing, and I love that you made it out of the shirt. It's going to take an honored position here in my studio, and that is neat. Thank you so much. Who's a good dog? I have a puppy now. I've got a puppy. I need to move I need to move some other things to make room for my puppy. Thank you. That is absolutely awesome. Wow. That's from Paula Mack in Missouri. You need to give him a cable collar, like an HDMI, like a little short HDMI or something. Name him. He does need a name. His name shall be Buffer. His name shall be Buffer, says Bree. That's a good name. Well, let's take some suggestions. But Buffer is a good name, and I would not be opposed to that. I think it's important to have a name that fits his appearance and his purpose, which is closely related to this. We can vote. Buffer is good. Docket is good as well. Wow. Buffett and Docket, they're great. Okay. Courtroom 4 just shut down their live stream, so now I have to start it again. Give me just 1 second. Okay. We've got JTR. Oh, they were just testing it, apparently. We're waiting for them to come back. It says they're back, but I'm not seeing it yet. So they probably are. My live feed has issues with their court periodically. Go all the way back out. Wait for it. That's not it. That one. It says it's live, but when I pull it up, it's not live. If you get what I mean. We might have just a couple minutes before they start, so either way. Name her Proffer. Proffer is good. Name it Justice. Let's see. Not Proctor. Sorry, no Proctor. He shall be jury. Rob has a robot. Rob has a robot jury, and I have a puppy jury. It's a jury of one, so it's a bench. It's a bench trial. But name it Paulif, like bailiff. I'm okay with bailiff, just being the dog's name. Chloe in tribute. No, we're not gonna do that. But grounds. No. Name it Paula. Paula the pup. Pro se. Mike Bailiff.
I'm not going to argue about semantics here.
Buffer was good. Bailiff is good. Okay. We'll continue the search for an appropriate name for the pup. Which and Paul Mack, thank you so much. I'm sorry I didn't open it live. I was holding the dog, and then I pulled out my phone and I checked the message and I saw one from you. I'm like, and it said, "Please open it on live on the air." And I'm like, oh, oops, I messed up on the one thing I was supposed to do. Okay, so now they're not live, just waiting. Court is supposed to start right now. We'll give them just a minute for everyone to come in. Pick 5. We could vote for 1. I think I have to pick 4. I feel like you're really quiet. I will be louder. Is that better, Crystal? Let me check my scope. Test 1, 2. I am a little quiet, actually. Thanks for catching that. was coming in at negative 10 dB, and I can come in a little hotter with this right here. Test 1, 2. That's louder. Test 1. That's even louder. And now, court with a little bit of static in the background because that's my fan. We'll turn that down a little, just a bit, just a smidge. Test 1, 2. Check, check, check. 1, 2, 1, 2. Testing 1. Yeah, that's good. I like this one. All right, much better. Crystal, you can hear me now. Boyd the Beagle, after Judge Boyd. The court says, please, no ASMR. Now I'm frozen. I've just been holding really still. Josh says it shall be named Justice. So we've got just.
Now I'm trying to have court. You don't raise your voice.
I apologize, Your Honor. I didn't realize you're trying to have court. Let me check and see if you are actually trying to have court. So far, no. I'm not seeing it yet, Judge.
I saw a chicken fight.
We could name it Dwayne. These are good names. Although Dwayne, no, I can't do Dwayne. I would say Pickles, Justice, Buffer, and Bailiff are 4 good names. You did Greener's input for the name. I'm sure it would be good. It would be good. Can name it Jim. Who's keeping the notes? Who's keeping notes on this? Pickles, Buffer, Bailiff, Justice. So far on the short list. We might have more to add a little bit. So I've given you some horror stories. Oh, there we go. That's a different court. I've given you some horror stories about my post office, but I showed up. Red Pen's voting for Buffer. I showed up at the post office. 2 of my kids rode with me. They just finished their math. I actually waited for a few minutes, helped my youngest through his last math problem, and then they got a little break from school. And I said, I'm going to the post office, and they all ran out to the car, thinking, of course, that I was going to take the car. But I promised you I was going to ride my bike and pedal the whole way, and I did. And so when I didn't come out to the car, they came back in and said, Dad, are you coming? And I'm like, I am, but I'm out the front door with my bike. And they all grabbed the bikes and followed me. And so we rode bikes there. We parked outside the post office, which I think is a crime in my town, honestly. I believe it's against the law to ride your bike on the sidewalk in my town. No joke. Come and get me. I'll fight that one in court. But we rode to the post office, and we ran in, checked the post office box. Sure enough, there was a little slip there, so we ran inside to get the package. And John, my postmaster, already had my package. He said, I saw you guys pull up. So we ran back and got my package because, they know you. I go there a lot. They know me. They know my post office box, and they brought it out, had it just sitting there already scanned, ready for me to pick up, which was really cool. So thank you, John. Shout out to our postmaster. He's a good guy. All right. It is in most towns. Okay. I could see if people walked on the streets, on the sidewalks, that would be a problem. But nobody does. Like all day, I'm on a main road. All day in front of my house, we might have 3 people. 3 people walk by our house in a 24-hour period. Unless it's school days, and then you have probably 10 different people. But anyway, I'd like to change the law a little bit because it's against the law for a kid to ride the bike on the street. It's against the law for a kid to ride skateboards or rollerblades on the sidewalk or the street. But it's legal to ride rollerblades and sidewalk on the blade. Sorry, it's legal to ride rollerblades and skateboards in a crosswalk. You guys hear me? It's legal for a child to ride skateboards and rollerblades in a crosswalk on a street, but not on the sidewalk or in the street. So I just think the law needs to be fixed. You could name it Foreman. It is weird. It's weird. All right, we're waiting now, trying to get to court, and so we don't miss too much. It just has not started yet. Did he take a plea deal? Anybody? Thurston County Court, Courtroom 4. Not live. Name it Paula. Paula. We have a new favorite in honor of Paula. Paula. These are all good names. Paula, do you sell these? Do you like make them and sell them? Is there a way somebody else? I feel bad that I have like the only one. Is there a way to get people a link or a no, says Paula Mack. Oh my goodness. They are very sellable. Let me just say they are very, this is something people would want, especially the idea that you can make one out of something that means something to somebody. Someone's shirt or a like you did here with a channel shirt. That is just, it is awesome. I think a lot of people would compensate you for your time and money and efforts and skill to get them something like that. That is really, really cool. Paula. I still say justice because I feel it needs to be court related. Okay. Where's court? They're supposed to start right now. Does anybody have the lowdown on Thurston County really quick? Let me see if just my YouTube is not updating. Okay, Thurston County Court 4. It shows live here. Okay, so let's try this again. You have to like back out all the way out of YouTube and have it just reset.
Morning, it's Thurston County District Court. Our trial calendar for Tuesday,
I hear you.
The 23rd.
You have to bring it in from a different source.
We have some folks in courtroom, others appearing remote. These proceedings are being live streamed on YouTube to increase public access. Mr. Holcomb, good morning.
Good morning, Your Honor.
State ready to proceed today?
The state is ready to proceed. The state did make an offer to defense last night. So I don't know if there's a response.
Okay, so hold please. We're trying to get the actual feed going. I don't know why my Apple TV does not want to update with the live stream that's happening right now. We'll do it on 8. Thurston County Court 4. Okay. Let me back up just a teensy bit and get this from the beginning. All right, can you guys hear? See? What do you guys get there? We're good.
Morning, it's Thurston County District Court. Our trial calendar for Tuesday, the 23rd of September. We have some folks in courtroom, others appearing remote. These proceedings are being live streamed on YouTube to increase public access. Mr. Holcomb, good morning.
Good morning, Your Honor.
State ready to proceed today?
The state is ready to proceed. The state did make an offer to defense last night. So I don't know if there's a response to that. Depending on the answer to that question, the state does have one preliminary matter to discuss before witnesses are called to testify.
Thank you. Ms. Moore, good morning.
Good morning, Your Honor.
Is he going
I
to take
think
a plea?
Mr. Woods is still considering his options, and we would ask for maybe 10 to 15 minutes more, if that's all right.
Ooh.
I've only just gotten to advise him this morning.
Okay.
Iris, dear Santa,
my understanding is that he's talking with family about it. So the state has no objection to I acknowledge the desire to start trial as soon as possible after 9 o'clock, but the state has no objection to just 10 to 15 minutes to allow the defendant some time to consider.
All right, let's take a 10-minute recess. We have jurors waiting, so I don't want to keep them. So let's get an answer one way or the other.
Thank you.
All right, so they take a quick recess, and we're catching up to live.
We'll be in recess. So
now we're at live in the recess. All right, dear Santa, my wish is a new carpet for this courtroom, says Iris. Iris, OG, 20 months. Hope you get your wish. Kim R says, I vote for Justice the Jury Dog. Justice is a nice name. Did you update TVO OS? No, I did not. Should I? I'm always scared to do that. And I can't tell you why. This specific machine, I can't do it on. Maybe I can do it on the other. But the one we're watching right now, I do not want to update because it has a feature on it that is quite unique and not found on any other Apple TV. I should know. I've bought several of them looking for another one with this feature, and I cannot find one. But it is extremely beneficial for us. So I don't want to update it and have them accidentally fix the feature, which I like so much, but the other one, which does not have that feature, I can update. Might cause problems if you don't. I'm back on the one that I want. This is the good one. It was just slow to accept the refresh for the live feed. Can we do a poll for the puppy name? Samantha says, since Scott turned into full Santa mode, I thought it could be granted. I am not Danny on direct. I can't grant wishes. Aphrodite is capable of granting wishes if you know who Danny on direct is. Lawyer out of Salt Lake City, Utah. And a YouTuber. This is our bridge to the sentencing phase to tomorrow, so he can't take a plea. Yeah, he's got to not take the plea, I think. Are you liking iOS 26? Gracefully Broken Mom? I can tell you the lock screen looks worse. I know they designed it to look better, but all the features that make it look really cool are extremely battery intensive, and I've disabled them. So iOS 26 with the disabled cool features as the look and all that, the live whatever screen, it looks crappy on mine. So I would say no on that part, but I'm getting used to the differences, the changes in the search bars, where they're located, how it truncates things for me. It's the jury's still out. Name the dog Pro Se. No, I like the dog. Call it Mac for Paula. I believe your surname good for both. I missed Share Bear. You missed. Oh, well, they're on a break. They took a real break. Okay, so we're going to be back in just a few minutes. I'm going to click off that. Got this dog right here. And it says Recovery Addict on the side. Those are the floppy ears. And it says exclamation point seat, because this is made out of one of my shirts, the channel shirts. It's just awesome. Just gorgeous. A gift from Polymac. Arrived in the mail today. We have not decided on a puppy name yet. I like Buffer. Maybe it's because it was the first one that was suggested, but I do like Buffer. It is court related, in that we watch court and we don't like buffers, but we use buffer sound to get my attention. And you try to get a dog's attention, you call its name. I think it might work. Allison, is it a real puppy? It is a stuffed puppy right here. It's a stuffed puppy, although it looks real. Who's a good dog? Who's a good dog? See? He looks real. He's even wagging his tail. Tail wags. The whole body wags. Yeah, I've turned off about 30 of the features on the new iOS. There's actually a video out there that the guy's like, walk through these 30. You want to turn these off, and he explains why. And I've turned off most of those and a couple others. Buffer is a command, though, only the mods can use. Atticus, I see the connection there. That's a great suggestion. It's a real stuffed puppy. Yes. We could name him OG. That would work. Although calling an animal another animal's name, like goat, is probably not the nicest thing to do. Okay, let's go back up to court here. See if they're... No, I think they've got new people running the YouTube stream up there, which is not good. We might have a deal. Alyssa, you need to rewind. I got a puppy. Paula Mack sent me a stuffed puppy made from a Recovery Addict shirt, and it's gorgeous. It's amazing. I love it. Let's see. Josh, you're pushing hard for justice. I'd say it's in the top 4. Justice in the top 4. Having chicken nuggets and cheese sticks for lunch, I feel like a kid. I had grapes and cheese slices, so I'm right there with you, AC's Wildflower. You call it backup counsel. Elbow justice. His name is Woofer. Name him Polly for politics. Maybe we have to get... I like this, because Amber, I'm looking at the big picture. I'm thinking every time we have a case that strays a little bit from the pickle realm, we might have to bring out Polly to let everyone know it's going to be okay. We're gonna mention something that might be politically related a little bit, but we don't live here now. we can just hold Polly and be all right, and we'll get on with everything here soon. Maybe that works. All right. I'm not sure if I'm ready to name him. I think I need to get my kids to weigh in as well on some of the names and see if they're cool with different versions or what they suggest. We are trying to go up to Thurston County to watch a court, which should be starting any minute now. I think it's actually starting now. Let's see. Nope. Man. Okay, we're live. Let's back up.
Beforehand, as I believe that it is directly relevant to whether or not the tox is going to be admissible. And my questions, well, I guess for the troopers, it wouldn't reflect the toxicology results, but it's going to determine how I construct the latter half of my case. And I think that it's an issue that I'd rather address on the front end without having to do it in front of the jurors.
Okay, what's the issue?
Okay, so the issue that I ran into when I was looking through evidence yesterday and compiling all of the appropriate exhibits was that the credentials were not in the file that was available to me on e-prosecutor or in discovery disclosed to defense. I went on to the website. This is a publicly available website to look at the credentials of the phlebotomist. The phlebotomist is currently credentialed, and I do have their credentials. However, the renewal date occurred after the date of the blood draw in this case.
It's out.
The credentials do indicate that the phlebotomist was originally credentialed back in 2013. We do have an older copy of the credentials, but that older copy of the credentials, which does cover the November 30th of 2023 date, that's not a publicly available document. I had to actually go into like old police reports and find it. So, the DUI bench book talks about the need for a phlebotomist credentials in order to prove that the blood was drawn by someone who was duly licensed to draw blood. So Trooper Murray has worked with Washington State Patrol for a very long time. And during those years that he worked with Washington State Patrol prior to November 30th of 2023, he worked with Susanna Craig as a phlebotomist multiple times at Capitol Medical Center for a variety of investigations, and he did it after that deadline as well. So my contention is that the newer credentials, in combination with Trooper Murray's experience with the phlebotomist taken together, is sufficient evidence to prove that the phlebotomist on the date in question was a duly certified phlebotomist at the time. And I would contend it's actually unreasonable to believe otherwise unless there's some evidence to the contrary of that.
I want to hear the opposite side.
My understanding is if you look at the DUI bench book that specifically talks about credentials, it says that the proof that blood was drawn by a duly certified phlebotomist or someone who is certified to draw blood may be proven with credentials. It's not required that the credentials be the thing that proves it. Often phlebotomists are called in to testify about it. So it could also be proven through oral testimony. And my contention is that the current credentials plus the history from Trooper Murray is sufficient to lay the evidentiary basis to believe that the blood was drawn by a duly licensed phlebotomist. My understanding is that defense sees this as a potential discovery issue when it comes to the credentials because they weren't originally in the file. My contention is that it is not, in fact, a discovery issue because it's on a publicly available website that can be looked up at any time.
It's not.
It's not kept up there for the purposes of trial or for criminal prosecution. It's there available for the public to look up information about healthcare officials.
Only her current licenses.
In any context. So it's not discovery, therefore it is not a discovery violation. That's the state's perspective on the issue.
Okay, so I think, or I thought I heard you say that you had in fact found a copy of a certificate which showed she was.
Yes, Your Honor, but there is a stronger argument that that document would cross into a discovery issue because that document I was not able to find on the publicly available website.
There it is.
We had to go through older police reports to find those credentials. So I could understand the argument that that is potentially discovery because it's not something that's readily available. So we have that available as well if the courts believes that it's appropriate for the state to use that in this context. I would argue that even if it is a discovery violation, it doesn't in any way unfairly or unduly prejudice the defendant because they've known the name of this phlebotomist for a long time. She's a well-known name. She appears in numerous reports, including this one. Her signature is on the report. It would not be difficult to contact this person, so it's not a surprise that it's this person. And there's no unfair prejudice here by introducing it.
So you don't have any intention of calling Ms. Craig? She was
I do not.
On your listed witness, correct?
She is not on the witness list, and I do not have any intent of calling Ms. Susanna Craig at this time.
Ms. Moore?
First of all, Your Honor, I'm reviewing CRRLJ 4.7. I don't believe there's any. I do think that both the sort of current and allegedly publicly available credentialing document, which is renewal date after when this sample was taken being publicly available. If the state intends to introduce it at trial, I think it is discoverable material, whether or not it's publicly available. There's no such exception for publicly available material. Proof of qualification to draw blood may be established through the Department of Health's provider credential search under the RCW. But it's true that that is one way to establish it. I think the other way would be for the state to call the phlebotomist for cross-examination. I think there's been, my understanding, and this was before I was practicing, but in the last few years, there's been some back and forth where it was ultimately determined that it was permissible to establish credentialing through the introduction of credentials without the phlebotomist's presence, rather than having the phlebotomist available for cross-examination. But that, in defense's view, only really works if we have a credential that actually indicates, a credential available that actually indicates that the phlebotomist was licensed at the time of the blood draw on the date of the incident. We do not have that. I do think that there is a discovery violation here. I think, frankly, the court should consider it. This is an 8.3 issue, but moreover, a 4.7 issue. As far as both documents, particularly the one where the state has indicated that there's more reason to call that a discovery issue, I don't think that Trooper Murray is qualified to testify as to this phlebotomist credentials. And I would ask the court, I guess, to
throw out the blood draw.
Act as the court will in terms of what we do with the blood, given this situation. I don't think it should come in.
Defense was given a gift.
And I would just push back on the allegedly publicly available. If you look up Washington State Department of Health provider credential search, anyone can do this on their computer right now. And then they go to the first name that pops up, says search criteria, put in last name, first name, you click search, it brings up the credentials.
That's different than turning over discovery, which is required to be done.
I think that this is coming up morning of trial is also, I guess I probably don't need to preach to the choir there, but for the court's consideration.
Mr. Holcomb's not confident.
When was the issue of the certification coming up that did not cut? When did the state realize it didn't have certification covering the date of the draw?
Yesterday, as I was compiling the evidence together. Often credentials will appear with the initial discovery packet. Mm-hmm. And as I was compiling all of the evidence, I said, well, the credentials aren't in here. So that has happened to me before, and I've been able to search it up on the Washington State Department of Health website. And the vast majority of the time, there's a credential that explicitly covers that specific area. But given the amount of time that passed in this case, that was not the case.
But the certificate that you had previously been provided to defense?
The certificate, are you talking about the
current one? The
current credentials? It was publicly available on the website. So I did not do the process of going onto the Department of Health website, downloading it for defense and sending it over to defense. This is just as publicly available as a document.
Right. And defense position is they don't need to access that site. They need to be sent that document from the state.
Yes, Your Honor. Defense's position is it should be discovery if the state intends to introduce it at trial. Especially if the state intends to introduce it at trial to invite the court to sort of make logical leaps in order to get something else admissible, absent evidence of certification at the time of the blood draw.
I think the court has to throw the blood out. And I think the plea deal they offered was because they know that they're in a weak position. They wanted him to admit because they think if they lose the blood, this case is dismissed. Why else would they offer a last-minute plea before a one-day trial? Like we're trying to save money. Seriously. The blood is, I think it has to go. They can go ahead with visibly impaired and obstruction. I don't think they will. I think they'll dismiss the case at that point.
I would also argue that when it comes to discovery obligations, the obligation of the state is to, in particular, provide discovery that is exculpatory. And in this case, it's, if anything, inculpatory. And again, it was not made for the purposes of trial.
Exculpatory is things that would get him off.
And Ms. Moore, did you file a discovery demand?
I did, Your Honor. I've gone back into Laserfish. There was a notice of appearance with my name and signature on it filed by my office dated June 4th, which was a notice of appearance and demand for discovery.
It included a discovery demand?
Yes.
Beside the notice?
Yes, it did, Your Honor.
Okay. The blood has to go out. She asked for it. This is a technicality, but he shouldn't be finding this the day before court, especially with a case this old. They had a lot of time to find this and get this turned over where it wouldn't have been a problem. Yes, Laserfish is a program they're using for documents and tracking back and forth legal discussions digitally. I agree. The offer this morning, it was probably a sweet offer. And him saying, I'd like to see if there's an offer, and depending on how the offer goes, we might have an issue to bring up. I think the defense lawyer keyed in on that and said, ooh, we think they have a problem. Why else would the prosecution on the day of trial come and say, hey, we've got a deal for you? Unless they think that their case is weak. Mr. Holcomb, sitting there with a trainee by his side. He's now a senior attorney in this court. Experienced, he doesn't have, he's got an officer by his side. He had a trainee next to him earlier. I don't know where she went.
Document found in your files showing the certification for the date of the draw.
For the older credentials?
The relevant credential for the date of the draw.
I have not, Your Honor. I can send it over, but I have the one that's publicly available right here.
Right now, I understand that.
I received it last night, and I have yet to print it off.
So he hasn't even added it officially to the list. It's still a discovery violation. Whoa. Well, this case might be over before it begins. Fact to this case, the defendant was found on the side of the road trying to change a tire, visibly intoxicated. Tire was completely demolished. Car was parked properly. Defense is saying he wasn't drunk at the time he was driving, even though he did drive the car there. The blood draw that wasn't tested for months and months after it was drawn showed a 0.21. I believe they put something in the blood to make it basically freeze the process of, the alcohol content changing. But the phlebotomist did not have a active license on file.
And what's the duration of a phlebotomist certification?
I can present, just show you this really quick. This is what's available on the website. I believe it's 2 years or 3.
It appears to be 2 based on about 2 based on this document, Your Honor. And in light of that, I don't think that a document regarding 2013, first date being 2013, indicates that anything about November 30th, 2023.
Correct, which is why it's not sufficient by itself.
Right.
That's why Trooper Murray's experience working with the phlebotomist in this case is relevant, because it helps to close the gap. Because my contention is it is unreasonable to believe that a phlebotomist operating 4 years with the Washington State Patrol, who was credentialed in 2013, was operating without a valid license, particularly when they have current phlebotomist credentials that shows that they are in good standing with the state as a licensed professional.
Thank you.
But it's not your feelings on the issue, Mr. Holcomb, that matter. It's the law. And you've already said you're not going to call her, so she can't testify and say, yes, I did in fact have a license, which would be enough. I don't think the officer can testify and say, yes, she was licensed at the time of this blood draw. Yeah, it's not an issue of whether or not she did it right, knew what she was doing, followed proper procedure. All that is encapsulated in the law that says you have to be licensed, and the state has to prove that the person who took the blood was licensed. It's basically an element of the case. And they're trying to say, well, she was licensed before, and she's licensed now, so she must have been licensed in the middle.
It also indicate that the burden on appeal is abuse of discretion.
Thank you.
The burden on appeal is abuse of discretion? He's already thinking about the appellate impact of this decision. I'm curious if this does throw this case out, what does that do to all the other cases that the state has used her on in the last 10 years where they didn't have a license? I don't know if this is just a discretionary decision for the judge. This isn't like, yeah, I'll let you, bifurcate your closing. That's discretionary.
John, Ms. Moore, the relevant certificate?
The older certificate?
Right.
I have it I have staff printing it off right now, but I have not sent it over to defense as of yet.
You don't have it on here.
I do have it on my computer. I can show it right now.
Why don't you do that, please?
Yeah. Yep. Do you like me to approach?
No. I just want to make sure Ms. Moore it's in.
So he says he has a copy of her license for the appropriate time. It just wasn't on file. It wasn't in discovery. Cannot be submitted as evidence in this case because it would be a discovery violation. How are they going to check this box?
I'm sorry.
Is the court reading things and considering, or would the court like to hear anything from defense at this time?
I'll let you know.
Okay.
I don't know how does the jury get told, because the judge is going to read the law, And the law is going to say this has to happen. This is a step. You have to prove that the blood draw was taken by a licensed phlebotomist. How does the state say we've proven that because it's just reasonable to assume that she was because she has a license now? I don't think they can do that.
So, Ms. Moore, this was not an issue until Mr. Holcomb showed you that he had a certificate that did not cover the time period involved. Is that correct? This was not an issue for you coming in.
Your Honor, defense was aware that we had not been provided with the phlebotomist credentials prior to this morning. I've discussed this with colleagues, felt I had an obligation to my client to, the obligation to provide discovery is on the state. I felt I had an obligation to my client to wait for the state to provide it. And if they did not, then to
use that in court,
address it at trial.
I would just indicate CRLJ 4.7 going to the prosecutor's obligation says the prosecuting authority's obligation under this section is limited to the material and information within the actual knowledge, possession, or control of the members of the prosecuting authority's staff. I do believe that potentially does apply to the older credential that specifically covers the time period explicitly, but that does not apply to the publicly available information that was on the website. Firstly, because it was not in my actual knowledge, possession, or control because I just looked it up. And secondly, because I have no control over the document itself. I don't have any say as to whether or not.
Yeah, clear. So when you get a discovery demand and you have a DUI that involves a blood draw, I'm not hearing that your office just automatically got a phlebotomist certificate and then included in all the other discovery and sent it to the defense.
That is correct, Your Honor. Usually what happens, it varies from trooper to trooper, because what our office does is when we are given the discovery, we send over all of the discovery to the appointed attorney or the defense attorney after they have issued a notice of appearance. So we send them everything. And we send them everything that we have as it comes into our possession. So like as supplemental reports are filed, et cetera. So there are some law enforcement officers who include the phlebotomist credentials in the packet they send our office. And when that happens, we send it over along with everything else. But there are some officers who do not. And at that point, it depends as to when the prosecutor notices the issue. And I do confess that I did not notice the phlebotomist credential issue until yesterday when I was compiling all of the evidence together.
And it is your position that you need a relevant certificate in order to have the blood draw admitted pursuant to withdrawal by a person certified under the statute to withdraw.
I believe it is reasonable to believe, based off of Trooper Murray's experience with the phlebotomist, that
can you present your case without presenting evidence to the jury that the blood draw was by a person certified to draw blood?
Can I present my case?
Yes.
Like at all?
Can you? Yeah.
Are you asking if I can proceed on an affected by case?
No.
Oh,
as to the legitimacy of the admission of the blood result, can you proceed with that if you have not indicated in any way that the person withdrawing blood was certified to do so?
I believe there is a reasonable basis for me to do that. I believe that I can. I believe that the credentials that are publicly available on the website remove any reasonable, like any doubt in any reasonable jury.
I don't think those should come in, though.
I think your answer to my question is yes, you need to indicate to the jury that the person who withdrew blood was certified to do so. You have a roundabout way of getting there in your argument. I understand that. But you believe that you need to show that to the jury, that the person who withdrew was, or show it to me to get admission of the document. that the person was certified.
Yeah, so they were. Yeah, my understanding of the WAC is that part of the requirements for the admission of blood is for the state to provide sufficient evidence to prove that the person who drew blood at the time was in fact qualified to do so by the state.
Do you need to call her? Here comes the document. Got copies for everybody, as if that makes it better.
So that explicitly covers the dates available if much provided. These are all the same thing, just
I
think defense wins this one on the face. And the blood can't come in, which means the results can't come in. And then you have a much harder time convincing anyone of DUI. Unless you've got a charge out there for changing a tire while drunk, I think the case should be dismissed.
So there are really two facets to this. One is this is not an element of the crime, so you don't have to prove it to the jury. In order to get the blood result before the jury, you have to prove it to me that there's an appropriate foundation for blood. And the objection here is that it wasn't drawn by somebody certified by any relevant evidence until I was just handed the document that shows that, in fact,
that changes things.
At the time of the blood draw, the person who withdrew the blood was certified to do so.
I think it comes in now.
So there is evidence before the court
this has got to be a discovery issue then.
That
it's a discovery issue.
In November of 2023, that Ms. Craig was certified to withdraw blood. So you would agree with that fact? Now, I'm removing the discovery issue from it. You don't see anything wrong with the certification you've been provided, Ms. Moore. Is that accurate?
I do not. The issue, I think there's a discovery as well as a management issue in terms of the timeline of this disclosure.
Right. I'm certain you're not indicating that you believe Mr. Holcomb did this intentionally.
No, Your Honor, I'm not ascribing any malice to this. But
ascribing some mismanagement.
Yes, yes.
Okay, so this really comes down to the discovery rule then, because we do have relevant evidence that shows that the person who withdrew the blood was certified to do so. Defense agrees to that. I'm not saying it's coming in, I'm saying we have that information.
I have a copy of it in front of me, I believe, Your Honor.
All right. So the issue is, what do we do about the fact that we just presented this right now?
Now we throw the blood draw out. Had the defense had this information, it would have changed how they approach the case. He may have taken a plea deal. He may have, it could have changed everything. This is a key part of the case. Edith, when did this happen? You're green. How did I miss this? That happened this morning?
Is that a question that the court was directing to defense or defense?
No, it's a question. Court was directing to the court.
Okay.
The court was directing
Just
to the
clarifying,
court.
Your Honor.
Kelly H, thank you for the super sticker. Appreciate that. Legally Blonde. The G in my OG stands for Gangsta. 22 months, Legally Blonde. Thank you very much. Iris, member for 20 months. Both of you, OG. Both over the 20-month mark. Kim R, I vote for Justice the Jury Jog. Thank you, Kim, for your vote. Brooklyn Janet, Courtney, or Innocence, both good names. Andrew C, member for 29 months. Thank you, Andrew. Amazing, 29 months. And Kelly H gifted a membership as well. That is awesome. How do we hit Edith? Who hit Edith with a membership? Who did it? Who was it? Fess up. We tried to... It was RA to Edith? I don't think it was me. Edith, you can take a seat now. And help yourself to the emojis. Edith was green on Friday. And I missed it? Kelly H, thank you for gifting a membership. That one went to Barbie Lifts.
Document that document, which is, I think we would all agree, something that's referred to in subparagraph 447, which refers to documents that the state intends to use during the trial. And it says documents within the actual knowledge. Said you didn't have any actual knowledge, that you didn't have the relevant document. Possession or control of the members of the prosecuting authority.
And they had that.
The actual relevant document was actually in your possession. Is that correct? You just had to find it?
You mean the older one?
Yes.
So firstly,
by pursuing other police reports from files that you had in the prosecutor's office is how you discovered this document. Is that accurate?
Firstly, I would argue all of them are relevant, but this specific document, yes. The way that we tracked it down is that I actually called Trooper Murray last night trying to find the credentials on the website. I wasn't able to do it. And he very helpfully looked through prior reports, which I believe there were reports that were also sent over to our office, but it's law enforcement. But yes, we had to go through police.
Your office had.
I believe so. I don't have a reason to believe we did not have access to this report.
Bellatrix,
under the possession or control, it may not have been under the knowledge, but it was under the possession or control of the state that you discovered that you actually had the relevant document.
Yes, Your Honor.
Okay.
Blood draw doesn't come in. Judge, I think that's the only thing to do.
Just as an aside, it strikes me somewhat curiously that your office doesn't have a process that every time there's a blood draw, it automatically goes to the site, makes a copy of the phlebotomist's declaration and puts it, or certification, and puts it in the discovery packet. I don't know why your office wouldn't have that as a backup. When it's, law enforcement apparently have different standards. Some send it, some don't. Why don't you just do it in every single case? That's a head scratcher to me. Because then if you don't, we have these conversations. So that's a hard one to understand.
Correct, Your Honor. And I can understand seeing a discovery issue with that specific document.
Yeah. Whether I'm going to let you get to the roundabout, I don't know yet. I haven't ascertained. I've heard what you've said, that you believe the current document and Trooper Murray's familiarity with Ms. Craig in your mind is enough to allow you to not argue to the jury, because you have to convince me that you can make the blood draw comes in. So that's really your argument to the court, is that Trooper Murray's history and the current certification.
Correct. And one of the reasons I have Trooper Murray in here is so that he's able to answer any questions that the court may have.
Right. No, I'm pretty sure he's going to say he's worked with her a long time, never known her not to be certified, and now we have a document that says she's certified. And you do have a document that was available to the defense, not provided to the defense, that she is currently certified. So I understand the logic of your argument.
And was certified as far back as 2013.
I think this, I mean, I don't like the idea this gets thrown out. I think if you commit a crime,
is more if I take the position that, yes, the state should have provided this to you. They have a somewhat disorganized discovery process in the prosecutor's office where they don't automatically send you a document that would be relevant in any blood draw case. And we're now seeing it on the morning of trial, that the appropriate remedy would be to continue this case. And I understand you would say, well, no, it's coming in the morning, and so you should suppress the evidence. If I decide that that's not the appropriate remedy, that it's pretty clear to me that it's quite clear to me that the withdrawal of blood was by somebody certified to do so. So suppression of the blood result, I think, would be inappropriate, but if the only remedy is continuance, to what end would a continuance serve the defense needs?
Your Honor, I don't think the only remedy is a continuance. I think the court.
Well, no, I understand you would like me to suppress the blood results because of the late provision of a document that shows certification was in effect on the date. I understand that. If I decide that that's not the appropriate remedy, that the appropriate remedy is just to say, okay, you've been provided, is ill-advised on the state's part, they did provide it, and I'll give you a week or two to look at the document, but to what end?
Yeah, I would strongly object, Your Honor. I would ask the court not to allow this to be admitted. We have a jury impaneled. Mr. Woods is present. He has been working night shifts the last 2 nights and is still present for trial. There's substantial prejudice to him with a continuance. I understand the court's position. I think that this is, again, not ascribing any malice to Mr. Holcomb. I would move the court to either not grant that continuance or to dismiss under 8.3 due to mismanagement.
Thank you.
Okay, yeah. The argument that we have a jury literally in the back room waiting. That's not, oh, we'll just get a continuance. Sorry, guys. Good try. And I think it's so dang sneaky that the state comes in and tries to, Mr. Holcomb comes in and says, hey, I got a new plea deal for you. How about this? Will you take this one? No? Okay.
So the remedy you're asking for, Ms. Moore, is suppression. And
or dismissal.
Sanction section indicates that would be as a result of a willful discovery violation or gross negligence.
I think that's dismissal would be in 4.7 if there's a willful violation or gross negligence. I'm reading 7.
Any other such order as the court deems just under the circumstances.
Yes.
So that's where you're trying to squeeze suppression in?
I don't think I'm trying to squeeze it in, Your Honor. I think it fits there.
Okay. But that's your argument is under that language is where I should go to suppression.
Yes.
And you do see that right before that it says grant a continuance.
But you've got a jury. It's the day of court.
So I'm going to go back to you, Ms. Moore. I'm not going to suppress the evidence.
Understood.
So I'm willing, reluctantly, to say I'll grant you a continuance, but the question becomes why? We all know what the evidence is. So is there any basis to be served in responding to that document to say, okay, go to trial next Monday?
Now take the plea.
There really isn't, Your Honor, but I think, again, this is...
Okay.
I would ask the court to consider the 8.3 issue also.
Yeah, so Holcomb is getting his way. It's coming in, and court's going ahead.
We're going to proceed to trial. I don't find any basis to object, or there is a basis to object, and defense has noted their objection. We'll note that objection to the admission of the blood draw result. As to the certification of the phlebotomist, that issue I'm determining is now resolved. I will accept the certification of the phlebotomist. You'll have to lay whatever other foundation you have for the admission of the blood, but it won't have to deal with the certification of the phlebotomist. I'm a little frustrated by the fact that we had to have this conversation. And I wish there was a way I could sanction the state for that. Because I believe that this is such a standard document as part of a DUI case involving a blood draw that the state needs to be much more on top of it. And I'm not speaking specifically as to you, but there ought to be an office process for making sure that a phlebotomist certificate in a blood draw case is provided to the defense, regardless of whether it's readily available on the site or not. So, or you come to an understanding with defense. You send them, here's the link, you go look at it. However you decide to do it, but that information needs to be part of discovery. And it's frustrating to me that we're having a 45-minute long conversation about this, hour-long conversation about this on the day of trial. So I would assess financial terms against your office, but I don't want them to take it out of your paycheck, Mr. Holcomb. I hope your office understands the frustration this causes the court when a procedural issue like this, which is so easily handled, becomes so convoluted. If I thought that in any way this would affect Mr. Wood's ability to present a defense in this case, then I would be suppressing the results. But it doesn't. So I just want to express my frustration that we've had to have this conversation. And I just hope your office sort of reviews all of its discovery rules. This discovery should not be a problem. We need to have both parties coming in with all the information so that they know where they stand. Okay. So we'll make part of the record for the purposes of appeal if the defense ultimately decides to appeal this. Do you mind if I take this copy and...
Yeah, so just to be clear, which credentials does the court wish for the state to, is available to the state? Are we using the one that's currently publicly available or the older one?
We're using both, and attach them so that if there's an appeal, the appellate court can look at both and see what we have.
Understood. And
did you have a number that you had already chosen for admission of the phlebotomist certificate?
I did for the one that's publicly available. Yeah. I had Miss Lopez mark it.
What's the number?
I think the sanction.
Department of Health. It should be Department of Health.
The sanction should have been to either lessen the charges or limit the penalty. There has to be some sanction. The prosecutor's office is not going to be like, oh, judge told us off, we're going to change our ways.
Because I believe number 6 is the blood vials and number 4 is the refusal ticket.
There is a prejudice against the defendant for this. Late disclosure, it changes how they prepare for trial.
A15B?
After opening statements.
Yep.
New evidence comes in. It's a discovery violation. It's allowed to be
5A
used.
and 5B.
I think this has appeal written all over it. Unfortunately,
if you want,
by the time he's ready to appeal it,
can do is I can go up and
his sentence will probably be over.
there if you want, or you can flash it. It doesn't. I mean, yeah.
The defense wasn't given many opportunities to argue. The
All right, and
the state argued a lot and kept.
The defense has made their argument on this. We have a record of that. We'll note the objection.
Yeah.
We'll give Amy a moment to make sure the documents are marked. So the relevant certificate, the one relevant to the time of the draw, is 5A. 5B is the current certificate. The one that was on that I gave you.
This prosecutor is not responsible for his office's procedures. It's his case. He's responsible, personally.
Yes.
I don't know why the judge said, I don't want to see this come out of your paycheck. Whose paycheck should it come out of? Unless it's the person who's responsible for the mistake.
It goes up.
Yeah, does he have his other? Okay.
So this one's we're getting en route to the hospital, so they're at the jail. They're going from the jail to the hospital. So this is having to get back in the car. This is at the jail.
Don't get them just yet.
Don't get the jury
Hold on
yet.
just a moment.
Well,
But you don't have to walk back here because I'm about to.
Yes, of course. I haven't shown it to you.
Walk back.
Yeah.
I'm about to somebody. But I want to check with counsel before you do.
But all of it's body cam stuff.
yes.
Okay. Are we ready for the jury, or Ms. Moore, does my decision on the blood draw change the defense position on going to trial?
I don't believe it changes defense position. No. We're prepared to proceed.
All right, let's bring the jury in.
Now I'm actually rooting for the defendant here because I think that was shady by the prosecution. I haven't heard the evidence yet. He might be guilty of sin. Hoping he's not. Or at least I hope there's reasonable doubt here.
Okay, they're doing a restroom break. Go ahead and have a seat.
Hey, Miss Zari, how are you doing? Oh, a little Miss Zari, sorry.
And I'll just remind counsel we kept the jury waiting for an hour, so I would hope that both of yours examination of all the witnesses is concise and to the point.
Don't blame the defense for that one. Don King says, I don't care if he's guilty. I'm rooting for the defendant. I think that was the wrong decision. I think suppression, and the judge looked at it basically saying, if I suppress this, what'll happen to the case? It'll pretty much ruin the case. Well, then I won't suppress it. That's the wrong way to look at it. If I don't suppress this, what happens to the defendant? Then he's prejudiced. He's been... Because a continuance wouldn't help, he asked if it changes the defense case by now having the certificates that don't, so they go on. I see that part, but I don't think we should have gotten that far. I think... And I see that... Because it's not an element, right? Because showing the phlebotomist credentials is not an element of the charge, it has to be proven to the jury. It only has to be proven to the judge. That's what the deciding factor was. If this had to be proven to the jury, this case would be thrown out. But because it's only proven to the judge decides what's right and what's wrong. And he looks at it, and it doesn't, to him, it doesn't matter if we just found out now or we found out before. He's like, well, I'm finding out that it was in fact true that on this date that he was pulled over, she was licensed. I just found out this morning. You just found out this morning. We just got the document right now, but it was true. Because of that, the licensure is not an issue. It's just a discovery issue. And I see that, but I think that the defendant lost in every single one of these. And especially if they had, like she said, the defense lady said, they have talked about this. They have said this is going to be part of our strategy at trial. to attack this because it wasn't provided and it should have been. It changes their preparation. It changes their approach to trial. Wonder what the plea was. Well, I don't think I've ever started more firmly on the not guilty side. State, you've got a hurdle. We all should start at this point with every defendant, but here comes prosecution calling the first witness. That's going to be the witness chair. Hopefully all the mics are working.
You see it.
This is a DUI and obstruction case.
Good morning, folks. My great apologies for the long delay. We've had a significant evidentiary issue we've had to discuss in here before starting the trial presentation today. So my apologies. When you came in, you were all stayed standing. The parties are standing every time you enter the room. They're standing out of respect for the role that jurors play in our judicial system. So when you come in, you feel free to just go ahead and have a seat. We'll make them stand until you sit. All right. Thank you, folks, for being here again today. Mr. Holcomb, call your first witness, please.
Yes, Your Honor. The state calls Washington State Patrol Trooper Claudia Travis.
I guess there's no sequestration rule. The other officer gets to stay here.
Other disadvantage, folks, of not having an actual courtroom. We don't have a witness room right outside where we could go get a witness. They're off in some other, what used to be office someplace, so they have to go track them down. So once again, they're not a very efficient place for us to conduct trials, but this is what we have.
For now. You have to go knock on all the doors in the hotel, see which room he's in. We are waiting for a witness.
Travis. Step up here, please. Raise your right hand for me. Swear that testimony in this case to be the truth, the whole truth, and nothing but the truth.
I do.
You may have a seat.
Thank you.
Please state your name and spell it for the record.
My name is Claudia Travis. My first name spelled C-L-A-U-D-I-A. Last name T-R-A-V-I-S.
Okay, and what is your current occupation?
I'm currently a trooper with the Washington State Patrol.
And what are your current official duties?
I'm patrol as a law enforcement officer in King County.
Okay. What do you do when you're on patrol?
Look for traffic violations, enforce the laws of Washington, and criminal offenses.
Okay. What was your status with Washington State Patrol on November 30th of 2023?
I was a trooper cadet, and I had not gone to any official training at that point.
Okay. So at this point, were you primarily an observer?
Yes.
Okay. Did you go on to finish the academy?
I did.
Okay. Are you currently a fully commissioned Washington State Patrol trooper?
I am.
Okay. On the night of November 30th, 2023, were you riding with anyone that night in the patrol vehicle?
Yes, I was riding with Trooper Murray.
Okay. And is he seated in the courtroom today?
Yes, he's over.
Okay. What type of vehicle were you in?
Washington State Patrol patrol car.
Okay. Could you just describe what it looks like?
It's a white Ford Explorer with Washington State Patrol markings on it with emergency lights.
Okay. What were you wearing that night?
A trooper cadet uniform, a state patrol jacket, and then a State Patrol baseball cap.
Okay. And were the words State Patrol clearly visible on hat and jacket?
Yes.
All right. Do your official duties require you to be familiar with the boundaries of Thurston County?
Not specifically mine, no. Mine are King County, and then at that time I had no official.
Okay. On the night of November 30th, 2023, did you and Trooper Murray encounter a disabled vehicle?
Yes.
Okay. Do you recall where this vehicle was located?
It was southbound I-5. I don't know the exact exit number, but like the Nisqually area.
Okay. And do you recall if that was in Thurston County?
Yes.
Okay. All right. Can you describe for me what the scene looked like as you and Trooper Murray pulled up to this disabled vehicle? You're in the patrol car. What are you seeing?
The car is pulled to the shoulder, to the right of the freeway, and there's somebody changing I think it was the front right tire squatted down like by the vehicle.
Okay. Is that person in the courtroom today?
Yes, he is.
Okay. Can you just point them out to the jury?
He's over here and he's wearing a white shirt.
Okay. And do you know who that male was? Like, was he identified?
Yes. His last name is Woods.
Okay. So not sure about the first name?
I think it's Dewan.
Dewan?
Dewan.
Okay.
Should lead it.
Overruled for that purpose.
All right. And how was the defendant identified? Like, what did you use to identify them?
He was identified by his Washington State license.
Okay. Did you see any other occupants in the defendant's vehicle?
No.
Did you see anyone in the immediate area other than yourself, Trooper Murray, and the defendant?
No.
Okay. Did you see any vehicles stopped nearby?
No.
Okay. Do you recall if the defendant ever told you how his vehicle ended up on the side of the road?
I don't recall.
Okay. Do you recall if he was the registered owner of the vehicle or who the registered owner of the vehicle was?
I don't recall.
Okay. So you hadn't gone to academy yet at this point, correct?
Correct.
Okay. So you hadn't received any formal training as to how to identify impairment, correct?
Yeah, correct.
Okay. Have you, before that date, had you been around people who had consumed alcohol?
Yes.
Have you, like, before that date, ever consumed alcohol?
Yes.
Okay. So are you familiar with what someone looks like after they've consumed alcohol?
Yes.
Okay.
Have you been drunk? Yeah. So you know what it's
like.
Did
you observe any signs of impairment from the defendant?
Yes.
Okay. Can you describe what those signs of impairment were?
Yes. Objection, lack of basis. Your Honor, she's just indicated she didn't have formal training on impairment.
All right. Well, I will allow lay witness to testify as to observations. Go ahead, Mr. Holcomb.
So I'll ask again, what were the signs of impairment that you observed?
He was trying to change his tire extremely close to traffic, and was walking into the lane of travel on a freeway multiple times. And then he was like unstable when he was like squatting down, he was stumbling around.
Okay. Did anyone tell him that he was in the roadway?
Yes. Trooper Murray had to remind him multiple times to not walk into the road.
Okay. Were there other vehicles present on the highway that day?
Yeah.
Did any other vehicles take that exit?
It's a pretty busy freeway, so I'd assume so, but I can't directly recall.
Okay, so you don't directly recall?
No.
Okay. But there were other vehicles passing by the highway, right? Yeah. Okay. Would it be accurate to say they were what speed were those vehicles going?
Freeway speed, so the speed limit is 60, but usually people go a little faster, so 60, 65.
How many OKs do we have so far? Up to that one.
Traffic.
We're going to count OKs.
Did traffic cause the vehicles to go at a slower rate than they would otherwise be legally allowed to be?
No, I don't believe so.
Okay, so we weren't dealing with back-to-back traffic jam, correct?
Oh, no.
Okay. Did you conduct the field sobriety tests?
No.
Okay.
I think
did you observe someone conduct field sobriety tests?
Yes.
Okay. Who was that?
Trooper Murray.
Okay. So we're at the point where the field sobriety tests are done. So prior to this, could you describe the defendant's general demeanor at the scene?
I think he was relatively cooperative.
Okay.
To answer the question.
Okay. After the field sobriety tests and the defendant was the defendant placed under arrest?
Yes.
Okay. Did the defendant's demeanor change after he was placed under arrest at any point?
Yes.
Okay. Could you describe that to me?
We're at 21 now.
He was making like lots of comments and threatening to fight if the cuffs weren't on, and calling Trooper Murray and I names.
Okay. So we're talking about what the defendant said. So before arriving at the jail, did the defendant like physically do anything out of the ordinary?
Before arriving at the jail?
Yes.
I mean, he is in the back of the car and he's just threatening that if he gets out of the cuffs, he's going to fight.
Okay.
People don't generally say that.
Okay. So when you arrived at the jail, so because went from the scene to the jail, correct? So when you arrived at the jail and did the defendant get taken out of the patrol car?
Mm-hmm.
Could you describe the defendant's demeanor upon being taken out of the patrol car to the BAC instrument room?
Yeah. As he was getting out of the car, he was trying to pull away from Trooper Murray, and he had to like pull him back so that he didn't leave.
Okay. You're using a lot of he's there. So, and we got two males interlocked together. So I'm trying to clear that up just a little bit.
What?
So, so you said that the defendant did something that caused Trooper Murray to take action, correct?
Yeah. Mr. Woods was attempting to pull away aggressively, and Trooper Murray had to restrain him so that he didn't get away.
Okay. Do you recall if anyone else at the jail responded to help?
I don't recall into the BAC room, no.
Okay.
But
okay. So once he's in once he's in the BAC room, can you describe the defendant's demeanor in the BAC room?
Yeah. He's still making aggressive comments towards Trooper Murray as he's trying to go through the process, and he was like name calling and things as he was being read the paperwork that he needed to be read. And then I remember he tried to like lunge towards Trooper Murray, and the jail staff came to help, and I think Trooper Murray had to like hold him where he was at because he was like trying to come up out of his chair. Okay,
so this is the second time that the defendant moved in a manner that required law enforcement to take action.
We're counting Ks, Ks and OKs.
Do you recall roughly how many people had to respond to help with the situation?
I know multiple people from the jail staff came outside. I would say from my memory, at least more than 3 people came outside to put additional restraints on him.
Okay. What do you mean by additional restraints?
The jail staff had like, they're not handcuffs, but ankle cuffs that they put around his feet.
Shackles.
Okay. And those weren't on him previously?
No.
Okay.
Try not to miss any of these.
So were you in the BAC room at the time? Well, firstly, did you observe the defendant actually in the BAC room?
Yes.
Okay. After the BAC room, returning to the patrol vehicle, can you describe the defendant's demeanor?
He was still being aggressive, name calling, threatening to fight as we were moving to the hospital.
All right. So you keep saying name calling.
Let's hear those names.
I have to say these more often than you need to, but can you just tell me what you mean by name calling?
Yeah, I believe he was calling us bitches and stupid and dumb, I believe. And I don't have any other direct exact things, but there was lots of different variations of similar comments made.
And he hurt my feelings.
I'm showing you what has been marked as plaintiff's exhibit number 9. Can you describe what that is to me?
A flash drive that says at the jail.
Do you recall being shown videos earlier today?
I do.
Okay. And do you recall what is on that specific flash drive?
I believe that at the jail one, there's like voiceover from a mic pack at the time of the jail.
Okay. So you know what's on the flash drive, correct?
Yes.
Okay. Is there anything else on that flash drive to your knowledge? Okay.
Okay. That as well.
Were you present for what is depicted in the flash drive, or recorded in the flash drive?
Yes, it was.
The state would move to admit state's exhibit number 9 and to publish to the jury.
Any objection, Ms. Moore?
I don't believe defense has a basis to object.
I'm sorry?
I don't believe defense has a basis to object.
What? Just simple no would work.
It will be admitted. You may
Permission.
publish.
Yep. Thank you.
We get to listen to this warning.
And
we might
before
hear
you,
some names.
you play it, Mr. Holcomb, I'll indicate to the jury, in my instructions yesterday, I told you that exhibits admitted will go with you to the jury room. That would be except for electronic exhibits. So pay attention to what you see here now, because you will likely not have it in the jury room.
Your Honor, permission for defense table to approach so that we can see.
Of course.
Thank you.
Granted.
Bring your chairs up if you wish. That's no problem.
We just want to hear it. That's all we want. We want to hear it. Well, maybe we don't. This might be all the bad words.
Everyone able to clearly see the television?
No, we can't see it at all. You said no.
Make sure that the volume is working even.
Northwest's going to translate for us. Thank you.
Get back to the beginning of the video and playing at the beginning of the video of Plaintiff's Exhibit 9.
We're going to watch the judge's expression. Judge is expressionless. I think this prosecutor thinks the strongest evidence he has in this case is the names the guy was calling people. It's awfully quiet. Like those three monkeys, you don't get to see the evidence, hear the evidence, or speak the evidence.
And that's the end of the video. So in the video, we heard someone saying that, first of all, we heard someone cursing. Do you know who that was?
Mr. Wood.
Okay. And he said something about being on the floor and cuffed, correct? Could you tell me what he means by that? What is he talking about there?
Yeah, at the point that he attempted to lunge at Murray, he held him in the chair until jail staff got out there. And then when the jail staff got out, they placed him on the floor to get the handcuffs on his feet. And they were attempting to get him stood up back to his feet again.
Okay. So is that what we're hearing? Is that the audio that we're hearing of that part of the incident?
Yeah, it's the after that incident occurred where they have him on the ground cuffing him and trying to get him back to his feet.
Okay. And is this before or after entering the BAC room?
That's after. You were already in the BAC room.
Okay. Do you know if body cams were in wide use with Washington State Patrol at this time?
They were not.
Okay. So the video that we just saw, what was that recorded off of?
I don't know the official term, but it's a mic
potato
pack that like picks up the sound.
Okay, so that's the audio, but I mean the video.
Oh, the front of the patrol car.
Okay. Instead of, do you know which patrol car?
Trooper Murray's patrol car.
Okay. I'm going to remove this just to, oh, actually, I'll just leave it there. So after the defendant was placed in the patrol car heading to the hospital, could you describe the defendant's demeanor between the BAC room, the jail, and to the hospital? Can you describe his demeanor in the patrol car at that?
He still maintained the same aggressive behavior towards us, making threats and not complying with commands.
Okay. This happened back in November of 2023, but do any of his words or
in the patrol
threats
car
stick out to you in your mind?
If the cuffs were off, he would fight is like what I remember mostly him saying.
Okay.
And I believe he said I don't remember if he used the word punch or.
Okay. I don't want you to guess. If you don't recall things, just say you don't recall things. I don't want you to have to feel like you have to gap fill here. So you arrive at the hospital. What was the purpose of going to the hospital?
To apply for a search warrant to draw blood because he had refused the BAC test.
Okay. And when you arrive at the hospital, was it both you and Trooper Murray in the patrol car again?
Yes.
Okay. And when you arrive at the hospital, did anyone assist with escorting the defendant from the patrol car to the room where the blood was drawn?
Yeah. Two more officers came. A trooper and a sergeant came to assist.
Okay. Do you remember if hospital staff was at all involved?
I don't recall.
Okay. So did anyone at the hospital have to physically respond to anything the defendant was doing? Or was it more of a presence?
I don't recall because I was outside of the room,
okay,
the hallway, because of his demeanor. I allowed them to handle him.
Okay. I do not have any further questions for this witness at this time, Your Honor.
Okay. Welcome. Ms. Moore.
The video still.
Yeah, let me go stuff. Sorry.
Morning. Morning. My name is Catherine Moore. I'm the defense attorney. I only have a couple of questions on cross. So just clarifying and confirming. So I believe I heard you say that you repeatedly that you were observing Mr. Woods attempting to pull away aggressively. Is there a way for someone under arrest to pull away that you would, in that situation, that you would not characterize as aggressive? Not in the manner that he did it. Just yes or no is fine, but I hear you. And I believe I heard you say that there were at least 3 CEOs that responded to help. Is that right? Once you got to corrections officers, I should say, at least 3 corrections officers that responded to reinforce once you got to the jail. Is that correct? Correct. Okay, so in total, there were a minimum of 5 law enforcement officers in the room with Mr. Woods and one of him. Would that be fair to say? I would say that would be fair, but I don't have a complete recollection of the exact number. Okay. I guess minimum of 4 because you weren't actually an officer yet at this point, correct? Yeah. Okay, you hadn't been to the academy? No. So all of the things that you've testified to, they're just sort of lay recollection. Mm-hmm. All right, no further questions.
Mr. Holcomb, anything else?
Briefly, Your Honor.
So defense referenced the defendant moving aggressively, as you just testified to a little bit earlier, correct? Let me put it this way. Did Trooper Murray have to do did Trooper Murray's actions stop the defendant from doing something?
After he pulled away, is that what you're asking?
Yes.
Yes.
Okay.
He had to physically pull him back, and I believe he pressed him against the car to stop him from pulling away. So,
but for those physical restraints being applied, what would have been the likely immediate result?
It appeared as though he was attempting to fight, so a potential fight could have ensued.
Okay, but at minimum, less control over the situation, correct?
Correct.
Okay. Nothing further, Your Honor.
Or anything else?
Not for Ms. Travis, Your Honor.
All right, thank you. Mr. Trooper Travis? I don't see any objection to Trooper Travis being excused. Mr. Holcomb?
No objection, Your Honor.
Ms. Moore?
No objection at this time, Your Honor.
Travis, you are done. Thank you very much for your testimony.
Thank you.
Yeah, we're on 63. Sorry about that. I was a little behind. I'm trying to get everything.
Your Honor, the state calls Trooper Jonathan Murray to the stand.
Who is in the courtroom right now. No sequestration of witnesses in this trial, apparently.
All right, raise your right hand for me. Swear the testimony in this case will be the truth, whole truth, and nothing but the truth.
Good to hear.
Yes.
All right, please state your name and spell it for the record.
Name's Jonathan Murray. The spelling on my first is Jonathon, and last is Murray.
All right, and how are you currently employed?
I'm a trooper with the Washington State Patrol.
And how are you employed on the date of November 30th of 2023?
I was a commissioned trooper with the State Patrol.
Okay. And what were your official duties at that time?
As a trooper, I'm assigned to District 1 Olympia, which covers all of Thurston County. Part of my duties are primarily responding to calls for service, collisions, on top of that, doing traffic enforcement. Okay. What sort of training did you have to go through to become a Washington State Patrol trooper? I attended a 26-week Washington State Patrol Academy. In the academy, we learned various laws relating to traffic, motor code, and criminal law. I've received training from the State Patrol to recognize subjects who are under the influence of alcohol, drugs, or both. In the academy, we receive 40 hours of training where we get to, or there's written tests, there's practical exams, and then at the end, we do what's called a wet lab, where we get members from the public to come to the academy in a controlled environment. And where they
I'll allow the testimony.
Continue.
Where it's a controlled environment where people voluntarily or drink alcohol in a controlled environment. And then we as cadets get to take what we've learned at the academy and actually use it. Okay. And you talked earlier about tests and exams. What would have happened if you failed to pass any of these tests or exams? At any point for anything in the academy, if we didn't pass or if we failed anything, we would be retrained and retested. Okay. And is it possible to graduate the academy without passing those exams? No, it's not. Okay. So how many years did you say you were with Washington State Patrol again? I was hired by the State Patrol August 9th, 2019. Okay. And when did your official duties as a patrol trooper start? I was commissioned September 30th, 2020. Okay. And in your role as a Washington State Patrol trooper, how many DUI investigations approximately would you say you do in a given month? Currently, I work day shift. I've been on day shift for about a year, so the number's not that high. Working night shift, on average, it's probably 1 to 2 a week. Okay. And were you working night shift at the time of this incident back in November of 2023? I was. Okay. So 1 to 2 a week for roughly 2 years, 2 or 3 years prior to this incident? Okay. So on November 30th, 2023, were you working that night? Yes. Okay.
So he's done about 150 on the top end.
In what capacity? As a trooper. Okay. Do you recall approximately what time your shift started? I was working the 4 p.m. to 2 a.m. shift. Okay. What were you driving? I was driving my issued fully marked State Patrol vehicle. It's equipped with lights and sirens. It says State Trooper on the side. Okay. And was there anyone in the vehicle with you? Now Trooper Claudia Travis was riding with me. At the time, she was a pre-academy cadet and was assigned to me for observation rides. Okay. And what were you wearing? Were you wearing what you're wearing now? What's this uniform right now? Okay.
Not this exact uniform because that was years ago, but maybe it was. We're issued one uniform.
As part of your official duties, are you required to be familiar with the boundaries of Thurston County? Yes. Okay. Why? That's my assigned jurisdiction. Okay. So you're assigned to work in Thurston County. Okay. Were you on the date of the incident, November 30th of 2023? Yes. Okay. On the night of November 30th, 2023, did you have an occasion to come across a disabled vehicle? Okay. Do you recall where this disabled vehicle was located? It was northbound I-5 on the exit ramp to Nisqually, which is exit 114. Okay. And is that located in Thurston County? Okay.
Up to 85 on the OK counter. 3 of those are defense.
What is marked as plaintiff's exhibit number 8?
I'm filing the workers' comp claim for my OK clicker.
Can you just describe that to me? Like, what is that?
The USB device with the label initial encounter.
Okay. And have you seen what is on that flash drive?
Yes.
Okay. What is on that flash drive?
It's dash cam video from my patrol car for the initial encounter.
Okay. And is it a true and accurate depiction of that encounter?
Yes.
Okay.
The state moves to admit plaintiff's exhibit number 8 and to publish to the jury.
Ms. Moore.
No basis to object, Your Honor.
Grant the motion to admit, and you may publish.
It's a weird way of saying no. No basis to object. So here's another one we're not going to get to see. This is changing the tire. Might go for a few minutes. Just hang in there. We'll get through this, and I'm sure the prosecutor is going to tell us exactly what we saw. Maybe we can at least get audio this time. Hmm. 4M, how are you doing, Michelle? Welcome. I'm surprised the defense didn't ask for the sequestration rule. A lot of times the lead investigator is accepted from an exception to that. Maybe they did. Was that in the... Might have been motion to eliminate. I might have to go back and look at that. I probably won't do it, though. It's not that important to me. Walker, we're finding areas they can improve. I guess he's still working on getting it set up because defense has not moved over to watch it. You cooked something and it was soup. Was it soup before you started cooking it? Or was it just like you started mixing things together and it became a soup? He's still working with the cables. I still think this should have been thrown out. The blood draw should not be in.
All right. Is this what you were expecting to see on this flash drive?
Yes.
Okay.
No, that's a home video that I don't know how you got. There was an okay in there.
Okay, is everyone able to see the screen clearly?
I'll file the same motion. I cannot see any of the screen.
Just so we're able to get reference, where is this location?
Northbound I-5 exit ramp to Nisqually, exit 114.
Okay, so what is that?
That's the exit ramp.
Okay, so that's the actual exit.
Correct.
Okay. And the two people who are approaching, who are those individuals?
That's myself and Trooper Travis.
Okay. The male that's depicted in the photo next to the car, who is that?
Mr. Woods.
Okay. And is Mr. Woods present in the courtroom?
He is.
Can you just describe what he's wearing briefly?
He's wearing the dress shirt and the slacks.
Okay. And was this, was the defendant identified as part of this investigation?
Yes.
What was used to make that identification?
His Washington driver's license.
Okay.
careful, man. This is a roadway.
Well, don't know. I'll tell you right, the fog line will work for you. But there's something sitting next to the fog line. It's not very safe.
So, do you hear what the defendant was saying there?
Nope.
What he was trying to do?
Change his tire.
Okay. Just very briefly, going to close. Well, I'll just finish the video first.
So don't go on the go. You're going to get hit.
So, did you catch what you said to the defendant there?
I asked him if he needed a tow truck.
Okay. And do you recall what his response was?
I believe he said he just needed to change the tire.
Okay.
Get a spare.
So he's still trying to change it. Okay.
Oh no.
So, you asked the defendant a question there.
Mm-hmm.
Do you recall what that question was?
I said, where did this happen at?
Okay. And it's a little grainy in the video, but is the defendant doing anything in response to you asking that question?
Yeah, he's pointing south of our location, indicating it happened somewhere south of us.
Okay. I'm going to rewind it back just a little bit. We can hear his response.
Oh no. That's why I don't know. That's why, okay. You being back, I think
Can't hear Jack.
Okay. Were you able to clearly see the fog line from where you were standing?
Yes.
Okay. So it's a little foggy there. Do you hear, did you mention anything about the traffic?
Did I mention
anything about the traffic using that exit?
I'm sorry. Did I mention anything
Yes.
like in my report?
No, to him just now.
I told him, you're in the roadway. There's cars coming. They're probably going faster than the speed limit, or at least going 60. You need to stay out of the road.
Okay.
You in the car? In the car? Yeah.
What was the question you asked there?
If it was just him in the car.
Okay. So do you recall his response?
Yes.
Yes, as in,
yeah.
Okay.
How many OKs did I miss? Sorry, I've been distracted.
Yeah, I got it.
So you asked him for something there.
His driver's license.
Okay. Did he provide it?
He did.
Okay. Were you able to see into his vehicle?
On the initial contact, the first thing I did was look inside the car, see what was in there. I noticed various boxes and a couple bags, I think.
Okay. Did you notice anything about where they were situated related to the seating inside the vehicle?
All the seating in the vehicle was occupied by something. So in my head, it would be unreasonable to assume that anyone else was in the car with them.
Okay.
Because the front passenger seat had, I think, a PS5 box or something on there. And then the rear seats were also occupied.
Okay. Did you recall seeing anything about this vehicle indicating when it had been driven?
So standing out there, it's a cold night. It's November, late November. I could feel that it was still warm while I was standing next to it.
Next to
the vehicle.
Okay.
On top of that, I did respond to a collision north of that location about an hour prior in Pierce County, and that vehicle was not there.
Okay.
That's pretty good evidence.
This happened, according to the dash cam, at 19:09:45, right?
Mm-hmm.
And I'm not in the military and I hate math. So can you tell me what 19:09:45 is?
7:09 p.m.
Okay. And your shift started at what time again?
4 p.m.
Okay. So had you passed by this location before this?
Yes. En route to the collision in Tacoma, Pierce County. I think that was around 5:45 p.m., somewhere around that time, about an hour prior that his vehicle was not there.
Okay.
I'm just using the mouse button to click OKs instead of using the other mouse to put people on screen. That's good evidence that the car was driven. The heat from the engine and having passed by previously and the car was not there. I think those two things together can argue the point that he drove there recently.
Okay. So again, the audio's kind of hard there.
Terrible for us.
Did the defendant mention anything about whether he had consumed alcohol that night?
Generalized, I said, have you had anything to drink today? And he said he did.
Okay.
I've had like 4 waters.
Did he ever indicate as to how recently he had consumed alcohol?
Not up to this point.
Okay, but he does later?
Yeah.
Okay. Do you recall what he said?
I believe he said he had a couple drinks earlier, a few hours prior to driving.
Okay, so a few hours prior. Okay.
It's like we get to hear a little bit of audio and then it just cuts out.
Just really quickly there. Did the defendant indicate who was driving the vehicle?
He stated he was.
Okay. And what was the reason that he pulled over to the side?
When he noticed his tire was flat, pulled up.
Okay. And he said, what was he trying? What did he say he was trying to do when you showed up?
His tire.
Okay. Did he plan on doing anything after changing the tire?
Driving.
Okay.
He's going to talk himself into a conviction here.
So a little bit there. Firstly, I'm going to show you what's been marked as State's Exhibit number.
You forgot to get it numbered. Send it over to the clerk to get a number.
Do you know what that is?
That's a picture of the tire that Mr. Woods is trying to change on the vehicle.
Okay. Did you take that picture? Okay. Is it an accurate depiction of the defendant's tire that day?
Yes.
Okay. Is there anything, so in your time as a Washington State Patrol Trooper, have you had to respond to disabled vehicles on the highway before?
Yes.
Like a few times, many times?
I would say daily we respond or stop out with to assist motorists. Yeah.
Okay. And is often the reason they're disabled due to a tire issue?
Yeah, there's a lot of flat tires that occur on I-5.
Okay. Does that appear to like any different from the average flat tire you would respond to?
On the video, you can hear when I approach, I say, "Oh, you got a flat tire," and then I realize that it's much more than that. The tire's just about completely off the rim, and the rim's chewed up, indicating it had traveled some distance on the roadway before coming to a stop.
Okay. Your Honor, the state would move to admit plaintiff's exhibit number 2 and publish to the jury.
The objection is one. It is admitted, may be published.
Okay. I'm going to pass this over to juror number 1. May I approach, Your Honor?
May.
And when you're done looking at it, just pass it down the line, and then I'll pick it up from juror number 7 at the end when you guys are done with it.
Show and tell is being passed around. It's a picture of the tire. I imagine it was probably a shredded tire, one that's been driven on when flat, and the sides are just completely mangled, you know. That's how it was described previously. Jurors are taking their time looking at the tire, wondering why this is important for a DUI case. Maybe this goes to show that intoxication caused him to drive for an extended time on the tire.
So what were you able to conclude based off of what you're seeing from that tire? Like how did it get like that?
And basic, I
Objection calls for speculation, but
You're gonna need more foundation if you want.
Understood.
Are you a tire?
You responded to flat tires beforehand.
Yes.
How was this different from the average flat tire?
I'll allow the description there. Go ahead, Trooper Mike.
This is pretty significant. Either an object was struck to cause something like that, or it was driven on a flat tire for a good period of time.
Okay. And I'm going to continue playing plaintiff's exhibit number 8. We're currently at the 5-minute and 33-second mark. So right there, you're talking about that you want to look at their eyes. What do you mean by
that? Voluntary tests, field sobriety tests.
Okay.
To look for nystagmus.
Okay. Is that a specific test?
Yes.
What's the name of the test?
It's horizontal gaze nystagmus. It's part of the standardized field sobriety test.
Okay. And can you just describe the basic procedure of that test?
Sure. The first thing we do are pre-checks, medical checks, make sure there's no resting nystagmus, make sure there's equal tracking, equal pupil size. And then we go into the actual test and we're looking for nystagmus, which is involuntary jerking of the eye. That can be caused from CNS depressants, which is what alcohol falls under, affects the eye muscles. So when we see the nystagmus, and there's various clues, there's 6 clues, that helps us to investigate if there's impairment.
Okay. Okay, and you asked the questions that you do at the beginning of HGN. Did he talk about consuming alcohol at that point?
Asked him if he had just had a couple drinks, because I asked him if he had any other drugs.
Yeah.
His answer was no.
Yeah, and did he say approximately when he last consumed alcohol? Okay, a few hours. Okay.
Well, that's it. Okay. And that's it. Well, man, I'm just gonna take a look at your eyes. Okay. You put your heels close together for me, then what? So arms down at your side. The top of my face right here. All of them are here. Okay. Okay.
Hearing the okays in the video. I'm counting those 2.
Okay.
I just found a spare roll of Smarties in my office, which I'm going to consume right now, which will probably put me to sleep as soon as the sugar wears
did you
off.
have any difficulties administering the HGN test there?
He kept moving his head and wasn't following instructions to keep his head still.
Okay. And did he volunteer to take this test?
Yes.
Okay.
I'm all out of candy after this. This is all I got. No Smarties last forever. But I do need to go to the store and get Halloween candy here soon, because it sells out before October. It could have been from that. It could have also been from Sweetwater ordering equipment. We're hoping this video ends soon so we can get back to testimony and more okays. Then you eat it before Halloween? Yes. We do. Only the best ones. We'll open like the Reese's and the Snickers and the good ones, and then we'll have the leftover like
So what are you doing with your hands there?
So in my hand, I have a pen, which is stimulus, and I'm using my finger as a contrast background. The instructions are to follow the tip of my pen with his eyes. And so I'm going side to side. There, I was doing the pre-medical checks, making sure there's equal tracking. There's no resting nystagmus, and pupils were equal size.
Okay. Is the flashlight directed at the defendant's eyes?
No, it's positioned in a way where it's just the edge of the light is on his forehead, so I can see his eyes.
So the focus of the flashlight, is that where the focus? Okay, yep. So it's past his head, correct?
Yep.
Okay.
Waldo, I've never been. I drove by it. I should go visit. I think they have a wing named after me. It's a long video. What is Sweetwater? Sweetwater is the name of a company that sells audio video equipment as well as instruments, musical instruments. And I try to buy almost all my gear through Sweetwater because they give a 2-year warranty on top of the manufacturer's warranty. So if something breaks, which we've had happen a couple times, it's always helpful if it's under warranty. I love B&H. Their selection is bigger. They're also quick shipping. Their prices are great. They're spot on the same on the price. But Sweetwater has a little better service for me. I've been to the RA wing. It's all cables. Well, this gig coming up this weekend, I've actually been thinking, do I need to order any more cables? Should I just order some just in case?
So, how many clues are there on the horizontal gaze nystagmus test?
There's a total of 6 clues.
Okay, how many clues did you observe?
6.
So what does that mean?
So there's lack of smooth pursuit, which we're looking for, just going side to side. That was present in both eyes. And then distinct and sustained nystagmus at maximum deviation. That's when we go all the way out, hold it there. And we're looking at both eyes. Each one is a clue. Saw both clues there. And then onset of nystagmus prior to 45 degrees. So when you slowly go out to that 45-degree mark, and if you see it, that's a clue in both eyes. So a total of 6.
Okay. And aside from horizontal gaze nystagmus, did you observe any other signs of impairment?
Upon initial contact, obviously I saw the wheel. That shows me driving. Maybe there's something hit. He was fumbling around with the jack. He had issues controlling the jack. Appeared to have some balancing issues. Stepping back into the roadway. He wasn't following directions. Didn't realize the danger he was in. Smell the odor of intoxicants consistent with alcoholic beverages. When I looked at his eyes, they were bloodshot and watery. Obviously, the clues observed on HGN.
Okay. And around what time of night was this?
7 p.m. Around 7 p.m.
Okay. Around 7 p.m. Okay.
I've got to turn counting over to one of y'all.
And after the HGN tests, was the defendant eventually placed under arrest for DUI?
Yes.
Okay. Did you perform any searches instant to arrest?
I did.
Okay. Did you find anything of evidentiary value on the defendant's person?
In the defendant, in Mr. Woods' pocket, I located the keys to the vehicle.
Okay.
In some states, just having the keys is possession is, they can get you for DUI. It's crazy.
So prior to the defendant being placed under arrest, how would you describe the defendant's demeanor?
I would say he was cooperative.
Okay. After the defendant was placed under arrest into the patrol vehicle, did the defendant's demeanor change?
Initially, no.
Okay. Did his demeanor change at all at any point that night?
After we left the scene to go to Lacey PD to offer the breath test, he started becoming verbally aggressive, verbally abusive, calling me names, calling Trooper Travis names, and then made several comments that if we pulled over and took the handcuffs off, he would fight us.
Okay. And did that in any way change your approach to the investigation? What he was saying in the back of the car?
When he started becoming uncooperative, instead of going to Lacey PD, I decided to go to Thurston County Jail, mainly because I knew that there would be staff there to assist if needed.
Okay. And upon arrival at the Thurston County Jail, was additional staff needed?
So we arrived to the jail, attempted to take him out of the car and escort him to the BAC room. When he pulled away from me, had to restrain him to get control. We went into the BAC room. And it's standard practice that you go in there by yourself. No one else is needed. Mr. Woods was causing such a scene in there that a deputy inside the correction facility came out and walked in, which is the only time that's ever happened. And
that's ever happened to you, correct?
Correct.
Okay. Okay. In your time with law enforcement?
In my time, I've never had a deputy come in, on their own.
Continue.
Assist. Inside the BAC room, he started yelling, calling me names repeatedly, and not following. I was trying to read his constitutional rights again and the implied consent warning for breath, and he just
objection.
The objection.
I don't know the number, but motions in the limb regarding being read as rights.
Yeah, the implied consent, I believe, is part of the basis for the refusal.
Yeah, I don't think that's something that was prohibited in the prior motions that will allow the question and the answer.
Okay, so you were trying to read him, and after, as you were doing that, what was he doing?
He was just shouting at me.
Okay. So did you eventually offer or ask the defendant if he would submit to the BAC test?
Yes.
What is that? What is the BAC test? What does BAC mean in this context?
Blood alcohol concentration. So the way that we administer and detect, we have a instrument. It's the Draeger. It's the device or the instrument that we use to collect the sample, determine what the alcohol concentration is.
Okay. And how does someone provide this sample?
It's a breath sample.
Okay. So so it's a breath sample. How do they provide the breath sample?
Well, what are the instructions or?
Yeah. So I've never seen a BAC instrument in my life. So let's pretend I have no idea what a BAC instrument is. I don't know what it looks like. What does it look like? How is it administered?
Let's pretend.
Yep. It's a device. It's pretty big, sitting on a desk. There's a tube connected to the device, and basically you have to provide 2 breath samples. Requires you to take a nice deep breath, good seal around the tube, and provide a continuous breath sample until the sample is collected.
Okay. Showing you what has been marked as plaintiff's exhibit number 4. Can you tell me what that is?
This is a ticket from the BAC machine. In this case, it's a refusal ticket, just documenting that the subject refused to take the test.
Okay. And do you know who generated that document?
I did.
Okay. Is it a true and accurate reflection of the document on the night in question?
Yes.
Okay. The state moves to admit plaintiff's exhibit number 4 into evidence and to publish to the jury.
Any objection, Ms. Moore?
Relevance?
I'll allow the admission of the exhibit.
Thank you, Your Honor. Permission to publish?
Why don't you hold on to it? You don't need to do that.
Okay.
Judge says no on publishing, but it's admitted. I don't think I've ever seen that before.
All right. On that ticket, did you sign that ticket?
Yes.
Okay. Was it signed under penalty of perjury? What does that signature certify?
It's certified that I followed the guidelines of the tests and did it properly.
Okay. And it says the word refusal on it, correct?
Correct.
All right.
Got a rare all right there.
Did you explain to the defendant or attempt to explain to the defendant so you said it earlier, implied consent warnings, correct? Can you just tell me what that is?
Implied consent warning. It's a document that we read to the subjects prior to administering breath. We read it verbatim, and basically at the end of it, we ask them if they're going to take the breath test.
Okay. And in this case, did he take the breath test? Okay. After that ticket was generated, can you describe what happened?
So while I was entering the refusal in the breath machine, the deputy that had come in observed Mr. Woods attempting to get out of his handcuff. Prior to that, he had made threats that he was going to fight. The deputy approached Mr. Woods. I believe he grabbed his arm in an attempt to prevent him from getting out of his restraints. At that point, Mr. Woods lunged up out of his chair towards me, and I assisted the deputy in holding him in the chair until other people could respond and help gain control.
Do you recall roughly how many people responded?
I don't remember exactly, probably 4 corrections deputies.
Okay, so approximately 4 corrections deputies. Okay. How many deputies does it typically take for you to be able to generate a refusal ticket?
0.
Okay.
0?
So after the 4 other deputies respond, can you describe what happened at that point?
So at that point, the deputies kind of took over. They escorted Mr. Woods to the ground. They placed the ankle handcuffs on him to restrain him and prevent him from injuring anybody.
That sounds gentle.
Or himself. And then he was escorted back to my patrol car.
Okay.
I don't think it was as gentle as that sounded. 69. There we go. Thank you, Camila. Keep me honest on this one.
Exhibit marked as plaintiff's exhibit number 10. Can you just describe what that is to me?
It's a USB device labeled en route to hospital.
Okay. And have you seen the video that's on that flash drive?
Yes.
Can you just tell me what it is?
It's the video and audio from the rear seat of my patrol car.
Okay. Would you say that it accurately reflects the events of that night?
Yes.
Okay. The state moves to admit plaintiff's exhibit number 10 into evidence and to publish to the jury.
Ms. Moore?
I don't believe defense has a basis to object, Your Honor.
Will be admitted. Will allow the publish.
There might be some language on this one. Let's see if we can hear this. Might be the one we don't want to hear. Still waiting. And waiting. We may live stream Halloween trick-or-treating this year again. Yeah, it's always the one that
clearly see
the problematic ones that we were able to hear.
Okay. Is this what you were expecting to see on the flash drive?
Yes.
Okay.
Can you approach?
Of course.
Of course. I don't think there's a limit to this counter. I could probably get it over 10,000 without a problem. Any guesses as to how many pounds of Halloween candy we give away this year? I won't know until Halloween, but get your guesses in. What was it last year? I think we were close to 25 or 30, right? Do a FOIA for all the videos we can't see. We could, but the process is probably really long, and then we wouldn't get them for like a month after the court. Maybe we could just ask the court to wire in their TV into Zoom as a display. How much do you spend on Halloween candy? About a house payment. No, not that much. I'm thinking we'll probably have 35 pounds of candy, 35 to 40 pounds of candy on hand for Halloween. We don't count pounds, but we did have 679 trick-or-treaters last year. That was a lot. My son bought a breathalyzer for his bachelor party. Stacy, I know trick-or-treating is a lot of fun. Usually it's fun in my neighborhood. It's just, I've lived in places where obviously growing up, trick-or-treating was big when I was a little kid. And then I've moved to places where there wasn't much.
During this, so you had a different view than us, and you actually heard it with your own ears. Do you recall what the defendant said there?
I'm drunk as F. Drunk as.
Huh?
Drunk as fuck.
Okay.
Change on my fucking tire in the side of the road. I don't know.
Whoa.
And fuck you and the horse world, you hear me? And a big boy in your mouth. Wait. You got shit to say. Yeah, you go. Bitch.
Suddenly we can hear. I don't eat much candy, actually. Come on. Judge isn't impressed. I think he's ready for a break. Looking at the jury.
Mr. Welcome, we pause that approach, please.
Yes, Your Honor.
I think I called it. This is live. That look. What are you doing? What are you? Just looks at the clock. Says, "Look at the time. Look at the time." Why are we showing this? What's the relevance? Ask them to move on. I think the judge regrets not striking that blood evidence.
Folks, feel free to stand and stretch while you're waiting. I know you've been sitting there for a while.
long time.
We are at the relevant portion. I don't anticipate needing any more than 45 seconds.
Thank you. Go ahead.
We'll take them up. And this is up. It'll be a little fight. Where you're at, I can't find it. Yeah.
He said, okay. He just wants to play the bad words. That's all Mr. Holcomb's trying to do.
All right. This was a snippet of the evening, correct?
Correct.
Would you say this was representative of a large portion of the evening?
Yes.
Okay. Is this behavior out of the ordinary for you when it comes to getting a blood draw?
Yes.
Okay. All right. So upon arrival at the hospital, what happens?
At that point, I applied for a search warrant and was ultimately granted one.
Okay. And what happened when the defendant was taken out of your patrol vehicle at the location of the hospital? Can you describe that chain of events?
I believe we notified the security staff at Capital Medical Center of the situation. They had they pretty well staffed with security there. They had a number of people come out and assist.
Okay. Do you recall roughly how many? This happened back in 2023, but do you recall roughly how many?
At least two.
Okay, at least two. And were they security staff?
Yes.
Okay. And can you describe the defendant's demeanor from the patrol car to the room of the hospital for the blood draw?
Pretty much what you saw in the video there. Nothing really changed. He was that way with everybody there, the staff, even the doctor that was trying to do medical clearance.
Okay. Did he make any threats?
Just that he wanted to get out of the cuffs so he could fight.
Okay. And did he make those statements just to you?
Primarily towards me.
Okay. Did he make it towards anyone else?
At the hospital,
Mm-hmm.
All I recall is that he was fixated on me.
Okay. So do you recall at what time the blood draw was done?
I don't recall the.
Okay. Would a copy, did you write a report for this case? Would a copy of your report refresh your recollection as to the time frame? Okay. I'm approaching you with what has been marked as Plaintiff's Exhibit number 3.
Here's the blood draw, or the report about it.
Spiritually.
Yeah, okay, go ahead. It
appears to be my entire case file.
Okay. Towards the end of it, Can you just look to see if it says anything about the time the blood draw occurred? After you have refreshed your recollection, please flip it over so that it's face down on the table, and then look up at me when you're ready.
Read your report.
Can't find it. It might be in my actual report. Let's see if I put it there. Do we have page 7 of it?
Do you have does it say when the warrant was acquired, when you got the warrant?
The warrant time is on here.
Okay. Can you just put it face down after you've seen it, after you've seen the timestamp? Okay. What time did you get the warrant?
21:14 hours.
Okay. And approximately how long after you got the warrant was the blood draw?
I'm not sure what time it was drawn.
Yeah.
I'm looking for page 7 of the.
Yeah. Was it within 15 minutes, 30 minutes, 45? Like roughly how much time between the warrant and the blood draw?
I don't recall.
Okay. Approximately how long did this investigation take you? Just in hours?
From the very initial contact?
Yes.
Between 2 and 3 hours.
Okay, between 2 and 3 hours. How long does the typical DUI investigation take when you're getting a blood draw?
It varies. Sometimes collisions are involved, medical clearance is involved.
Okay, just a situation where you don't have a serious collision, it's just come across someone, you arrest them for DUI, take them to the instrument machine, take them to the hospital. How long does that typically take?
Between 1.5 to 2 hours.
Okay, between 1.5 to 2 hours. So would you say that this took significantly longer than how that process normally takes?
Yes.
Okay, and would you say that the defendant's actions that day directly contributed to how long it took?
Yes.
Would you say that the defendant's actions that day contributed to the amount of law enforcement personnel that were required?
Yes.
But for you taking physical corrective action that day, would you have been able to do your investigation? But for you physically at times restraining the defendant or having to do things in response to what the defendant was doing affirmatively, would you have been able to conclude your investigation?
It would not have been safe to do so without physical.
Okay. Did you witness the blood draw? Okay. Do you know who performed the blood draw?
Was who drew the blood?
Yes.
It was a phlebotomist that works at Capital Medical Center, which is the hospital we went to.
Okay. And do you remember the name of that phlebotomist?
Susanna Craig.
Indy Cindy, OG, 27 months. Hello, friends. What's happening today? We're trying to get through this DUI case, which is dragging on, but I think we're getting to the faster parts here. We're up in Thurston, getting ready for going back to our Florida trial tomorrow for the sentencing phase. Red pen. One more witness.
Come together, I asked.
Showing you what's been marked as plaintiff's exhibit number 5A and 5B. Do you recognize those two documents?
Yes.
Okay. Can you tell me what they are?
This looks like it's stamped with from the Department of Health. Verifies the status of the medical assistant phlebotomist certification for Susanna Craig.
Okay. And is the certification date on that document or on both the documents?
Yes.
Okay. On 5A, what is the certification period?
At the top one.
Yeah.
The expiration date, or
so the renewal.
That says last renewal date was July 29th, 2022.
Okay. And what was the expiration of that specific credential? When did it expire?
September 12th, 2024.
Okay. And this incident happened on what date?
November 30th, 2023.
Okay. So that's within the.
Correct.
Okay. And on the 5B.
You don't need to do that. That was just for other reasons.
Okay. Do you know Susanna Craig?
We've worked numerous times together.
Defense's standing objection.
Noted.
Okay. In what capacity did you work with Susanna Craig?
Susanna is a phlebotomist there at Capital Medical Center, and throughout various other DUI investigations, she's been the phlebotomist.
Okay. How many years would you say that you have worked with Susanna Craig as the phlebotomist?
In my entirety, I've worked in Thurston County my entire career, and she's been.
Objection relevance.
Oh, wow.
Okay, so she was a phlebotomist before the date of this incident, correct?
Correct.
And she was on the date of this incident, correct?
Correct.
And she still is a licensed phlebotomist, correct?
Objection relevance.
Oh, wow.
Okay. Your Honor, the state moves to admit.
It's previously been admitted. She'll take back the report, which has not been admitted. Thank you.
All right. So is there a procedure that you are meant to observe for when the blood draw is effectuated?
Yes.
Okay. Could you describe what the phlebotomist is supposed to do when you are observing the blood draw?
So we are issued from the State Patrol, we are issued tubes for the blood, and we both verify that the tubes are not expired, they haven't been tampered with, if there's a white powdery substance in the tube, and then I observe her take the blood from the defendant.
Okay. For the process of her taking the blood, could you describe what the phlebotomist is physically doing from the beginning to the end of the blood draw?
Well, they assess where the best point is going to be for which vein they want to draw from. Once they pick a spot, they clean the area of injection. They use either water, soap and water, or iodine or something similar. They don't use alcohol wipes. And then I observe the blood draw, and I observe the blood placed directly into the tubes.
Okay. And was that procedure followed in this case?
Correct.
Okay. I'm showing you what's been marked as plaintiff's exhibit number 6. You describe what that is.
These are the tubes that were used that night, and they contain Mr. Wood's blood.
Okay. How do you know that?
Because these are the tubes that I placed into evidence.
Okay. How do you know that?
It's got Mr. Woods' name on it and his date of birth.
Okay.
And the case number.
Okay. The state moves to admit state's exhibit number 6 into evidence.
The objection is more.
Okay, I'm going to stop
I guess
counting
I
as
would
okay, so
question
we're over
how
200.
relevant it is, how necessary it is, but.
Okay, counter is going away.
It's
I
admission.
just can't focus on it.
Okay.
Over 200.
And what did you do with those vials? Well, first of all, are there multiple blood vials there?
There's 2.
Okay. What did you do with those blood vials after the blood was placed into the vial?
I secured them back into the box that they came in. I kept custody of the vials after Mr. Woods was booked in the Thurston County Jail. I transported them back to our Tumwater office, and I put them in the evidence.
Okay. And earlier you said that typical procedure is that the tubes have the powdery substance in them, correct? Was that substance in these vials?
Yes.
Okay.
Powdery substance in the vials. What? Just kidding.
And were those vials sealed? Nothing further at this time, Your Honor.
Thank you.
All right, folks, it's 11:50. I think what we'll do is we'll take our lunch break now, and we'll come back at 1:30 to continue with cross-examination with Cooper Murray. I'll remind you that the prior instruction I gave you yesterday, that is not to discuss the case either with each other or with anyone else at this point in time, still applies. So enjoy your lunch. For those who haven't spent any time up here, there's nothing up here, with the exception of a new coffee shop just about a quarter mile down to the west of here. But beyond that, there's nothing up here on the hill. So I'll give you some additional time to get to wherever you wish to go have lunch or a break. So we'll be back here at 1:30 to continue with testimony. And just
1:30.
Let Amy know when you're back, and we'll gather you all back there. And as soon as we have everybody present, we'll proceed with testimony this afternoon.
That's an hour and a half. What are we going to do for an hour and a half,
and
Judge?
you may leave your notepads in the deliberation room. We'll secure that room for you, so they're there. Any issues? Hey, can have seat. Any issues to take up before we recess?
Not that I can think of this time here.
Not from the state at this time, Your Honor.
Okay. I promised the jury we're doing a one-day trial, so we're doing a one-day trial. So just counsel, remember that.
Understood.
Okay, we'll Murray will sit back there 1:30.
So, promise the jury one-day trial.
Mm-hmm.
So, totally and 1,000% understand if this is not an option. But are you willing to stipulate to the blood coming in? Because if not, there are questions that I have to ask about the process, about storage, etc. And it's totally fine if you're not willing to stipulate to that, but it is figured out in the question.
No.
Okay. Yeah, that's fine.
The state's now saying, hey, help me out. Will you stipulate? The judge is doing his robe thing. Whoa, is this a tease? What are we seeing? Okay, the full tie reveal. Wow, there you go. I'm too sexy for my robe. Too sexy for my robe. So sexy. Yeah. Anyway, now what? I think Mrs. Aria is singing. Let's jump down here for a minute.
All right. When was the last time you had a job other than the family farm?
That was for Jeremy Austin, tight wire construction.
How long ago was that?
Approximately 6 months to a year. I can't.
Well, it sounds to me like you probably will qualify fairly easily, but fill out the form that the deputy has and put both your case numbers on it. Like I said, you can always still hire an attorney, but I want to be ready to go to preliminary hearing come October 10th on these two cases. So
yes,
whether you hire an attorney, whether you apply for court appointed, whoever your attorney is going to be, make sure you talk to the attorney about both these cases before that October 10th date so we can keep it moving.
Yes, ma'am.
All right. Okay, anything further, Ms. Gillette?
I can't think of anything.
We have a bond set.
Yeah, it's 50,000.
50,000, that's probably the bond schedule. All right, I'm going to leave it at 50,000 unless you talk me out of it, Ms. Gillette. Talk me into something worse, or if he wants to talk me into something less.
I just wanted to make sure there was GPS on it. We know that him and Ms. Mitchell are not having contact. I believe that was already a condition.
Okay, this is that other case that we needed to maybe talk about, Bond, isn't it? I think you wanted GPS on that, but it may not have been ordered previously at hearing. Missy, this is the right case, isn't it?
No, Judge, this is the new case that you did put GPS on the warrant when you signed it, I believe, Friday.
Okay, but you don't think he had another case that needed it as well?
Well, there was another case that didn't have GPS on it, but he has GPS on this one, so.
All right, so GPS 50,000 will be the order continuing. Now, if you and your attorney want to come back and revisit that at a later date, we can, but you're going to have to talk to your attorney in order to do that. All right, if there's nothing further, Mr. Gordon is remanded to the custody of the sheriff at this time and will be in recess on this case.
Is that his own shirt or is that somebody else's shirt?
All right. Now that covers everyone in the jail for this docket, Deputy?
Yeah, except for my extradition.
Okay, I think we're going to look at him in a little bit. All right, let's take up Boyce on the record at GW 2025 TR 442, State of Kansas versus Michael Lynn Boyce. County Attorney Jill Gillette for the state. Is Michael Lynn Boyce here? Looking for Michael Lynn Boyce. First appearance on driving while suspended. Apparently fails to appear. Ms. Gillette, have you any recommendations on his failure to appear?
Date requested by bench warrant, Your Honor.
Bench warrant is ordered and bond will be set at $2,500 cash or surety required, as this appears to be a first time driving while suspended and not a subsequent. All right, moving along then, we'll call DeVore on the record in GW 2025 CR 165, State of Kansas with Stephen Corrigan DeVore.
Judge, this is the one that Mr. Paul is on, and he said he wasn't going to be able to log in until about 2 o'clock.
Well, I show it is about 2 o'clock, 1:58, but he hadn't logged in yet, right?
Right.
All right, Mr. DeVore, you are Mr. DeVore at the courthouse, is that right?
Yes, ma'am.
Okay, as you may have just heard, your attorney expected to be here by 2, but he's not quite, so I'm going to move on to someone else and come back to you, okay?
Okay, thank you.
So stay put. Now, you're welcome to stay right there if you want, unless I call somebody else to take that chair. All right. Is Mr. Elam here? On the record
yes,
in GW 2025 TR 48, State of Kansas,
yes,
Joshua Daniel Elam. Is it Josiah or Joshua?
Joshua.
Okay. Screen to me looks like it says Josiah, but we're going to call you Joshua because that's what it's filed under. All right. State of Kansas versus Joshua Daniel Elam. County Attorney Jill Gillette for the state. Defendant in person and pro se. Again, you are Joshua Daniel Elam, correct?
Yes, ma'am.
Sir, this is your first appearance. You failed to appear 1, 2, 3 times previously. March 4th of 2025, May 27th of 25, and August 5th, 2025. Each time a bench warrant bond forfeiture being issued with your bond increasing. But because you've never apparently been here for first appearance, 4th time hopefully will be the charm, you're charged in count 1 with having one-way glass or a sunscreen too dark for your windows as allowed by law, an unclassified misdemeanor.
A tint?
Fine and jail time possible on that. Count 2, driving while suspended. That is a B misdemeanor up to 2,500. Let's see. It's a B misdemeanor. The fine could be up to $1,000 and your sentence could be up to 6 months in the county jail.
Wow.
Because the potential sentence is as high as 6 months, you do have the right to apply for court-appointed attorney. You also have the right to hire an attorney, or you can waive your right to an attorney and represent yourself. What do you wish to do, sir, on the issue of attorney?
Apply.
Court appointed. I suppose I'll apply for a court appointed.
All right. And are you employed, Mr. Elam?
Yes, ma'am.
Where do you work?
Lee Aerospace in Wichita.
Oh, you're not
And
going
what
to
do you make per
qualify.
month at Lee Aerospace?
It's right around 5,000, like 5,200.
I don't think you're going to
I can
qualify.
almost assure you that you said 5,200 is going to be more than an indigent findings where you would be entitled court appointed. Do you think at that amount of money you think you make, you can hire an attorney? You don't, apparently?
I could probably hire an attorney, yes.
Well, let me ask you a few questions. Are you married or single?
I am single.
Do you support any minor children or legal dependents?
Yes, I have 2.
Okay, that's
How
different.
old are they?
7 and 8.
Do you pay any kind of child support on them, or how do you support?
Yes, ma'am.
As you said you were single, I concluded that you weren't with a spouse, or you don't have anyone helping you with the household income, you're sole supporter?
Correct.
All right, what do you pay per month for rent or mortgage?
Rent is $850.
That's cheap. We charge more for our Airbnb.
And what do you pay for combined utilities per month?
It's right around 300.
What kind of automobile do you own?
Just a 2012 Acura.
Do you make payments on that?
Yes, ma'am.
How much per month?
You might qualify.
That's 320.
We're doing the math.
And do you know what the value of that car is?
No, not off the top of my head. No, it's like, I don't know, around 12,000.
And do you know what your balance on it is?
I just got it. So,
So
yeah, I would say right around 12,100.
Okay. But your payments are $320, and what about insurance? What do you pay per month for that?
Insurance a month is like $160.
This is not a Geico commercial. This is the process. It sounds quite
no matter
basic,
how
but
I break this down, and for a family of 3, let me check one more source.
I think he's over the.
If it's too much trouble, Judge, we can just, I'll hire an attorney.
Well, it's not that it's too much trouble.
It's too much money.
But that it is that you're still well above the poverty guidelines, and so I can't appoint an attorney at this time.
Okay.
But if you want to hire an attorney, you can do that. You also have the right to waive attorney and represent yourself. But remember that you are looking at the charges I went over with you.
Yes, ma'am.
One is an infraction and one is a traffic, but it's still a misdemeanor. They're not felonies, so. Let's see, Missy, when do you want him to reappear?
November 7th at 9 a.m.
November 7th at 9 a.m. You'll need to be back here and with your attorney if you're going to have one represent you. You might also want to look into the county attorney's diversion program. Do you know about diversion?
Yes, ma'am.
All right. Well, if you want to be considered for diversion in this case, you would have to call the Greenwood County Attorney, who is Miss Gillette there, but she has staff that would help you if you want to look into that. Do you want to take down their number? It's 620-58.
I'm going to turn that off, even though it's not a. YouTube's just been whacking my channel, just like meanies.
Qualify for diversion based on his history.
All right. So she thinks you might not qualify, probably won't qualify. That's between you and her, Mr. Elam. I'll let you guys look at that. But that's an option for a lot of folks. And on that tinted glass, the statute has a provision that if you get that off of there and show the county attorney proof you've gotten it off, that charge can be dismissed with or without the diversion.
Yes, ma'am.
All right. Thank you. If there's nothing further,
can I just pay the fee and keep the tint?
You're on bond. I'll continue any bond you're already on.
Okay.
Let me make sure you're on bond before I say that.
Chelsea's been patient. Jair's been patient.
Should be, yes.
Josiah has a barn raising he needs to get to.
Yeah. Okay, I'll continue that bond. That looks like it is a $2,500 bond.
Yes.
Shows you posted it twice. Big Mike's bail bonds.
Yes, ma'am.
And Mike's bail bonds. So
6 videos
that's
I had
strange.
to fix.
I don't know what that's all about.
Today.
But anyway, you'll be continued on bond. And I have your attorney back here with you so we can get this resolved.
Yes, ma'am.
All right. Thank you, sir. We'll be in recess. You may go.
Which reminds me, I still have another to fix.
Mr. Paul has joined us. Mr. Paul, I think there's a gentleman at the jail waiting to see you, if I'm not mistaken.
At the court. Judge, he's at the Greenwood County Courthouse.
All right. Do you want a breakout room with him, or are you ready to proceed?
I'm ready to proceed, Your Honor.
You're going to have to remind me what his name is. So is that Mr.
Stephen
DeVore?
DeVore, Judge. That's 25 CR 165.
We are on the record in 25 CR 165, State versus Stephen Corrigan DeVore. County Attorney Jill Gillette present for the state, the defendant present, and with his attorney, Richard Paul. Mr. Paul, we've got a list of charges, 7 in fact. Does he want those read to him individually?
No, Your Honor. He would acknowledge copy and receipt of the complaint. Judge, I think at this point it'd just be appropriate to set it on a preliminary hearing control docket.
All right. So we'll just request enter a not guilty plea, waiver reading of rights and charges, and Missy, when do you want him to come back?
November 7th at 1:30.
November 7th at 1:30 will be your next appearance, Mr. DeVore. You are ordered to reappear for that. And you can appear by Zoom or in person at the courthouse again if you wish, sir. But make sure you stay in touch with your attorney or be available where he can call you if he needs to.
I'm just jealous of Josiah's beard.
All right. Anything else from either party that we need to address?
No, Your Honor. Thank you so much for squeezing me in, and may I be excused.
You are excused if that's the only one you have today.
That's the only one I have on this docket, Your Honor.
Okay, you had one.
I'm sure I'll be appointed to some.
All right. Thank you, sir. You may go. You are excused.
Stephen, I'll be in touch. Bye-bye.
And again, Mr. DeVore, you're excused. You may leave as well. Thank you.
All right. Thank you, ma'am.
All right. We'll now be on the record in Humphrey, 2025 CR 155, State of Kansas versus Brooklyn Rose Humphrey.
Hey,
County
Brooklyn.
Attorney Jill Gillette for the state. And where is Brooklyn Rose Humphrey? You're here in
up
person,
here by
is that
me,
correct?
Judge.
Yes, ma'am.
All right, Miss Humphrey, this is your first appearance, and you have a list of charges. Count 1.
I do.
It accuses you of, on August 22nd, 25, in Greenwood County, unlawfully and knowingly possessing a hallucinogenic drug, to wit THC and or marijuana. This is a Class B misdemeanor. If you were to be convicted, your sentence could be up to 6 months in the county jail. Your fine could be up to $1,000. Count 2, you're charged with unlawful possession of drug paraphernalia, to wit a black bag containing 3 separate bags of pre-rolled marijuana cigarettes. The B misdemeanor carries up to, again, 6 months in the county jail
Jared's
and
doing his
$1,000 fine.
hand hygiene right now.
Count 3, driving without liability insurance or providing proof of liability insurance, another B misdemeanor. Up to 6 months in the county jail possible, plus another fine. This fine has to be at least $300, but could be up to $1,000. Count 4, driving without a valid driver's license, is another B misdemeanor. The penalty could be another 6 months in jail and another $1,000 fine. Count 5 is a registration offense.
Now they threw the
Driving
book
a
at
motor
her.
vehicle without a current registration, an unclassified misdemeanor. The penalty could be anywhere from 30 days to 6 months in the county jail. The fine could be up to $2,500. In count 6, another registration offense. Operating a vehicle with a license plate assigned that was not issued to that vehicle. An unclassified misdemeanor, another possible fine up to $2,500, another jail sentence 30 days to 6 months possible. Count 7, an excessive window tint or sunscreen, an unclassified misdemeanor. Now for that, You may have heard me tell someone, if you get that removed, it is possible that you can get proof of that to the county attorney. You could get that charge dismissed.
Okay.
Otherwise, you are looking at
the rest of your life in prison.
A misdemeanor, which could carry 30 days possible sentence and fine up to $500.
We'd hit 67,000 if we get 11 more people subscribed to the channel.
The statute actually says within 60 days of this ticket, but the county attorney usually, if you bring it to them within any reasonable time after first appearance, they would consider dismissing that.
Okay.
Then in count, let's see, that's count 7. Looks like that's all of your counts. Do you intend to hire an attorney, apply for court appointed, or waive attorney and represent yourself?
I would like to apply for attorney, Your Honor.
Are you employed, Miss Humphrey?
No.
How long have you been unemployed?
Since June.
And what kind of work did you do up until then?
I worked at Wesley Hospital in Wichita.
What kind of work?
I was a patient care technician.
And what did that pay per month?
Per month, I would say around $3,000.
But you haven't had any income since June?
No, I moved to Missouri, so I no longer live there.
Who supports you in Missouri?
My boyfriend.
Do you live with your boyfriend?
Yes, we live together.
And he supports you?
Yes.
How much money does he make per month?
I wouldn't know off the top of my head.
What kind of work does he do?
He works at a wine barrel factory.
Okay, do you have any children?
Yes, we have one child.
You have the child with him?
Yes, we share a child.
All right. Well, with you being in that kind of a relationship and him paying the bills, I'll need to know more about his income to determine if you qualify for court-appointed attorney. So, Missy, how can we get an application to her in Missouri?
I can email it to her, but she'll have to scan it and send it back or send it in the mail.
Okay. In other words, you can't take a picture of it and send the picture because it won't produce right.
Okay.
So you'll either need to get that back to me as soon as possible or bring a hired attorney or waive your right to attorney at the next hearing. And when will the next hearing be, Missy?
November 18th at 3:30.
November 18th at 3:30. You can reappear by Zoom, but you must be back here at that date and time. And if you're not going to represent yourself, you better have that application back to me shortly after you get it, within just a few days.
Okay.
Okay. Now, I am not seeing that you posted a bond. You didn't get your picture and prints taken or have a bond posted, apparently.
I never went to the county jail.
All right. Well, you're going to need to at some point to get your picture and prints taken. They're not going to keep you. I'm going to order that you make arrangements to do that by calling the Greenwood County Jail, because Kansas law requires me, if you have an A or B misdemeanor, you have to get your picture and prints taken. So please call our sheriff to set up a time to do that. Are you ready to write down his number?
Yes.
It is 123.
That's
686753099. Just kidding. Yeah, A or B misdemeanor, they have
bond at 5,000 OR. You won't have to take the money, but that's what you'll owe the state of Kansas if your bond is forfeited for failure to appear.
Okay.
In fact, I'm going to make that. I said OR. I'm tempted with you being out of state to make it cash or surety, but since you start up today, Ms. Gillette, unless you want to be heard further on that?
No, that's fine, Your Honor. You said November 7th is their court date?
No, Missy, you said it's November 18th, didn't you? Or is it November 8th? Missy, would you say that again, please?
Yes, November 18th at 3:30.
Okay. That's when you'll need to be back, Miss Humphrey. Does that help you out on your record taking, Miss Gillette?
It does, Your Honor.
All right, Missy, if you let the jail know that her bond is 5,000 OR, and I'm going to expect you to get that done within the next, well, call them today to set it up, but you better have it done when I call your case November 18th. You better have had that done.
Okay. Yes, ma'am.
Thank you. You may go at this time.
Thank you.
Who's up? Josiah? Jer? Chelsea?
We'll now be on the record in GW 2025 CR 156, State of Kansas versus Josiah Christopher. I think I've had this told to me. Is it Kaczynski, or how do you pronounce that last name?
Yes, ma'am, it's Kaczynski.
All right, Mr. Kaczynski appearing in person and pro se, and County Attorney Jill Gillette for the state. Mr. Kaczynski, in count one, you're charged with possession of marijuana, a Class B misdemeanor. If convicted, your penalty could be up to 6 months in the county jail. Your fine could be up $1,000. Count two, possession of drug paraphernalia, another B misdemeanor, same possible penalties, another 6 months, another $1,000 fine. And then in count three, speeding, that's a traffic infraction. It does not carry jail time, but a scheduled fine if you were to be convicted, which for 75 and a 60 would be a fine of $75 and court costs of $108. Do you intend to hire an attorney, apply for court appointed? You can look into the state's diversion program if you want.
I was told by my bail bondsman to look into the diversion because it's my first time ever getting in trouble with anything, and that it would probably work out, is what I was told.
Well, I don't know if your bail bondsman is an attorney or entitled to be given legal advice, but that is an option, is the diversion. So you can do that with or without an attorney. You would need to contact Ms. Gillette's office, the Greenwood County Attorney, and tell them you want to talk about diversion.
Yes, ma'am.
But
how fast was it going?
aside from that, at this point, you intend to hire an attorney, apply for court appointed, and waive attorney and represent yourself. And you can waive, and then after if you're denied diversion and then you want an attorney, you can always apply at that time. It's up to you, whatever you want to do, sir.
Okay, yes, ma'am. I will represent myself.
What?
All right. Well, I won't make you sign any paperwork to that effect, but I'll make a note that you intend to represent yourself and apply for diversion. Is that what you want me to do?
Yes, ma'am. And am I able to get an email for that as well? Because I'm currently working in New Jersey. I don't live in Oklahoma right now. And I'll be out here for 3 to 6 weeks and be going back to Bartlesville to start working for Lincoln Electric down there after this.
All right, but you understand I'm in Kansas.
Yes, ma'am.
This case is in Kansas. All right, if you want to, I can give you the number for the Greenwood County Attorney. Do you have a pencil?
What was his charges again?
1 second. I'm sorry.
Everyone always bring something to write with when you come to court. There's always something to write down.
I'm ready.
Jerry's like, crap, I need a pen.
See, you're going to apply for diversion, so you want the Greenwood County Attorney's number. And that's
1-2-3-867-5309.
71.
620-583-8171.
He was speeding. He had some weed,
that's right. If you want to apply for diversion, and I understand that's what you're wanting to do, sir.
Yes, ma'am.
Okay, and then if that doesn't work out, then you'll contact the clerk of the Greenwood County Court to find out about applying for an attorney, or you'll need to hire one, whichever.
Yes, ma'am.
Or I'll take up your waiver if you want me to at that hearing.
What is a waiver? I'm sorry.
That's where you represent yourself. You waive your right to counsel and represent yourself. Okay. I thought you were thinking about that. Maybe I confused you with someone else. I've had several on here already.
No, I was. Yes, ma'am. I'm sorry.
Okay. All right. All right. But if you decide you want to apply for court appointed, contact the clerk and she'll get you the application. And then you'll have to sign it and fill it out, sign it, and get it back to us.
Yes, ma'am. And so I call that. Yes, ma'am. I'll call the number for the diversion.
Yeah, start with that, and you're on bond. I will continue your bond with the added condition that you reappear if you're not diverted by what date, Missy?
November 18th at 3:30.
November 18th.
Who do you think can go first, Chelsea?
And it will have different Zoom codes, so
or Jer?
We don't have your email, or you don't get the codes within a day or two of the court hearing. You call and get them.
Yes, ma'am.
If you don't show up, that's the same as failing to appear in person for a hearing, and a warrant will issue for your arrest.
Yes, ma'am. And that's November 18th at 3:30, right?
It is, yes.
Like, remind me again, what state are you in?
But if you have diversion finished by then, you have to apply, they approve it, they send you a contract, you sign it, you send the contract back with any fees. They may tell you you don't even have to come back November 18th.
That would be nice.
But unless the county attorney tells you that, then you better be here to protect yourself.
Yes, ma'am.
All right, Mr. Kaczynski, you're excused at this time from these proceedings, but you're ordered under your bond and added condition to reappear at that date and time, so you may go, sir.
All right, thank you, ma'am.
You're welcome.
Chelsea's like, can I go next?
Chelsea Kelly will be next on the record in GW 2025 CR 161.
She was about to hit that
State of Kansas versus Chelsea Renee Kelly. County Attorney Jill Gillette appearing for the state. Defendant Chelsea Kelly appearing in person and pro se. Can you hear me?
Your Honor.
Okay. Okay. All right, Ms. Kelly, in count one, you're charged with battery against a law enforcement officer.
Ooh.
The state is alleging in that count that on or about August 22nd, 25 in Greenwood County, you did unlawfully and knowingly cause physical contact with another person done in a rude, insulting, or angry manner to a uniformed or properly identified state, county, or city law enforcement officer, Deputy Fisher, while Deputy Fisher was engaged in the performance of an official duty. This is charged as a Class A person misdemeanor. If convicted, your fine could be up to $2,500 and you could serve up to 1 year in the county jail. Count two, you're accused of operating a motor vehicle on August 22nd, 2025 in Greenwood County. Driving a motor vehicle with window tint, which exceeds the state allowed maximum. This is
Kansas
an
and their window
unclassified
tint.
misdemeanor.
Your Honor, on that charge, it was my mother's car. It wasn't mine.
Okay, they go after whoever's operating it. So your mother could be charged for letting you do it, but you also, as the driver, are responsible. And as an unclassified misdemeanor, you could have a fine up to $500 and up to 30 days jail sentence. Then you have an infraction in count three, driving on the wrong side of the road when required. This is an infraction. I think that's a $75 fine. There is no jail time allowed with that. Count four, driving on a laned roadway, also an infraction. No.
I can't help but notice you're in a car, Chelsea. I'm
No
not sure if
jail
that's the
time,
best
a
move.
$75 fine. That maintains that you failed to maintain a single lane by crossing the dotted white line 2 times and crossing the double solid yellow line.
Cop's pulling up behind her right now.
In count three, the language is that you failed to drive on the right-hand lane when you were not overtaking or passing another vehicle. That's often locally and commonly unofficially called lingering in the left lane, although that's not the legal definition. I just gave you the legal. Yep. Count five, you're charged speeding 80 in a 65 mile per hour zone. Traffic infraction, no jail time. The scheduled fine for 80 and a 65
She must have been a handful on the
is a
side of the road.
$75
So you hit her
fine
with
and
everything.
108 court costs. You intend to hire an attorney, apply for court appointed, or waive attorney and represent yourself, Ms. Kelly?
Apply for attorney.
All right, where do you work?
I started a new job as a CNA at Health Hutchinson Health and Rehab.
When did you start that?
I started, I do believe, on the 5th of September.
What do you get paid per month?
$22,500.
All right, and do you have any children that you legally support?
No.
Married?
No.
Live-in roommate with someone?
Roommate.
Okay, and does that roommate help with the bills?
They do.
All right. So what do you pay for rent each month? Your portion?
$600.
Yeah, that takes it down to $2,200.
And utilities?
That's included with the $600, ma'am.
All right. Do you have any monthly bills that you're obligated to pay? Bank payments, things of that sort, car payments?
Just my phone bill and my car insurance.
All right. What's your phone bill?
$175.
I thought she was $2,200 a month. She's now just over $2,000 if it was $2,200 a month, or $2,800 a month.
And then you said you had another payment, your insurance, I believe?
Yes, $90.
Cheap insurance.
Okay, any other monthly bills that you have?
Not that I can think of at the moment, Your Honor.
Okay, and there's no one besides you that you're responsible for?
No.
Well, even with one person in the household, well, you're not qualifying for court appointed. So you'll either need to hire an attorney or waive your right to attorney and represent yourself hereafter.
I'll hire one.
Okay. To hire an attorney and does not qualify, if you need to make that in the docket notes. All right. And Missy, when is her next court date?
November 18th at 3:30.
You will need to be back here November 18th at 3:30. And if you're going to have an attorney, you need to have the attorney here at that time. Anything else, Ms. Kelly?
You said that I would be held responsible for the tint on my car, on my mother's car, either way.
The driver, if you drive a car that's in violation of the law, you are responsible for that consequence. Now, maybe she'll help you with it. If you can get proof that she's removed the window tint that's excessive and get proof of that to Ms. Gillette, that may be dismissed.
Okay.
But she has to be willing to have it removed, and then you need to get proof to the county attorney. You can either have it removed and have an officer send her an affidavit or statement that it's been removed. You can take it to a window tint shop and remove it, or any other way that Ms. Gillette would approve. And you can call the county attorney if you remove it at
620-867-5309. Speaking of eight more people will be at 67,000 subscribers.
And I don't know if, Ms. Kelly, you would qualify for the county attorney's diversion program, but if you want to find out about that, where if you do certain things, you might be able to get the charges dismissed, you need to call the county attorney at that same number.
That's very different than the Kentucky sheriff and judges diversion program, where you do certain things, and that's a different program, and I don't recommend that one.
All right, sounds good. Thank you, Your Honor.
You're welcome, and let me check your bond situation. You haven't posted bond, and because you have an A or B misdemeanor, I have to order that you contact the Greenwood County Sheriff to get your picture and prints taken. So you'll need to call the sheriff at
620-867-5309. They're all at the same number.
And I'm going to set a bond since you haven't made one.
You can get a script for a window tint?
I'm going to make that it.
Front windows as well?
I'll set yours at 5,000 OR. You won't put up any money, but if you don't get your picture and prints taken like I ordered you to do, or if you don't come back to court when I tell you to, you may end up getting your bond forfeited and have to serve your time in jail and owe $5,000 to the state of Kansas.
Yes, ma'am.
All right, Miss, if you'd let them know that's a 5,000 OR. Thank you. Anything further, Miss Gillette, from the state?
No, Your Honor. Thank you.
All right, Miss Kelly, if you have nothing further, you may go with this. All right, you're released from this hearing at this time.
Thank you.
You're welcome.
Hey, Kayla, are you there?
I am here.
Hey.
Can you hear me?
Yeah, you're live on the air. We just muted Judge Webster for a minute.
Sorry, I'll make it quick.
You can get a prescription for a window tint?
You can. So my son's on the spectrum, so this might be why. So they said because as long as I had it documented that he needed that for sensory issues and to block any, he has self-injurious behaviors, or he did. We're coming out of that phase of life now, thankfully, it'll help keep him safe from all the stuff and people from looking in. And so it kept us from getting tickets with 5% tint, which is in Indiana, it's limo tint. I don't know if that's everywhere, but
that's 5% of the light is kept out, or only 5% comes in.
Comes in.
Oh my goodness, it's blacked out.
I
You're rolling
love
fully
it.
blacked. It's
I
like,
love it.
Can you see out?
I can.
And is it on the front as well? Can't be on the front.
Yeah, so I have a bar, up on top.
Oh,
yeah.
wow.
Yeah,
That's
it's great.
crazy. Now I have to.
Yeah, so I had it for my Toyota, and then I have it for my Equinox as well. So
That is crazy. That's absolutely crazy. I didn't know that was possible. Well, thank you for the update. Now I have to look and see if I've got some qualifying conditions that might grant me insurance paid window tint on my vehicle. So that'd
there
be cool.
you go.
Then I can drive through Kansas, and it's like I can flip them. They wouldn't know if I give them the bird.
They wouldn't. They
see me.
wouldn't. They would never know.
Yeah, I don't give them the bird.
So.
I'm not that driver. I don't.
Oh, I know.
Yeah.
I know.
I'm in the
You're
slow
fine.
lane. I'm nodding, smiling to everybody, handing out stickers. Yeah. All right. Kayla, thank you for that. Good talking to you. We'll see you.
You too. Bye.
Bye. Wow, that is just crazy. We're going to go back and listen to the judge again. So,
County Attorney Jill Gillette for the state.
Where are we at?
All right, Mr. Phillips, you're here on one count,
Of
several
what?
counts, but count one is alleging that on or about the 19th day of August, 2025 in Greenwood County, Kansas, you, Jason W. Phillips, then and there, contrary to the statutes of the state of Kansas, did unlawfully and knowingly possess a controlled substance, to it methamphetamine and or MDMA.
AWOL. Sorry, we've got somebody getting some charged with possession of meth really quickly. What's up, my friend, my brother?
Hey, what's up?
From another mother.
What's up? I just wanted to double down as well with the tint laws. My friend has been doing it for 28 years.
Mm-hmm.
You can get it covered if you have skin cancer or certain issues. You can get a card
What if you have
that
a
your doctor
sunburn?
would give you.
Is that?
I don't know if that would. I mean,
I'm thinking things that I have, or that I could readily get.
I don't know if you're gonna. I don't know if your doctor's gonna give you that pass, but you could try. But you can have medical issues that they can sign it off and they would pay for your vehicle. My friend does vehicles that the insurance companies pay him to do it. The customer does not. And it's covered by their insurance, and they get a card and they get to present it to the officer for the reason why there is new technology called carbon tint where it blocks UV rays. Now, of course, like the previous caller said, 5% is limo. With carbon 5%.
Are UV rays the light that comes off a police headlight? Is that what
no,
kind of light
definitely
is that?
not.
They're flashlights. Is that
it's only
UV?
for the sun.
Just kidding.
I mean, it doesn't work that. I mean, but there are tints now with the new technology that even though it is harder to see inside the vehicle, technology has changed that before 5% limo tint, you barely could see out. But now you can have a 5% for the person looking in, but the person looking out is almost at a 20%.
It's like one-way glass.
Yes.
I can see why the police don't like
the technology got better with it.
Wow.
Yes, the technology definitely got better with it. And if anybody in chat suffers from any skin issues or whatever, I suggest talking to your doctor, and it might be covered. Of course, if you get into an accident and you have dark tint, and you can tint the windshield, there's a technology for that as well, for the front windshield. But if you get into an accident and you argue, oh, I couldn't see him, that's a problem.
Yeah.
So you pick your level to whatever you can argue in a court of law, but while you're safe and pedestrians are safe, but it is allowed to do, you are allowed to do it now medically, where before it wasn't that type of thing. So now you can do it. So if anybody suffers from that type of condition or they're sensitive to the sun, whatever, I would suggest looking into it, and you could legally do it.
What about?
And it may be covered.
What about just putting like a polarizing film on it so that most people can't see, but if you have like the polarized glasses that are aligned the right way, you can see right in. So the cops get the glasses and everyone else, you know, No?
Now you're onto something here. I will call you off air and
let's patent that real quick. Okay.
You already said it on air. So no. All
It's
right,
just
I'll let
us
you
and a
go.
few friends. Nobody
to...
knows. No one's going to hear. No one knows. Hey, well, thanks. Appreciate that. Good talking to you, my friend.
All right.
We'll see you.
I love everybody. Bye.
Bye. All right. Back to Judge. We're almost done here. Oh, she's continuing.
At 1:30, and the added condition that you contact your attorney prior to that date. And then any one. Now, do you intend to hire an attorney, apply for court appointed, or waive counsel and represent yourself, sir?
I would like a counted appointed, please.
All right. Where do you work, sir?
I work at the Independent State Mill. I make wine barrels.
Okay, I've heard that somewhere here, haven't I? All right. What do they pay you for making wine barrels each month?
This is the boyfriend. Stop. Let me back
it
up.
Depends because
we're going to back up a little bit.
Cito, County Attorney Jill.
Hang on. Here we go.
Be back here by Zoom, November 7th at 1:30.
This is the boyfriend. This is the boyfriend that makes the wine barrels.
I will continue the bond.
She had what, possession of
on
weed and everything?
With the added
she
condition.
Lives in Missouri now or something?
That you reappear November 7th at 1:30, and the added condition that you contact your attorney prior to that date. And then any other conditions existing on that $7,500 cash.
Whiskey barrels would be a better business there instead of wine.
Any questions, Mr. Phillips?
No. 605838155.
What are you doing?
Yes. Okay. All right. Thank you, sir. You may go from today's hearing.
You as well.
Now we'll be on the record in Salcedo. On the record in GW 2025 CR 152, State of Kansas versus Hare Salcedo. County Attorney Jill Gillette for the state. Are you Mr. Salcedo?
Yes, ma'am.
How do you pronounce it? Is it Salcedo?
Salcedo.
Salcedo. Okay, sir. You are here for first appearance, and on count one, you're charged with having on or about the 22nd day of August 2025 in Greenwood County, Kansas, unlawfully and knowingly possessing a hallucinogenic drug, to wit, THC and or marijuana, a Class B non-person misdemeanor. Penalty could be up to 6 months in jail. Fine could be up to $1,000. Count two, unlawful possession of drug paraphernalia in the form of a black bag containing 3 separate bags of pre-rolled marijuana cigarettes.
This is
him. This would also be a B misdemeanor, so another 6 months in jail and another $1,000 fine available. You may or may not qualify for the county attorney's diversion program. If you want to look into that, you can call at 620-583-8171. You intend to hire an attorney, apply for court appointed, or waive counsel and represent yourself, sir?
I would like a counted appointed, please.
All right. Where do you work, sir?
I work at the Independent State Mill. I make wine barrels.
Okay, I've heard that somewhere here, haven't I? All right. What do they pay you for making wine barrels each month?
I would say about, I mean, it depends because depends on how many barrels, like our checks depend on how many barrels we get out. So if
on average?
So just a month, I would just say like probably like 2,500.
Okay, and are you married or single?
I'm single, ma'am.
Do you have any children that you support?
Yes, ma'am.
How many?
One.
Just one.
And a girlfriend.
All right, and what do you pay for rent or mortgage if you do each month?
I pay $1,280.
$1,280?
Yes, ma'am.
He says he's single. The girlfriend says, I live with my boyfriend.
Rent, in addition to rent or mortgage, do you pay utilities?
Like my trash and my electricity and stuff, yeah.
How much does that come to each month?
My trash is $22. My electricity.
$22, okay.
Yes, ma'am. And then my electricity is usually like $90 to $70.
Okay. Any other utilities, electricity?
90 to 70 for electricity?
The rest of that's in the, because I live in a townhome.
Okay. And do you have any other bills you pay, car payments, for instance?
No, ma'am.
Credit cards, bank payments, anything like that?
No, ma'am.
All right, you and yourself would be a family of 2, and
Actually, it would be.
that would qualify you for a court-appointed attorney under the guidelines in the chart. So I will appoint Attorney Richard Paw, since these are all misdemeanors.
So he qualifies, but she didn't.
P-A-U-G-H, Paw.
How much does he
his
make?
number is 3.
And we're just giving out attorneys' public business numbers.
1 0. And Missy's going to give you your court date. Missy?
November 18th at 3:30.
November 18th, 3:30.
You must be back here. You can appear by Zoom again, but you must be back here with your attorney, Mr. Paul, ready to proceed on these charges.
Okay. The first number you gave me is 620.
They're giving out numbers.
7-1, but before you call that, call Mr. Paul.
Okay.
That's the county attorney's number for diversion. Call him first. He'll want you to do that.
Mm-hmm.
And then doesn't look like you've had your picture and prints taken. It doesn't look like you were arrested.
No, ma'am.
So I'm going to have to order that you appear in Greenwood County and do that. Contact the sheriff to set that up at 620.
Why do we just... Yeah, okay.
And I'm going to give you a $2,000 OR bond. You won't have to put that money up unless you fail to come to court, fail to contact your attorney, or comply with any other the bond conditions I'm ordering. Absolutely do not use any illegal substances, and don't go about people in places where it's available.
I think he's at work right now.
All right. Anything else, Ms. Gillette, we need to address on this? I think we've got it all.
No.
All right. Thank you. Mr. Salcido, anything else that you want to ask me before I let you go?
So Richard's number is 316.
Good grief. Please stop giving out phone numbers.
And my court is November 8th, 3:30.
Correct.
Same as your girlfriend.
And then the sheriff I need to get a hold of is 620.
Very good. All right, then I will let you go at this time. If you tell me how you pronounce your first name.
Yaid.
H-A-I-R is pronounced Yaid.
It's J-A-I-R, and it's Yaid.
I'm not laughing at his name, but she butchered it the first time.
So the Y takes, the J takes a Y sound, and the R takes a D sound?
Yeah, kind of.
Well, but I don't remember that. Okay. What nationality is that? That's not Spanish.
I'm Mexican.
It is Mexican.
Yeah.
Well, that R is really throwing me. It's J-A-I-R in English, right?
Yes, ma'am.
But you pronounce it Yaid. Okay, well, I hope I'll remember that next time. Please forgive me if I don't. Forgive me in advance. All right, thank you, sir. You may go.
Appreciate it. Thank you. Have a good rest of your day.
You too. All right, we took care of Heather Hutt yesterday, so that brings us back to the extradition.
Do a quick extradition
and
one.
That is
I'll go up here, Judge. I'll sit in your box for this one.
Swade Allen Scott, correct?
Yes, ma'am.
All right. Deputy, do you have the fill in the blank waiver of extradition form?
They just fill in the blank like a Mad
Libs? Is that in front of him?
I don't think
No,
I have.
you have it, Judge.
Well, I didn't know she had one too. All right.
No.
Oh, we need to get this to him then. Missy, can you come get that and meet her halfway there? Maybe.
Yes, I can meet her at the back door.
Thank you.
We'll wait.
You by chance have another one of those that I can look from? Or if I can find it on my computer, I might be able to look at it.
Let me just make you a copy.
All right, thank you.
Also by the back door.
I emailed it to y'all earlier.
All right, thank you. Ms. Gillette, we were talking earlier. Did you used to fill these out? I had gotten in the habit of typing in the blanks, and then Missy pointed out we can write in the blanks. But was there a time when your office used to prepare those extradition orders?
If there was, it was a long, long time ago. Or because when it was passed to me from Mr. Lee, they hadn't done them in a long time.
Okay, well, that's what Missy was saying. They used to just, the judges used to fill in the blank by hand, and then it's like, well,
When it's a different county attorney's office, we had to appear for every extradition and fill out the paperwork. And as a defense attorney, I've done it many, 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 many times. And when I was a certified paralegal, I did them frequently for the defense. So,
well,
yeah,
years ago as a prosecutor, I just showed up and they were magically there, so I never questioned where they came from. But today it was an issue for me. All right, so we are going to go on the record now in the matter of the extradition of Swade Allen Scott. I do not have a case number. County Attorney Jill Gillette present for the state. The gentleman in custody at the Greenwood County Jail, is your name Swade Allen Scott?
Yes, ma'am.
And I have in front of me, sir, from the state of Texas, county of Midland, what appears to be a warrant for your arrest upon a bond forfeiture, upon pending indictment with the offense of soliciting prostitution or other payor, a felony. And from what I can tell, the case number must be DCR-24-00125, as I'm interpreting this Texas warrant. And so you are you believe you are that individual, and that those are the charges pending against you in Texas, is that right?
Yes, ma'am.
And so for this reason, rather than fighting extradition, you wish to sign away your rights and just go back voluntarily to Texas. Am I understanding that correctly?
He's waving.
Yes, ma'am.
All right. So do you have in front of you a document called a Waiver of Extradition?
Yep.
And it reads, I, Swade Allen Scott, have this day appeared before the Honorable Phyllis K. Webster, Magistrate Court Judge in Eureka, Kansas, a court of record, and have been informed by the court that a demand is made for my surrender to the state of Texas based upon criminal proceedings. They're alleging that I have failed to appear in Midland County on pending indictment with the offense of soliciting a prostitute or other payor, a felony, 238 DC Midland, Texas, DCR 24-00125. And I have been informed by the court of my rights to counsel, which I have not done, but I will tell you. Do you understand? You do have the right to counsel. You have the right to challenge extradition and to require the issuance and service of a governor's extradition warrant, and to petition for a writ of habeas corpus, meaning that you're being unlawfully held, as provided for in the Uniform Criminal Extradition Act, and you fully understand those rights. I'm going to take a moment just there and go over those with you. All right, you do have the right to an attorney, and you do have the right to challenge being held on these charges if you think you're not the person they're wanting, or those aren't the charges that you're failing to appear on. You can challenge that. You can challenge it with the aid of an attorney, and if you do that, it will put a hold on any issuance and service of a governor's warrant, but it will put the burden on the county attorney to get that issued. Do you understand all of that, sir?
Yes, ma'am.
And then the next paragraph, I knowingly and voluntarily and without promise of reward or leniency state that I am the identical person sought by the demanding state, that I waive the issuance and service of the governor's extradition warrant and any other legal documents and procedures which otherwise would be required to secure my return to the demanding state, and that I knowingly and voluntarily consent to my return to that state. Do you have any questions about any of that paragraph?
No, ma'am.
Next paragraph, I wholly exonerate and hold blameless in this matter the sheriff of Greenwood County and all persons acting under the same, and agree to accompany to the demanding state any peace officer who may be sent to take me there without requisition papers, warrant, or rendition, or other legal forms or processes having their object my return to that state. So in that paragraph, you're saying you're not holding the Greenwood County Sheriff responsible for holding you in reliance on that warrant, or upon releasing you to an officer that comes in from Texas and says they're there to take you back, without the governor's warrant. Do you have any questions about any of that?
No.
So you can't sue them when they come
All
to get
right.
you.
The next and final paragraph, this agreement and waiver is made by me without reference to my guilt or innocence and shall not be considered in any manner as prejudicing my case and is not in any sense an admission of guilt. That's just saying that because you signed this waiver, that doesn't mean you're saying you're guilty of what they're alleging, just that you're willing to go back voluntarily.
Yeah.
Okay. Any questions about that?
No.
Okay, if you agree to that, to everything I've just gone over and everything on that paper, do you need any help reading that document, or did you follow along? Do you have any questions about what it says?
I followed along. I do have some questions.
I'll try to answer
stop
those. You may
signing.
need your attorney to do that, but go ahead.
Kansas doesn't want to be sued either.
How long does it normally take for them to come pick somebody up?
Well, how long it normally takes them, it probably depends on how quickly the jail notifies them, and that's usually just really quickly. And then how quickly they get somebody in the car to start heading this way. And different jurisdictions will depend. There is a limitation on how long you can be held. But deputy, you can probably tell better than I how long you usually see somebody coming for pickup.
Like 2 weeks.
2 weeks. What is a limitation?
If you're still there in 30 days, you ask the jailer to put you back in front of me. I don't think I've ever had to have one pick up later than 30 days.
Okay.
All right. So if you want to sign that, you can do so.
He already did, Judge.
All right. Then if you'll just get that back to
He
me,
signed it
I'll
before he asked his
sign
question.
my signature on it, and she will call the folks, the officials there in Midland, Texas. And like I said, if you're still there in 30 days, we can review this for sure. All right, if there's nothing further, you may be excused at this time, sir, and remanded to the custody of the Greenwood County Sheriff.
Appreciate it.
Thank you. Missy, is there anyone else on the docket that we're going to need to call?
I don't have anybody else.
All right.
We done. She just shuts it down. Thanks, Judge Webster. Just shut her down. Unceremoniously just dumped into the abyss of the internet by Judge Phyllis K. Webster. You can put that off, check that off your bucket list. Well, we still have another half hour before they come back from their lunch break up there in Washington, so we can take a peek and see what else is happening in the world of courts. But there's this one
of the construction project and her need to retain other contractors to finish. And you've heard how much she's requesting, $6,850.
The judge got a perm.
All right. What is your response?
She used to have straight hair.
Do you disagree that you owe her this money?
Yes. The last thing I had to do was paint her island and paint the ceiling. And that's all I needed was paint, not an entire redo. That was per our phone conversation on 5/23, I think.
So are you contesting that the counter? Let's start there with that line, the seam.
Yep. So she wanted it done for Thanksgiving, I think. So it had to get done, and a longer countertop that would not have to have a seam would have took
Josh has
4
one for
weeks to ship to Menards. And I got the 12-foot and then added the piece. And for a few days, maybe a week, it was all fine until she changed her mind on it.
Well, you see it. It looks sucky. It's crappy. It's not done very well at all.
A lot of countertops have
They're very
seams.
legal words, ucky and crappy. All right. What?
A lot of countertops have
Oh, no, they
seams in
don't.
them.
No, they don't. Not like this. If you're a contractor, I'm not a contractor. There is absolutely no way that a professional contractor who cares about their workmanship would put a seam where this seam is. Absolutely none.
That was due to the time constraints.
As a contractor, did you ask her and say, hey, do you know you'll have to have a seam right here and it's not going to look really great?
Yes, that
We had
was
that
established
conversation.
and it was fine for a few days, a week.
Where's the text? Do you have it in text?
I think that was in face conversation.
All right, so you're saying you had a conversation and you're saying she said, that's okay, I'll live with it.
It was fine for a few days, a week maybe.
Did she see it when you, with the length of the counter that you had, where the seam would need to go and cut like right in between a drawer?
That was purposely put there to access the dog clips to install it.
Okay.
But you see the picture, right?
I've seen the picture, yes.
Would you want that countertop in your house?
My countertops have seams in them and they're shorter.
Again, I'm not asking about your countertops or where your seams are. Looking at this picture where this seam is with this countertop, would you want this in your home?
Yes.
Oh, then I think you're lying. I don't find you credible at all. Because this is obnoxious. Because I'm going to guess this isn't marble. I'm going to guess this isn't granite. This looks like it is.
No, it's not granite.
Yeah.
It's Formica.
It's Formica. That's exactly. Excuse me. It's a cheaper countertop instead of granite.
Right.
However, it's made to look like granite and have the grains that go in it, and the positioning of this
I can't bail on this yet.
seam with the lines,
It's
because
the
it's
kitchen job.
white granite lookish or looking, with the really dark black veins. Where the seam is, you can tell this just doesn't line up.
It's
and
ugly.
then to have the line, the seam be right through the middle of the cupboard door and the drawer. I mean, I'm going to tell you, here's the thing. I'll give you a tip. Grew up with a very awesome man, my father, who knows how to do everything. My brother's in contracting. I've been around contractors. If you're going to do a seam like this in a countertop, you do the seam where the dishwasher ends, that split between the dishwasher and the cabinets. You don't do a seam halfway in between. If you would have put the seam after the dishwasher, I probably could have been more like, yeah, I can see that. You probably talked to her. You probably told her those things. But with the seam where it is, that's just not where a contractor would put a seam, because it looks ridiculous. It would have blended more after the dishwasher. All right, so what about the ceiling? You said you had to just repaint the ceiling?
Yes, there was a wall there. I took the wall down. I sprayed popcorn texture on it, and it needed to be painted.
Okay, popcorn's a crime.
Well, I don't really have a great photograph. Not really the best photograph, but I can see popcorn sprayed on there. I'm going to tell you, spraying popcorn, that's not that easy to do. I've done it myself. Not easy. You can do it. I'm OCD, so I worked on it and worked on it and worked on it until it was almost pretty much
practically perfect.
But it's very difficult to do, and I can't see. I see the different layers here, but then I see where it looks like there's not any. And we have a contractor, a different contractor who came in, who, if you look at his bill in Exhibit 3, the second page, $1,600, and it was to then remove and then have to paint that popcorn ceiling. And then on top of that, to fix that, she paid him to do 3 other rooms. She paid $1,500 additional dollars to do other rooms. So she paid more money
prank call coming in
to try and make it look the same instead of having him try to.
Hello? 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 Okay.
To get it to blend. I think that was a personal decision on her part to take all the popcorn out of the entire upper level of the home and do a flat ceiling.
And you agree, though, wouldn't you, that if she had Boss Construction Solutions here coming on in to redo this work or to come in to complete the work because you were not coming to complete it, that it would have been cheaper for her to say, fix that spot of popcorn
John,
and
have fun.
paint it if that was all that needed to occur, right?
Well, I think she wanted a flat ceiling after that.
This judge has some strong interior decorator feels. And I don't think the contractor's going to win this one.
Tell you that she wanted flat ceilings, or how did this popcorn ceiling come about?
She didn't tell me she wanted flat ceilings, no.
Did she ask you to redo the popcorn part of the ceiling?
No, she asked me to paint it and I was going to, and then broke my hip and was unavailable.
What about this island where she loaned you money to buy supplies to finish the island?
Uh-oh.
A little confused about that because the supplies were there and it just needed to be painted and maybe a piece of trim underneath the nosing.
Well, I'm confused about the loaning of the money too, because unless you already paid for it and you needed additional supplies.
You mean for the ceiling?
The island.
The island. He came on the 2nd of June. There had to be some things finished. And when he came, it cost me $300 more to finish it. He said he had no money. So I gave him $300 to finish the island. He never came back after that. So there was the shelves and there was baskets and the trim that have to be done and a few other things. Bill put it on here what he didn't finish. So it cost me $500 besides the $300 I gave him to finish my island.
So, but the $300 was for the other supplies?
For him to come back and finish it, and he never came back.
Not for the supplies that were needed?
No, he said he needed $300 to finish the island. And I said, okay, I will borrow you the $300. Will you come back and finish it? He said yes, and he never did.
I don't get borrowing. Why are you borrowing money?
Because he had no money. I wanted him to finish my island.
That's not borrowing, that's paying. I'm paying you for a service. Why did you say borrow?
But the whole thing is I already paid him the money for the island on the top $4,200 to do the island. But for him to buy parts and everything to finish the island, he had no money to go buy the parts or anything. So I borrowed him the $300 for parts so that he can come back and finish the island. And he never did.
So he did not bring parts back either?
No, he didn't do. I haven't seen him since the second when he told me he needed the money to buy the parts. That was the last day I seen him.
Okay, this is not going to go the contractor's way.
He told me he was going to try to have this all done before he had his surgery done.
So why did the contractor William Andrew need to install a bigger shelf in the island? Was that pre-planned?
Because that was the stuff he was supposed to do.
And install dual trash slide out in the island, that was what he was supposed to do as well?
Right.
So Mr. Andrew had all of the materials, he just needed to do the labor.
He did the labor, that's including labor and parts.
Well, it just says miscellaneous labor. There's no parts.
Well, it was $300 for him to buy the parts and to do it.
Who?
Bill.
Who's Bill?
He only charged $500 only for labor. There's no parts.
Well, it was for parts and labors. It wasn't just the labor. It was for parts and labor. I guess he didn't put that in there. I'm sorry about that. But it was parts and labor.
He would have to put that in there. Contractors have to put this part and it's this labor and this. This only says labor. So I'm having a difficult time understanding that there was a need for additional parts of $300 that Mr. Rayner needed to borrow to go buy.
He was just supposed to buy parts to finish the island, Mr. Rayner, but he never brought the parts back.
Did he tell you what parts?
Well, I wanted 2 baskets and there was only 1 in there. And then he also did something with the shelves, and then on the bottom.
Okay, do you guys want to finish this one out?
The base bolting on it, it was there, so he had to put that in there because he didn't finish that.
Do you want to finish this one out, or do you want to jump to one that Josh has found for us from about a week ago?
I'm trying to figure out $300 in parts. One other basket is not $300.
I am not understanding you.
I'm just trying to understand this loan. You loaned him $300.
I owed, because he had no money. He said, okay. So I gave him $300 and I said, this is a loan. You have to pay me this back for go buy the parts so you can finish the island. And he never did. So
I'm still not understanding how a basket is $300 because the parts, I'm not hearing that there's $300 in parts. Plus, if something happens and you're doing construction and then they say, oh, well, you're like, I want 2 baskets instead of 1. That means that's an additional charge on you, not on the contractor.
No, I gave him $300 to him to come back and finish doing my island. I don't know what parts he had to buy, but he was supposed to come back and finish it, and he did. So my friend Bill, because he only bought 1 basket, I wanted 2 baskets, and Menards was not nice enough for me to break the 1 basket in. I got a double basket, it cost me more for that. And then Bill finished for the labor, he putting the basket in and then doing some shelf and doing the trim was $500.
All right, still not understanding completely, but Mr. Rayner, she gave you $300 at some period of time for the island. She says it so you can go buy supplies to finish the island. I don't quite understand if it was that or for additional services. What was that $300 for?
I'm not aware of $300 being loaned to me for any purpose, especially parts. The parts to the island were there. The baseboard that she talked about, that was the piece of trim I had to install, paint it, and then paint the ceiling. She owed me $420 on our phone conversation, $523. We agreed that she should just take that money and put it towards the individual coming in and finishing those 3 items.
All right. Do you have any proof that you gave him $300?
Everything I gave Mr. Reiner was cash. No, I don't.
And so you didn't do a receipt? You didn't do anything?
No, I trusted him.
But either way, it costs you an additional $500 to finish the island.
That's right, ma'am.
Mr. Rayner, what is this $600 to consult with a contractor about blueprints?
Yeah, explain that one.
There's no consulting for any blueprints.
I have a quick question. Where's his quote? Okay. Where's his quote? Where's his bill? Where's Mr. Rayner's anything?
That's what he billed me, $600.
I get it. Where is his bill that he gave you to say?
He never gave me any bills or anything.
Like, this is what the total's gonna be. He just said, well, I think it's gonna be $10,100. You're like, sure, okay.
That's what he told me. He said that he took my papers, all my papers to a contractor because I told him the wall was not a permanent wall. So he said he took it to a contractor and it cost him $600 to pay the contractor.
I get what you're trying to say with that, when a contractor comes into your home and says, I'm going to renovate for you, I'm going to do some projects for you, and it's going to cost over $10,000, even if it's going to cost $500, you see what happens here. You see that you get a bill from boss and you get a bill from Mr. Andrew. Where's the bill from him?
He didn't give me a bill. He told me that's what he paid a contractor, so I paid him $600.
You're not listening. I don't care about the $600. The total bill, the $10,000 bill, where is that?
I gave him all cash. He told me it would cost me an extra $1,000 for him to change.
Do you see a receipt? This is from Mr. Andrew. Do you see this?
Yeah.
Where's the one from Mr. Rayner?
He never gave me any bills of any kind.
Why? Why didn't you require one?
He gave me nothing. He never gave me one bill for anything, ma'am. Everything was done from his word to my word. And I paid him cash with everything.
And you didn't ask for a quote, a written estimate of what it's going to cost?
No.
You just believed him.
On my emails, he tells me what it was going to cost for each one of these projects that he did.
Where's the email?
Okay, show me.
On the first part of the emails.
They're text messages.
Right.
Where?
Right, Jesus.
In the first part of October. I was looking at them. But that's what he told me it would cost me to do.
He says in a text message, I don't know what page because none of them are marked, but it says, it goes, as far as the wall demo, I'm going to have to look into that some more before giving a quote. So where's the quote?
On this page, the second page, at the top, he was saying it would cost $40,000. It's on the second page. And it's this one here and this one here. And then to do the sink, it was going to be $300 and so far. That's what the cost, that's how he was doing it to me. There was no paperwork, it was.
Roro, thank you. We are one person away from hitting 67,000 subscribers. One person.
I hope you've learned a lesson that with the other contractors that you've worked with, you get quotes, you get receipts, you get paper.
We hit it.
Not a text message.
Thank you. Thank you very much.
And it gives you an idea of it's going to be this much in parts, this much in labor. This is exactly what we're going to do, instead of the text message number 2 that says setting the countertops with all the custom cabinet work is $4,200, or the tile backsplash with the wall tile is $2,000. It should say $800 for the tile backsplash and then $1,200 for labor. It's not very detailed and it's not written. Not a good way to do business.
Okay, I want this to resolve. I've got something funny to watch, and we've got 15 minutes before the court comes back.
Is there a text message that says the $600?
No, it was just word from him to me.
And I have a question for you. If you don't have a quote or an estimate or anything of that nature, how do you remember $800 for repainting, $300 for the sink, $600 for a contractor?
I wrote it down on a piece of paper.
Where's that
for myself?
paper?
Oh, at home, I didn't bring it. That's why I brought this. I wrote it on a piece of paper at home.
When did you write it on that paper?
Okay, we are going to bail.
I don't know when I remember how to do things, you know, what he did and what it cost. I know that he redid my painting,
Here's what needs to happen. The judge needs to yell at both of them, not just one of them. Sounds like both of them, the lady should have done a little bit of more careful due diligence. Can we say that? Due diligence on her side. And if that guy was running that whole show as a scam, he needs more than a yell. Let's see. Let me jump to Josh's real quick. Okay, let's see if we can get this one. This one is from 8 days ago. The other Jules, thank you. We hit 67,000. It's awesome. Let's see. 1 hour, 12 minutes, 48 seconds. I can't tell which one it is. I think it's this one. 1 hour, 12 minutes, 48 seconds. Okay. Let's see if this is it.
Good morning. This is Mr. Hoffpower sentencing. I didn't see you over there, Mr. Hoffpower. Good morning. Good morning. Are you Crystal Vogan? And Ms. Vogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes.
And any additions or corrections or?
There's a lot of history, we understand, but discussed it with counsel also about restitution.
Speak up, I'm sorry.
I just want to make sure the court knows restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2,
DSN,
3,
thank you very much.
and 1/4 pages of criminal history.
Whoa.
Well, there's a lot of stuff that wasn't dismissed.
This lady, she's got a few pages of history on her. Almost a complete chapter has been written. Purple Coconut, maybe celebrate 100K soon. Congrats, RA, mods, and friends. Thank you.
There were 14 felonies that weren't dismissed.
Did she say 14?
At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but there's I mean, she's on probation right now in Sutton County, correct?
Yes.
I have been for 2 years.
Right. So do they know about this case? And what has happened over there, if anything?
I'm still continuing on my deferred.
Is she a nurse?
I can't understand you.
I'm supposed to start nursing school.
Oh, she's starting nursing school.
When?
She's wearing her scrubs.
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes, I
school
am.
with this type of
Yes,
criminal
my
history?
previous deferred, yes, ma'am. Because I haven't been convicted of it. I'm a CNA now.
You're a CNA now? Sloth Life, thank you very much. 5 gifted memberships.
Where do you live now?
We're on break, Cindy. We're going to be going back up there in just a minute. 4 pages of history. 14 felonies. She's a CNA. She's on probation. out of another county.
Okay. Another issue that I see on here also is the restitution, because it shows 9,400, but then it also, that was from inside the bank, and then it shows 500 from an ATM and 100 from a cash app, totaling 10,000, not 9,400. Is that correct?
10,000.
Added on, that's a bank fee, I believe.
Well, it says 500 was
rob the
withdrawn
bank?
from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the closet.
Okay. So possibly the other person that was involved did that?
Only thing we knew about
That
was
was no-
9,400 that was within the bank.
I wasn't aware of, Your Honor, when we did it, when I got the PSIs, when I was in the cash app. But if it was a withdrawal, then that would be her responsibility joint and separately. So
Joint and separate.
Right, it says, so
that's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of 10,000, 94 from inside the bank, 500 from an ATM, and 100 from a cash app transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of the?
I don't have the other status of another person, Your Honor. This is one that was, that's the charge. I'm not posting on there. But she's responsible.
Yeah. So I mean, if there was another person, and you didn't give that information, then that's, okay. Apparently the cops didn't either, so.
She went in the bank, she was the one called. Size, whether or not she had a conference on the backside, is not to my knowledge.
And hold on. So the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County?
Make it make sense, Judge.
Okay, and so it's the state's position to go forward with the agreement?
I understand the court's concern, and the state has the same. Like I said, our initial deal was to get some of the money back on our victim, however, we understand.
So, all right, so here's what I'm going to do, Ms. Vogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please?
Sorry. I'll listen.
I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly. I'm not. I can't. There's no way. I mean, it has to be straight probation, and I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing. So you do.
No, I don't. No, I don't.
Okay. How many do you think you have?
I have 3 hearings and one back home.
Okay, you have lots of them that were at the same time for different offenses.
I was never convicted, never charged.
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, theft, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm gonna run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit, and that's the 10-year probation that you're on in 5 different cases. That's not correct.
No. Okay.
So how many cases are you on probation for in Sutton County?
It all ran together.
I understand it all. It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not gonna help.
It don't matter. My life's on anyway.
Well, looks like you did that, not me. I'll see you in 3 weeks. Come on, hold on, get her, don't let her go. Come back.
I heard bullshit.
Everybody heard it.
You said you're bullshit.
Come back.
Sure, lawyer.
I told my lawyer he was bullshit. I didn't say this.
You don't talk like that to anybody in this case because he didn't do this either, you did.
He got me the plea.
He did get you, he did a great job. I'm gonna find at this time that your bond is not sufficient because of your attitude and because of your criminal, because of your,
I gotta go to work. So I'm gonna lose my job and everything too.
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at?
We're gonna need another bailiff.
Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're gonna make it worse. You're just gonna make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. Let's see, can you?
Wow.
All right, I'm going to set your bond at $25,000. Go back with the bailiff. Mr. Macon on Cedric Fontenot.
I believe he still needs his fingerprint.
Okay, I'll call it as soon as it shows up. Thank you, sir. Mr. Paget, Mr. Galmore,
So
you
that
have,
that was one of them. We're about to go back to Thurston County, Washington, where they're about to start up again. But there's another appearance for the same lady from the day after. Wow. We'll have to watch that other one in just a minute. Let's see. We'll be here all night at this rate. Tell you what, let's see if we can catch that right now, and then we'll catch up on the other. Let's see. Then she returns the next day. Let me find it real quick. Oh, I hit the wrong button. next day was when? What's the time? Let's see. 3 hours, 27 minutes, 34 seconds. 3:27. She's right at the end of the day. 34. Here we go.
Mr. Lewis, Crystal Bogan.
Here's the apology.
Let's see how today goes.
Yes, let's do that.
I need the certification. Please. If I'm gonna, we'll see. I mean, my main thing is a convict, and we're done with deferreds for her, so see what y'all want. All right, ma'am, you're Crystal Bogan. And Ms. Bogan, when you were here yesterday for sentencing in cause number 25 DCCR 0026, just so the record's clear, I rejected that agreement based on your criminal history. The fact that it was a deferred probation, I feel like with your criminal history, it is at this point, if you're going to accept responsibility, time for a conviction. You were going to be able to leave yesterday. There was an incident in the courtroom. Based on all of that, I raised your bond. Mr. Lewis asked that we bring you out today. Mr. Lewis, what is?
Yesterday afternoon, I went and spoke with Ms. Bogan about everything going on with the case. One, she did apologize to me, and she said, of course, when she had the opportunity, she wanted to apologize to you, to the court, for her actions yesterday. I did explain to her as far as where we were as the case, the rejection was there on the deferred. You did kind of put at that point, it would have to be a straight probation with the restitution if she was to be on any type of probation. She told me she was more than willing to accept that. She understands how it may affect her with her job, but if she wanted to still, if that opportunity was there, she wanted to definitely take it.
Mr. Hoffpower.
Judge, in light of all that the court's already mentioned and cited, we're going to leave it to the court, but we would not be inclined. We're on probation after the way she acted and due to her criminal history. So we would, if the court wants to allow her to do straight, that's fine. I understand.
Yeah, well, that's what your argument was yesterday.
It was.
To continue, for me to go forward. So, I mean, the most important thing to me, obviously, I don't know that you deserve a probation at all with your criminal history. But as I said yesterday and today, it is time for you to have some responsibility and some consequences for continuing to commit felony offenses. You know, it's great that you can finish a deferred probation, but at some point you got to quit getting felony offenses and quit violating the law. And so I don't think that's fair at all. So what I can do, I have the paperwork still from yesterday, and if you guys would want to agree to a convicted probation, I can make that modification on this punishment recommendation, and then I can kind of reinstate everything up to the plea and all of that, so we don't have to go through all of that. So I'll reinstate everything we've done prior to today, make that modification on the paperwork, and go forward with sentencing. Is that everyone's agreement?
That's fine.
That's fine with us.
The modification will be a 2/5. It will be a 5-year probation. It will be a convicted 2/5. I am going to, I'm not inclined to order a fine because I want that restitution paid. So I'm going to mark through that. So with everyone's permission, I'll make that change, and that's what everyone's agreement is. Is that correct? And it is, I want to make sure you understand that this is now your agreement. And so if I follow an agreement to give you 2 years in the state jail, but probate it for 5 years, order that restitution, you can't change your mind later. This is your agreement. Is that correct? Okay.
I don't know if that's the right answer. Alicia and Horses is cancer-free after her testing today. That deserves a party sound. Congratulations. That is awesome news. Thank you for sharing that with us. That's really...
All right. Then what I'm going to do, let's see, restitution. And the restitution will be that $10,000.
$10,000 restitution.
And that's everyone's agreement as well, correct?
Yes, correct.
All right, then at this time, Ms. Vogan, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of property. Sentence you in accordance with your new agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay the $10,000 restitution and to follow all of the rules and conditions of probation. If you do this, this is still a good opportunity because you will be able to serve that 2-year sentence while you're out on probation instead of in the state jail prison. The other side of that, though, is if you violate any condition of probation at all, you will be brought back into court and you will be facing that 2-year sentence that I just gave you. Do you understand? I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, ma'am. Do you need my PSI? I printed it out. Okay, you've got everything. I'm sorry, I just printed my PSI, but y'all can throw that away.
Orders, but I have them.
You have them? Okay.
Judge, if it's okay with the court as well, we want to apologize to you.
Yes, ma'am.
I'm very sorry. I was going through a lot, which I understand is not an excuse. And I do apologize for my actions and behavior yesterday.
I appreciate that. Make sure that while you're on probation, that you don't let those emotions also get in the way of you being cordial and doing what you're supposed to on this probation, as well as the other one that you're on, because that just in itself could get you right back in here. Even if you disagree with whatever they're ordering, if you disagree, you disagree. But you have to do everything they said. You have to be cordial. Thank you for your apology. You can go back with the bailiff. Thank you.
Wow, it's amazing how a night in jail can change your attitude a little bit for some people. It did for her. Okay, we're going to see if we can go back up to Thurston County and catch what's left of our trial up there. Where are we at? Thurston County 4 is where we're at. It's not showing up yet. Come through over here.
Homeownership is often considered the cornerstone.
I don't know why I'm getting an ad. All right. They're not back yet, so we're just waiting. It was good use of our time there watching that. Josh. Wow, that was a live one for sure. All right. Watching to see if they go live. Read some chats here. Let's see. Maybe they took an extended lunch. Maybe she went frog, or the defendant went frog. You know, that happens at lunchtime in this courtroom. So people can leave and never come back. The judge isn't a pushover. But, man, okay, first of all, I think she was lying to us. I'm not a CNA. I've never been a nurse or a nurse assistant or anything else. But isn't crimes like forgery and drug possession and theft. Don't those typically, raise the red flag on the employment factor? I would hate to think that if I go to the hospital and need treatment, that, the nurse that walks in might have a rap sheet as long as my arm for, taking someone's drugs. If I need them, if I need medication, I'd just be like, man. Tash says, heading home today. Today will be a test. Heading home today will be a test in patience with traffic. I love New York City, but the UN Assembly being here right now clogs everything up. It's crazy. She says she's a CNA already. The other jewels, where we left off on Thurston, it was lunchtime. Oh, they just went live. So let's see if we can get that up. Court 1, Court 4. Yeah, I wish this thing would just work a little bit better, but no. There's Court 4. We'll take it this one until it comes up here. Okay. Looks like everyone's just standing up, waiting for the jury to come back in. Give me a second to get the audio fixed on the better source. Take it to 2. Beautiful. There we go. Cross-examination is where we left off. It's going to be a late one tonight. One more witness. Cross of the second. Let's see where this goes. Tash, I'm not sure what the red zone between 56 and 42nd is, but it sounds busy.
Yep.
And slow.
Folks, good afternoon. We're ready to proceed with the defense examination. Trooper Murray, Ms. Moore.
Thank you, Your Honor. Is this an all right place to have this? Am I obscuring anything?
It helps we can see you. That's actually good.
So, Trooper Murray, good afternoon. So, September 30th, 2020, you're getting close to your 5-year mark.
Yes.
So in this case, you first encountered Mr. Woods outside of a car, which was parked and turned off, right? And you said, we heard you say you thought the vehicle felt warm, Will?
Yes.
Correct. And you know how long it takes for a vehicle to cool down once the engine turned off? No, you haven't timed that or anything?
No.
Okay. So would you agree that in the video we saw, while you were sort of conducting that stop, we saw 2 cars pass?
Yes.
Mm-hmm. And those cars, would you agree that they didn't look like they were going 60 or more miles per hour? They were slowing down because it was an off ramp. Is that fair?
I would hope they were slowing down. Their lights were on.
And would you agree that as you were talking to Mr. Woods, you and Trooper Cadet Travis were kind of standing on either side of him?
I was positioned initially at the rear, and then I moved to the front so I could keep eyes on traffic.
Sure. And you were in a pretty narrow strip between the car and the off-ramp. Would you agree?
Right.
So the only way a person in that position between the two of you could see both of you would be to take a step back. Is that fair?
Say again.
So Mr. Woods standing between the two of you, right?
Yes.
Would you agree that the only way a person in his position could see both of you, both you and Trooper Cadet Travis, would be to take a step back?
I guess that'd be one way to do it.
Okay. Are there other ways to do it you can think of?
If you wanted to look at us.
At both of you.
You could position in front of his vehicle.
I suppose. So I think we heard both you and Trooper Cadet Travis testify that when you first encountered Mr. Woods, he was polite. Would you agree with that? He was cooperative?
Yes.
And the situation kind of escalated? So you made the choice, I think I heard you say, to go to Thurston County Correctional Facility, so the county jail, instead of Lacey Police Department, to get more law enforcement available. Is that correct?
Yes, I knew that there would be staffing there.
Yes. So that's a choice, that's a decision that you made based on being in the patrol car with Mr. Woods in the back saying things that, yeah. Would it be fair to say that this is a situation you already felt like was escalating?
Yeah, I would say as soon as we started leaving and I could hear him in the back, just felt like it was going to escalate.
And in that type of car, so he was in the back of the car, correct? You were in the front of the car, you and Trooper Cadet Travis both in the front seats?
Correct.
And he was strapped in the back of the car?
Yes.
And it's a patrol vehicle. Those have a barrier between the back and the front seats, correct?
Yes.
Is it a grate or a plastic barrier in that
partition.
one? Okay. So there's a partition. Have you had training? You've had a lot of training. We heard about that. Has part of that training been on de-escalation?
Yes.
Okay. And in your training and your experience, does increasing law enforcement presence usually help de-escalate a situation?
It can.
Okay. It can sometimes when someone's already upset.
Yes.
Okay. Would it be fair to say that in the course of your job, you deal with a lot of angry people?
Not as often as you would think.
Okay. But you've dealt with angry people in the course of your job, because there's a lot of folks that aren't happy when law enforcement appears. Is that fair to say?
Sometimes.
Sometimes. And at this point, you'd been doing a night shift. I think I heard you say 2 to 3 years. And for that,
up to that incident,
yeah.
Was that 2020? Yeah, about a little over 2 years.
Okay. And 2 more years since then, or have your duties changed?
I went to day shift about a little over a year ago.
Okay. And what was happening in the back of the car that continued in the BAC room, sort of verbal escalation?
Yes.
Okay. And again, so I think we've heard from you and Cadet Trooper, former Trooper, now Trooper, formerly Cadet Trooper Travis. There were at least 2 or 3 corrections deputies as well as the 2 of you present, correct?
Eventually there were.
Okay. So minimum of 4 law enforcement versus 1 guy in handcuffs.
Initially, it was 3 of us in the room.
Okay, but you said you observed, I think I heard you say you observed what looked like Mr. Woods trying to slip his handcuffs?
The deputy that was standing to the rear and just there for if I needed help, he spotted that.
Do you have people try to slip out of cuffs sometimes? Is that something that happens?
It's happened.
Yeah. When they do try, do they often succeed?
It's happened once with someone in my custody, just because the handcuffs wouldn't go as tight as they needed to be.
So purpose of handcuffing someone is to restrain them, correct?
Correct.
But sounds like maybe they're not all that effective at that sometimes.
Well, yeah, yes.
Okay. So this was a sort of switching gears. This was obviously a whole kerfuffle and a stop, but it was also a training exercise for formerly Trooper Cadet Travis, correct? And had you trained cadets before at that point, about 3 years in?
At that point, I don't know if I was a field training officer. I am now, but I had taken cadets with me as pre-academy cadets.
So it sounds like it's not that intensive of training for a ride-along person, correct?
No.
Yeah. But part of that training, I'm guessing, based on, I guess my own experience being an attorney, training your attorneys is role modeling how you interact with a wide variety of folks in different situations, right? And including how you respond to an escalating situation, correct?
Sure.
Okay. And one thing you'd want to train someone also is probably looking for signs of impairment, correct?
Yes.
Is it fair to say with any traffic stop, you're looking for signs of impairment?
It is fair to say that.
Okay, so anytime you encounter someone in a car looking for signs of impairment?
Personally, yes.
Okay, someone near a car?
Say again?
Someone near a car?
Near a car? Like if I'm contacting a disabled motorist?
Yeah, like in this situation.
In that situation, I don't necessarily go into it like that.
Fair enough, but you've handled a lot of DUI stops over the years, yes?
Yes.
Okay. And we heard that you're trained in SFSTs. I think I heard you say also the HGN, the horizontal gaze nystagmus, that shows the presence of a depressant, correct?
CNS depressant.
CNS depressant, central nervous system depressant, right? So what it shows is alcohol consumption, correct? It doesn't show impairment level.
Impairment level? Well, there's a study that NHTSA did. It's the.
I would ask just yes or no is.
Okay. I would say HGN can show if someone is under the influence.
Okay.
CNS depressant.
But it doesn't really show you. Really, what it shows you is that they've consumed a certain level, like they have consumed alcohol, right?
It does show that, yes.
Okay. So, is it fair to say that there's a wide range of ways people react to being accused of DUI, especially if they have been drinking?
A wide range, I guess.
Mm-hmm. So all of this, I guess, you're the one who was sort of doing the training, and as you're now a training officer, is it fair to say this was a good learning opportunity for Cadet Trooper Travis? Yes. Difficult though this experience may have been? Yeah, and part of what you train on is also proper reporting, correct? How to write a narrative report.
Yes.
Yes, what details to document, correct?
Yes.
How to do that paperwork? Okay. So jumping back to this encounter in particular, I mean, we've kind of been talking about it the whole time, but at the time you made contact with Mr. Woods, I think we saw it was about 1900 hours, about 7 p.m., correct? And I think the time on the part Mr. Holcomb asked, where he stopped it and asked you earlier, it was about 7:25, 7:30. Do I recall that correctly?
I'm sorry, I'm bad at hearing. Say that again.
I think the part that Mr. Holcomb showed you earlier, it looked like it was about 7:25 or 7:30.
What's with these officers that are bad at hearing?
It was a brief thing. But later on, you observed the blood draw, correct?
Yes.
And I think I heard you tell Mr. Holcomb that you don't recall what time the warrant was granted. Is that correct?
The warrant, we did find the time. It was the time of the blood draw after the warrant.
Okay. Let's see. What I wanted. Your Honor, permission to approach the witness?
Mm-hmm.
It was yesterday and it's been marked. It's the DUI.
Oh, okay. Yeah, okay.
It's Exhibit 1. It's, do you recognize this?
Yes.
What is it?
Can I look, see what is included here?
Yes.
This is the DOL DUI packet.
Mm-hmm.
And then this is a copy of the property evidence form.
Yes. Your Honor, is there more I need to do to get this admitted before I can use it to refresh?
It won't be admitted, but you can use it.
Thank you. So this, I want to draw your attention to this sheet in particular from the back of the DOL packet. Can you read what it says in this line?
Which one?
I'm going to object to that, Your Honor. Can be used to refresh recollection, but neither the state nor defense can have the officer read from
I apologize. Does this refresh your recollection of what time the blood draw was completed?
Yes.
Okay, so do you now recall what time the blood draw was completed?
Yes.
What time is that?
21:54.
So in sort of 1 to 12 time, what time?
9:54. Yep.
Thank you. Actually, I should leave this over here.
No. If it's only admitted document.
So it was before or after the warrant? Which one? It's got to be after the warrant.
So almost 10 p.m., correct? Nope, 9:54. Okay. So we heard you testify, I believe, that you had passed that exit earlier that night, correct?
Correct.
and you thought that the car was not there before. And that was something that you believe you remembered.
Yes.
So I think I heard you say that you were responding to a collision up in Pierce County when that happened. Do you remember where you were starting from?
I don't recall where. It would have been on the south on the beat. Exit 114 is the furthest north exit in Thurston County for us. And I usually patrol in that area because it's a busy area for us, but it would have been south of that.
Okay. And when you're responding to a collision in somewhere else, is it fair to say you're probably like on the radio with dispatch, focusing on other things?
It depends on what if it's an injury crash, probably running code, lights and siren. If it's a non-injury crash, it's routine response. There's no urgency to get there.
Do you remember anything about that collision?
That collision in Pierce County, I don't recall.
Okay.
I think it was non-injury. I don't think it was even reportable, to be honest.
Okay. Do you remember what lane you were driving in when you passed the exit where this incident happened?
I don't remember it.
Okay. Do you remember, and you don't, it sounded like you thought it was maybe an hour earlier, but do you remember exactly what time it was?
At the exact time, I do not.
Okay.
I do have that in my report.
So I appreciate that. I actually want to switch gears to the bot. So we've seen a lot of video. All that video, it was captured on in-car cameras, correct? Either a dash cam or a camera that's capturing the inside of the patrol car. Because Washington State Patrol didn't have body cam at the time. I think Mr. Holcomb established that with Trooper Travis, yes?
Correct.
Do you have body cam now?
Yes.
Okay. And I believe I heard that the visual on that mic pack audio was coming from the car camera in the BAC room at the jail. Is that correct?
So for the dash cam that we used to have, we carried the mic pack on our belt.
Okay.
And the camera was affixed to the front vehicle.
Okay. And regarding the COs, the correctional officers at the jail, sorry. One of those correctional officers contributed a supplemental memo when you filed your police report, correct? And that memo was, I think, written and directed to you, correct?
Yes.
And that was called a use of force memo?
I don't recall what their memo was called.
Okay.
At this stage, objection relevance, and also this witness did not write the report. Anything he has to testify to for the report itself would be hearsay.
Okay, thank you. Folks, I'm going to ask all of you to step back into the room. I'm going to discuss this issue with counsel. We'll bring you back in here as soon as we have it to tell.
Jury out. Let's make sure we're all the way current on this. And we're live. Jury out. It's time to maybe kick the officer out as well. I don't know. Maybe we'll proffer it. What do you think? Time for a little proffer?
And Ms. Moore, where are we going with this?
Just
What's the relevance of it?
I think it's relevant to the sort of the reason or the mens rea component of the obstruction charge. To prove this, the state has to prove that Mr. Woods willfully sort of behaved willfully. And I think the presence of a use of force memo is relevant.
Okay. May I see the memo, please? Are you trying to introduce the memo?
I'm not trying to introduce it. I was just going to ask a question about it.
And what's the question, so I know what it is?
The question is, it's called a use of force memo, and the context of that is for when there's been use of force against someone in custody.
So you're trying to establish that, and there's already been testimony that use of force was used to restrain Mr. Woods.
Yes.
And you're trying to confirm that whatever was used necessitated a use of force memo.
Yes.
I believe that that information has been established by testimony that's already been elicited. And the state would just object to going into any of the contents of it. The fact that one was written, no objection to that.
And defense was not asking him to testify to the contents of it, just to the subject.
You just want the existence of the use of force memo. To be-
Yes.
First, now they know it. And Mr. Holcomb, are you asking me to tell the jury to disregard the existence of the use of force memo?
I mean, that would be my preference because I don't believe that it's relevant. But my strongest objection is to objecting to the content of the force memo itself. I also believe that its existence is irrelevant, but I have less of a strong objection to that. I guess I'll put it that way.
Well, we're not going to admit any statements in there because of the statements, hearsay statements of somebody who's not here. I'll allow you to ask the one question: did Trooper Murray receive from whoever this other officer was a use of force memo?
Okay.
And other than then asking questions to Trooper Murray about his specific experience, I don't think there would be any basis for going further on that. Okay. All right, we can bring the jury in.
All right. We've sorted that out. The judge was just curious where we were going because it was dangerous no man's land. Four officers is a lot.
Please be seated. And we're back on the record, Ms. Moore.
So just to sort of wrap up that line of questioning, you received something that we could call a use of force memo, correct?
Yes.
All right. I have one final sort of thing. So I believe in the video, one of the sections of video, the in the car video facing the back seat, I believe we heard Mr. Woods say, and you, I think, said something like, "This time is different. Like this won't be the last you see of me." Is that more or less correct?
More or less.
Okay. And it seems like in context, you interpreted that as a threat. Is that fair to say?
Yes.
But it was true, wasn't it?
Sure.
I mean, it's coming true today. You are seeing each other again today. So, actually, no further questions. That's it.
All right. More, Mr. Holcomb, any redirect?
Yes, Your Honor, brief.
As long as the last you're going to see of me, there are some other things he said that made it clear that that was a threat.
Did the defendant say he would shoot you if he didn't have cuffs on?
No.
Okay. We're going to the scene, or there's a video. There are cars passing by.
I'm sorry, that was funny.
Says that defense said that the vehicles were slowing down. You mentioned something about your emergency lights.
Yes.
Okay. So were those activated like at the point that you pulled over?
Only the rear lights were activated. The lights were on so that approaching traffic knows that we're there, and hopefully they slow down and move over.
Okay.
That's a good one, Amber. That's a really good one.
So the defendant's words in the back of the vehicle, as defense talked about, that caused you to change your plans when it came to where you were going to get the BAC sample, correct? So, but for the defendant's words and conduct in the back of the car, you would have done this investigation differently, correct?
There's his but for again.
Briefly talks about de-escalation when it comes to numbers. I believe you said something about additional units can help with de-escalation situations, correct?
Correct.
Could you expand on that a little bit?
Sure. If it's just a one-on-one scenario, someone might be more inclined to try to use force against you. If you have other officers there, usually it can calm things down a little bit.
Okay. So it's a forceful presence is the idea, right? Okay. Did you put cuffs on the defendant before he started to act belligerently?
Yes.
Why?
I placed him into custody.
Okay, so you say that as a matter of fact. Is that standard procedure for people who are taken into custody? Okay. What is the purpose for putting defendants in handcuffs when they're taken into custody?
It's policy and it's for safety.
Okay, what do you mean by that?
We're required to.
Well, yeah, I meant by safety.
Oh, safety. When someone's in custody, they need to be secured, they need to be searched, and then, to make sure they don't have weapons, and then that they remain in custody.
Okay. Throughout this encounter, did you have a firearm on your person?
Yes.
When you were walking around the defendant, did you have a firearm on your person?
Yes.
Are the cuffs in response to presence of stuff like that?
No.
Objection.
Understood. Right. But you didn't ever pull out your firearm or anything like that, correct? You didn't touch the firearm at all during this, correct?
Actually, maybe put my hand on the holster just to rest it, but yeah.
Okay.
Just resting my hand on the. that looks threatening.
Going back to the timeline, because defense raised the blood draw happened at 9:54 p.m. Correct?
That was a
blood draw.
De-escalation.
Do you recall when the encounter was? When you initially encountered them on the road?
At 6:58, I believe.
6:58 was the encounter. Okay. So, and you were on patrol in the area already at that time, correct?
I was, when I came across Mr. Woods, I was patrolling there.
Yeah. And your shift started at what time again?
4 p.m.
Okay. So you'd roughly been on patrol for approximately how many hours from 4 to 6:58?
3 hours. Sorry.
Okay. And when you're on patrol, does that involve passing by the same location multiple times?
For me, like I said, I patrol that area because we get a lot of collisions, a lot of calls for service. So I try to stay in that area.
So what does patrol mean? Like, define patrol for me. Like, what is, describe your driving pattern when you're on patrol.
I'm driving the area looking for violations, mainly speed, because we get a lot of crashes there related to speed. Other violation, distracted driving, looking for disabled vehicles, things like that.
Okay. And you did not encounter this disabled vehicle prior to 6:58 p.m., correct?
Correct.
Okay. Defense briefly referenced a use of force memo, correct?
Correct.
Is that standard procedure when you physically, or deputies have to physically restrain someone?
I don't know what their policies are. I'm assuming that's their policy.
Okay. Why did you ask for a use of force memo in this case?
I didn't specifically ask. I just asked for a report from the deputy.
Okay. So, and throughout the encounter, did the defendant say what he would do if he did not have cuffs on?
Multiple times he said he would fight.
Okay. Nothing further, Your Honor.
Ms. Moore, recross.
Just one question on recross. So the initial stop 6:58, blood draw 9:54. You said you remember the time, where you did find the time of the warrant, and that was 9:14, correct? So 40 minutes before the blood draw was actually effectuated?
Yes.
That's all. Thank you.
Mr. Holcomb, anything else?
Nothing.
Okay, next
At this time,
witness.
Your Honor.
All right, members of the jury, any questions for Trooper Murray?
Jury
Don't see any?
questions? No.
Trooper Murray, thank you for your testimony. And Mr. Holcomb, do you wish Trooper Murray to remain, or is he excused?
He is excused, Your Honor.
Ms. Moore, any objection?
No, I don't believe so.
Murray, have a good day. Mr. Holcomb.
Yes, Your Honor. The state calls Washington State Patrol Toxicologist Alec McDougall to the stand.
Alec McDougall. We're going to unpin this message. I'm emailing Charlton Young right now. Charlton Young is my Sweetwater sales engineer. Hoping he can get a product that they don't have on their website. Just a heads up, I am trying to grow the channel. That is a goal of mine. And obviously hitting 6,000-7,000 subscribers, that's part of it. But I'm looking at live streaming on multiple platforms simultaneously. So it'd still be this, but we would also possibly have the feed on Facebook, and I don't know if Twitch would do it, but Facebook and Twitch and possibly X, and maybe in short form, like vertical on YouTube, just in a lot of different ways. So I think I found the there's a lot of companies out there, Restream type companies, that for a fee will let you restream. StreamYard will let you stream to multiple locations like that. But you have to pay them every month, and I don't like doing that. So I've got a piece of hardware I'm trying to source. It's made by Magewell. It's called a Magewell Ultra Encode AIO, which can stream to 6 different locations simultaneously with no monthly fees. And I'm a big fan of no monthly fees. So basically we would still be here on YouTube, but also possibly be on Facebook and a couple of maybe Twitch even. I'm not sure if I'll ever be on Twitch, but
all right. Can you please state your name and spell it for the record?
My name is Alex Mascougall, and my house name is spelled MCBOUGALL.
And what are your current official duties? Well, how are you employed?
I am a forensic scientist at the Washington State Patrol Toxicology Laboratory.
As well.
Okay, and what are your current official duties?
So as a forensic scientist in the toxicology lab, I test biological specimens for the presence of drugs, alcohol, and other inferring compounds. It is sort of the broad overview.
Okay. In order to become a Washington State toxicologist, did you have to go through any education or training?
A forensic scientist in the tox.
Right, forensic science.
The toxicologist is a position far above me.
Okay.
But yes, I received a bachelor's of chemistry from Western Washington University in 2017.
Okay. And aside from the bachelor's degree, did you take any specific training with the Washington State Toxicology Lab?
Yes, since I was hired by the Toxicology Laboratory, I've gone to a number of courses, including the Borkenstein course on alcohol, which is a week-long course on the effects of alcohol on the human body, and the Borkenstein drug course, which, very similar to the alcohol course, is a week-long course, but focused on drugs, not just alcohol. I've been able to attend the SFST, or the Standard Field Sobriety Testing courses that's offered to a lot of law enforcement officials, as well as the ARIDE class, which is the Advanced Roadside Impaired Driving Enforcement class, as well as reading a number of scientific texts and literature since being employed with the State Patrol.
Okay. As part of your occupation with the Washington State Toxicology Lab, are you expected to keep up to date on the literature regarding toxicology?
We do. I am subscribed to a forensics newsletter that does keep us up to date. We do. In part of going to these courses that we're able to attend is being informed on more recent literature in the field, and the texts that we read while employed through the lab are periodically updated.
Okay. Did you receive any specific education or training about how alcohol is processed in the human body?
Yes, I did. So I mentioned the Borkenstein alcohol course. That is one course specifically focused on that subject. And additionally, a number of the trainings and materials I've read in the lab covered that topic.
Okay. Did you receive any training or specific education about how that process of alcohol in the human body, how it can manifest, like how the effects of it can manifest, like individual, like things that you can see in a person.
Yeah, part of that is understanding the effects of alcohol on the general population.
Okay. The state would move to have forensic scientist Alec McDougall admitted as an expert both in how alcohol is processed in the human body and how those effects manifest.
I would object as to the relevance of how those effects are manifest. That's not, Mr. McDougall has no firsthand knowledge, but it would be relevant to sort of the facts of this case.
I'm not sure what Mr. Holcomb means by how they would manifest. So I think we'll hold off on that as far as how he phrases a question. I will acknowledge Mr. McDougall as an expert on the effects of alcohol on the human body.
Okay.
That's the same thing. Effects of alcohol on the human body. Selena, soon, and then I challenge you to a race.
What's been marked as plaintiff's exhibit number 6. Do you know what that is?
Yes, I do.
Okay. What is it?
That appears to be a copy of the photographs of the tubes involved in this particular case.
A copy of the photographs of the tubes.
Well, first off, my question is, how do you know that those tubes are for this particular case?
So my first indication is we have an ST, or a state toxicology number, at the top. That is what we use to track all of our cases within the laboratory. And the number at the top of this page matches the number that I'm familiar with in this case.
Okay. And are you able to see on the vials if there's any name or discernible inscriptions on the vials?
Yes, there is a what looks like a hospital label, so a printed label with a name on the tubes, and additionally an agency case number written on the label of the tubes.
Okay. What's the name on the tube?
The name on the tube, and please correct me if I'm pronouncing this wrong, is Dewan L. Woods.
Did you personally handle these vials?
Yeah, so when I accept my cases for testing, I will review the request for analysis form, which includes a lot of information relevant to the case, who, the subject name, what agency is submitting the tubes to us, and I will physically receive the tubes and inspect the tubes and make sure that any information that is on the tubes matches the information on our request forms.
Okay. Do you know if there were any preservative chemicals present in these tubes?
So the type of tubes used in this case are our gray top tubes, which I know to contain both an anticoagulant and an enzyme poison. So preservatives to protect the integrity of the sample while it is being stored.
Okay. And did you do anything to test the integrity of the sample before you took it out of the tube and started conducting tests on it?
Well, so I can, in addition to, I've got, there's a lot number printed on the label of the tubes that's attached to a certificate of compliance saying that these preservatives are added into the tubes. Additionally, when I get the tubes and inspect them, when I'm inspecting the information on the labels, I'm also checking to see that the blood in these tubes is still liquid and free flowing, which is an indication to me that the anticoagulant is present in these tubes.
And what does the anticoagulant do?
Prevents the blood from coagulating or, congealing kind of something.
Keeps it liquid.
It allows the blood to stay liquid.
Okay.
Hey, well, I obviously, when that time comes on those other channels, I'll need some help on the moderation front. You'd be surprised.
I'll take
I'm not a
plaintiff's
taskmaster
exhibit number
when it comes to mods.
6. Can you tell me what plaintiff's exhibit number 7 is?
Yes, this is a copy of the toxicology report that I authored for this case.
Is it a fair and accurate representation of that report?
I would say so, yes.
Okay. And is your signature on that report?
Yes, it is.
You personally created this, correct?
That's correct.
Your Honor, the state would move to admit plaintiff's exhibit number 7 into evidence and publish to the jury.
There's more.
No basis to object, Your Honor. Aside from the existing standing objection.
Aside from the other objection.
Admitted.
Permission to publish?
Me.
Spinning the tube separates the white blood cells out, right? Red, I'm excited for your drywall contractors. They are so much fun to watch work, especially good ones. You get good ones, they work fast, and they do such a dang good job. Or there's me, who takes months to do it.
So I've frozen. Oh.
Again.
He's using the digital Elmo, his laptop.
So I've frozen.
Let me interrupt. For the members of the jury who are thinking, how are we supposed to read that? I'm going to tell you that having been admitted, you'll have that document with you in the deliberation.
So I have frozen on the screen exhibit number 7. So I'm just going to go from the top to the bottom of this just so that everyone knows what we're looking at, because no one else here is a forensic scientist. So up at the top, let's start with here. It says attention, and then it lists a name. Whose name is that?
It is Trooper Jonathan K. Murray.
Okay, and why is that name up there at the top of the report?
So on our request form, when they send the samples into the lab, it's usually there's a line on the form that says who do we send this back to once we've got all of our testing done, who's going to process this information, who's it important that this gets to. So that's just letting kind of directing this report once it's returned to whatever agency it goes to.
Okay, and the agency and address, is that where you're going to send it?
Correct.
Okay. And then you talked about the ST number already, correct?
Right. So that ST number, or the state toxicology number, is the identifier that we use to track cases within our laboratory.
Just very briefly, giving you plaintiff's exhibit number 6 again, that's the blood vials. Does the ST number in this report match the ST number that is on the blood vials?
Yes, it does.
Okay. And then it lists subject's name. So, and what does it mean by subject?
Just the individual involved in the case.
Okay. So is this like, by involved, do you mean it's like a sample from them, or?
Correct.
Okay. Then we go down to agency case number. It's just does that just track it, or?
Yeah. So, where we have the ST numbers to track things within our laboratories, other agencies have their own numbering system to track their own cases. We assign a different number, the ST number, because what if the city of Spokane and I don't know, Kittitas County Sheriff end up with the same case number because they're not necessarily communicating when they're numbering their cases. So we assign our own case number to separate. It's just an additional piece of identifying information.
Okay, and then we go to evidence, and it says ST, then it gives a number and a letter, and then another ST number, letter, and that says gray lot. So what are those? What are those in reference to?
So that is in reference to the 2 pieces of evidence that were submitted to this case. There were 2 blood vials. So we will assign the ST number and then A and B to these 2 vials. The V gray is identifying the type of tube that was submitted. In this case, the gray top stopper tubes that I mentioned before, containing those preservatives. Blood, what's in the tube, and peripheral, where it came from. The location of the draw. Peripheral typically means it's an arm somewhere.
I'm out of candy.
But they're are alternative locations that blood can be drawn depending on the situation.
The last
Does it matter?
box of crackers.
Not particularly, no.
Okay. Going down to volatile analysis results. So then it lists out tested head space, gas, a lot of words I don't understand. So could you try to break that down for me as if I failed high school chemistry?
Sure. So it next breaks down the volatile analysis results. It says we have the ST number and then an A. So that's indicating that we did the testing on the A tube. In this case, it then says that this was tested by our headspace gas chromatography. Headspace gas chromatography is a precise and accurate method that our laboratory uses to separate and quantify volatile compounds in liquid samples or blood samples. It lists what compounds we were testing for in this volatiles analysis: ethanol, drinking alcohol, acetone, isopropanol, and methanol. It will indicate, or then there'd be another line, it would indicate, what the results of this test were and what dates these tests were run on.
Okay. And this method of examining the blood, it's headspace, what is it called?
Headspace gas chromatography.
Okay, headspace gas chromatography. Is this a scientific method analysis that is approved by the Washington State Toxicologist?
Yes, it is.
Is it in wide use throughout the state?
Yes, it is.
Is it a process that could be repeated by a different forensic scientist?
Correct, it could be.
Okay. And these blood vials, are they still with the Washington State Toxicology Lab?
I believe they are, yes. We retain, the Washington State Patrol retains Washington State Patrol evidence samples. Other agencies have different rules, but we tend to retain the samples from the Washington State Patrol cases.
Okay, and going back just a little bit, when you got these blood vials, what storage unit or like machine were they in? Like what type of storage container were they in?
So you mean like what, when they were received, or once we got them, where did they kind of hang out until I was able to do my test?
Where did they hang out?
Yeah, so we, once our samples are received at the laboratory by our PECs, or property and evidence custodians, they'll get accessioned. So they'll take whatever information is on the request form, put that into LIMS, or our laboratory information management system. That's when we'll assign the ST number to keep track of everything. Then they will go into what we call the vault, which is just a series of temperature controlled and secure access refrigerators that only a limited number of people have access to. So they wait there until a scientist needs them for testing.
Okay. How long did it take from the moment that the lab received the samples to the moment where your test was conducted? How long was that? Like,
I believe these samples were received December 11th of 2023, and I believe I did my testing in late August of 2024. So that's approximately 9 months until, or from receiving to me beginning testing.
okay. Is that atypical?
It's something we're working on, but for our laboratory right now, no, it is not atypical.
Okay. So let's just continue down. It says ethanol, and then it lists a number, and then a plus minus sign, and then another number.
It seems like a long time.
What am I looking at here?
Yeah, so that was the result of our volatiles analysis, done by headspace gas chromatography. We have whatever compounds we found, in this case, ethanol. We have a quantity. In this case, we found 0.21 grams per 100 milliliter of whole blood. And then we have that plus or minus that we mentioned, a 0.02 or plus or minus 0.02. That's our confidence interval in this test. So basically it's saying if we ran this sample 1,000 times, 997 of those results would be within that 0.21 plus or minus 0.02.
So giving the benefit of the doubt of this error interval, that number could be as low as I'm bad at math, 0.19?
Correct.
Okay, but it could also be as high as 0.23.
Both of those quantities would be within our confidence level, correct?
Okay. And then if we go down to the signature block, it's gone. All right. Did you sign this document?
I did, yes.
Does your signature appear on this document?
Yes, it does.
What does that signature signify?
That I have reviewed, that the findings in this case are my own, and I've reviewed my findings, and to the best of my knowledge, these are whatever information I'm including on this report is accurate.
Okay, and is that signed under penalty of perjury?
I believe that's what that the block of legalese right there says.
I'll give it back to you. So under penalty of perjury, just so that you're able to know for sure.
Action relevance. He's testifying.
I have a lot of questions.
Okay.
Does it specify whether or not this is under penalty of perjury on the report you got in front of you?
Yes, it does.
Okay. And is it under penalty of perjury?
If that is what it says.
Yes. Okay. All right.
Let's ask the question 2 more times. So
both of these to the side. All right. So what type of is alcohol an accelerant or a depressant?
So alcohol is a central nervous system depressant.
Okay, what does that mean?
Generally, it just means it slows things in the human body.
Okay, so how would that manifest itself? You said what it does internally, but what is that like? What you're able to see?
Yeah, so it has effects on your vision, your coordination, your decision-making processes, your reaction speed. So I guess some things that you might be able to see, like physically see on an individual who's under the influence of alcohol. They may have slurred speech. They may have poor balance and coordination. They may have kind of watery, bloodshot eyes, or some, things you could observe in an individual.
Okay. Going back to vision, are you familiar with HGN?
HGN, horizontal gaze nystagmus, yes.
Okay. So what is horizontal gaze nystagmus, just briefly?
So horizontal gaze nystagmus is sort of the uneven, sort of jittery movement of the eyes horizontally, so side to side.
Okay. So how does alcohol cause nystagmus in the eyes?
So alcohol can, at moderate and lower dosages, impact your body's fine motor control, which you may think of as, doing something very intricate like writing, texting, something along those lines. But it also affects the small muscles that are responsible for you being able to enunciate and pronounce things correctly, which is why sometimes you hear slurring, but also the small muscles in your eye, or that, control your eyes. So it impacts their ability to kind of function smooth.
Okay. And decision-making, what do you mean by it affects decision-making? How so?
So it can sort of depress the frontal cortex. So basically, potentially more rash decision or less, less thinking behind some of the decisions potentially.
Okay. You said something about the prefrontal cortex.
Yeah, that's kind of your checks and balance system. So you're like, well, I could jump over this desk right now, but then another part of your brain is going to be like, that may not be an appropriate thing to do with them.
Okay. Then going to balance, I think was already covered with fine motor skills. You said that it slows things down. Does this mean that, do you mean like it calms someone down? Like, what do you mean? Does that mean someone's sluggish the whole time, or?
Well,
inartful, but I'll allow the question.
So it can slow down reactions, So, if you're potentially, let's say, under the influence of alcohol and someone throws a ball at you, perhaps you might not be able to get out of the way, or you may not be able to catch it because you're just sort of not reacting as quickly to a new stimulus.
Okay. Okay. Odor of alcohol. Is that something that you would typically detect, or odor, like any particular odors?
You could, yes.
Okay. How does alcohol cause that when you drink it?
So it in the lungs, the way kind of your you've got all these little air sacs in your lungs that are responsible for getting oxygen into your blood. But alcohol as a volatile substance, volatile meaning it transitions easily from a liquid to a gas. The alcohol in your blood, when it's in your lungs, does actually transition to a gas in your lungs. So if you've got an excess of alcohol in your system, and then you are breathing some of that alcohol that is now a gas in your lungs, gets exhaled and potentially smelled by people around you.
Okay. No further questions at this time.
There's more.
Good afternoon, Mr. McDougall.
Hi.
Welcome to Thurston County. So you're a scientist, yeah?
Forensic scientist.
Forensic scientist. I want to go very kind of broad, but I'm no scientist, but I took high school science classes. Part of the scientific method, right, is doing repeated trials to test for results, correct?
Correct.
Typically, is that fair to say?
Yeah,
that's
hypothesis and then analysis. Yeah.
You want to make sure there aren't any confounding variables, correct?
Sure.
So that's a reason maybe why when, say, phlebotomists do blood draws in DUI cases, they take multiple samples, correct? You want to have one to measure against in case you need it.
I think, I'm not specifically sure why we, for example, our DUI cases collect 2 vials as standard practice. It is possible that we would need more blood to do more tests.
Sure.
So more volume of sample is sometimes needed.
But typically, in sort of following the scientific method, to get a reliable result, you're going to want to have repeated trials. Is that correct? Fair to say?
Repeatability is an aspect, yes.
Okay. Now, when you receive a blood sample from a law enforcement officer, is it possible to know sort of at what stage of the presence of alcohol in someone's body that sample might have been taken?
I'm not sure I understand the question.
I mean, I guess to phrase it more simply, is it possible to know whether the alcohol level in someone's body at that time is rising or falling?
Without any additional information, no. When I analyze a sample, I can only tell you how much alcohol was in the blood at the time of the draw.
Sure. Now, this sample in particular was received on December 11th, 2023, correct?
If so.
Okay. And it was taken on November 30th, 2023, correct?
I'm not specifically sure when it was drawn, but.
Okay. Can you be certain that it was properly refrigerated between the time it was taken and the point where the lab received it?
I don't have any knowledge of the tubes before they arrived at our laboratory.
Okay. And this sample was tested, I believe we heard August 2024, is that correct?
Correct, August 22nd and 23rd, I believe.
And just one of the 2 samples was tested, right?
That's correct.
And so that means it was about 8 months between when it was received by the lab and when it was actually tested?
Something like that.
Okay. And are you aware that you said that you've been a forensic scientist for a few years, correct?
I don't know if we actually talked about when.
Yeah, I guess I don't know if you did either.
But yes.
Thought you did. But you have been, correct? Yes. Were you working, had you been working there like at least a year by the time you were testing the sample, or were you fairly new? over a year. So I'm guessing you were probably aware that about a year before the incident where this sample was taken, so December 2022 to January 2023, there was at least a week period discovered where a refrigerator storing samples in the lab malfunctioned.
Objection, relevance.
Not operating.
I'll allow it.
Sorry, do you need me to repeat that at all?
Could you please?
Yeah, just I was asking if about
getting
your
good. Hang
awareness that about a year before this happened, there was at least a 1 week period where that the lab discovered where a refrigerator that was storing samples in the lab had malfunctioned and wasn't operating correctly.
I don't recall if it was exactly a week, but I do remember there was a refrigerator that was not operating within the specific temperature range, and all of the cases that were stored in that refrigerator had notices included in those cases.
They did, that's true. And that was obviously well before this happened, but at any rate. So without knowing when a sample was taken versus when the person was driving, is it actually possible to estimate where they might have been when they were driving? Alcohol level wise.
Given potential information from law enforcement, we can do estimates, but these are just estimates. So as I mentioned, what we're measuring is the amount of alcohol in the individual's blood at the time of the blood draw.
Right. And I mean, are you familiar with sort of the reason that you do that, the provision in the DUI statute that to find someone guilty, it needs to be over 0.08 within 2 hours of driving?
Objection. This witness is not a lawyer, and at this point, defense counsel is testifying.
Right. Well, rephrase the question if you're trying to get to where I think you're going.
Okay. I guess, would you agree on a scientific level that there's a certain window of reliability of a test relative to sort of the time of the conduct of driving?
I'm still not sure I understand the question.
So if you're testing a sample of blood to try and show a level of alcohol in it for a DUI case where you have a law enforcement officer investigating a DUI, in order to make a scientifically reliable estimate for alcohol content at the time of driving, that's sort of what the point is, correct?
Objection.
I'll allow that.
I'm sorry, could you one more time, please?
I can try to rephrase it again. So when you're testing a sample in a case where there's a DUI charge, would you agree the point of that test is to get an estimate that can help you at least figure out where the level might have been when the person was driving?
Objection. This witness is not a prosecutor.
At the risk of having Ms. Moore constantly rephrase that, if you can answer that question, go ahead. Yeah.
I mean, I think what we're getting at, the point of us testing blood from a DUI type case submission for our laboratory would be, yes, to ascertain a level of, as I mentioned, drugs, alcohol, or other impairing compounds that were present in the blood at the time of the draw.
Sure. And on a scientific level, there's a reason why you would need to do that within 2 hours of driving?
Objection. This witness is not a legislator.
Yeah. I'll sustain that objection.
Okay.
There's a good objection. This witness is
basically
not a
what it comes down to is what I'm asking is it's without knowing when someone was driving relative to when the sample was taken, there's no way to know for sure, or even there's no way to know what the alcohol level in their blood might have come back as when they were actually driving.
So I think what I can kind of get at here is, I am testing whatever is submitted to our laboratory, and reporting our findings for, in this case, alcohol, or whatever is submitted to our laboratory. Our laboratory is not involved with putting individuals in a vehicle at a specific time in a specific place.
All right. I think that's, fair enough. I know I'm asking a lot of you here, but I appreciate your patience and your time. Thank you.
Ms. Moore, Mr. Holcomb.
So Let's give specifics when it comes to timeline, but let's just go back a little bit for a general concept. If someone consumes alcohol and hours go by where they do not consume alcohol, does the blood alcohol concentration go up or down after, say, 3 hours?
So I will have to give some stipulations just so we're covering all of our bases here. If you were to, consume alcohol, well, potentially, let's say you're also eating a heavy meal. You're drinking the alcohol is in your system, your body is absorbing that alcohol, but with a large amount of food, it may take up to 2 hours for you to completely absorb all of the alcohol that you have consumed. So if we're doing if we're trying to do an estimate on what a level may have been at an earlier point in time, we will provide a 2-hour window to guarantee that any alcohol in an individual system is fully absorbed. So in this case, if we're saying 3 hours, that would be 1 hour past our window. So, just generally speaking, if someone is drinking and then, 3 hours later, what would I expect the concentration of blood alcohol to be? I would expect it to be lower.
Okay, so lower at the time of the blood draw, correct?
Yes, if we're going 3 hours from drinking to the blood draw, I would expect it to be lower at the time of the blood draw.
So as time goes on and we reach the 3 hour point, we're at a lower place than we were at the time the person was pulled over or the stop happened, or
correct. I know I had to put a lot of stipulations in there, but yes, we are metabolizing that alcohol, so the concentration is going from higher to lower.
Okay, so defense was asking you questions, and your response in part was that you would need more information to fully answer questions. So the encounter in this case happened at 6:58 p.m. and the blood draw was at 9:54 p.m. By the time of the blood draw at 9:54 p.m., would you expect for the blood alcohol concentration to be lower at the time of the blood draw or higher than back at 6:58 p.m. when the defendant was first contacted by law enforcement?
I would be at the time of the draw. I would expect the concentration to be lower than at the time of the first contact.
Okay. So the test. So did you test both of the vials or just one of the vials?
Just vial A.
Okay. And is there a two-step process to these tests?
Yeah. So positive cases or cases that have alcohol or that we detect alcohol in are tested twice. And then the reported value is the average of those two tests. And those two tests must agree within plus or minus 10% of the average of those two.
So defense referred to high school chemistry or science and knowing that repetition is important. So repetition happened in this case, correct?
Correct. We did do repeated tests.
And that's where the number came, correct?
That's correct.
Defense briefly talked about it. The refrigeration issue at the Tox Lab. Was there ever a refrigeration issue at the Tox Lab?
Yeah, there was.
Okay. Did that refrigeration issue affect this case?
This case was not stored in that refrigerator, so is not relevant to this case.
Okay. How would you know that?
There would have been an IOC or a notice included in the case, saying, hey, this sample was in this refrigerator at this period of time while it was operating outside of the, designated temperature range.
Okay. And that notice was not in this case, correct?
Correct, because this case was not a part of that refrigeration issue.
Okay. And she referred to, you don't know where the vials were stored before it got to the Tox Lab, correct?
Correct.
So you didn't know if it was in a refrigerator then, correct?
That's right. I don't know where they're at specifically.
Okay. If that vial was left in a locker room somewhere, just in a locker, and it went from that locker to your Tox Lab, what would the effect be on the blood alcohol content?
So if you store blood samples with alcohol in them at, elevated temperatures for extended periods of time, you can see the alcohol concentration fall or decrease, because I've mentioned alcohol is a volatile compound. It moves it can move from the liquid to the gas phase. At higher temperatures, some of that alcohol in the blood will occupy, the empty space in the top of the tube. So when we open that cap, that, gaseous alcohol disappears, and whatever we test is potentially lower than what it may have been had it been stored refrigerated for its whole life.
So if there's an effect on the accuracy of the test, the BAC, the effect would be to lower it, correct?
Yeah, so if it was, yes, correct.
And that's, okay. No further questions.
Ms. Moore.
It's more to your hypothetical with heavy intake of alcohol immediately prior to contact with police.
When someone drinks alcohol in any amount, does that hit their bloodstream right away?
I mean, if you mean like instantaneous, no, there is a period of uptake.
So there is an arc, kind of.
Correct.
Okay. So if you don't know when someone was drinking relative to when a sample was taken, it's still hard to know where, and even if you know when they were first contacted by law enforcement, it's still hard to know where exactly in the arc of it falling they are when the sample's taken, correct?
Sorry, I just want to make sure I'm just going to paraphrase to make sure I have the question correct. I'm sorry, could you just repeat it one more time for me, please? If
you don't know either when someone, if you don't know when someone was drinking, even if you do know when sort of a contact with law enforcement started and when the sample was taken, you still can't really know where in the arc of it sort of rising and falling.
Okay, so if
sample was taken, correct?
Without knowing, when they may have started drinking, I can't state where, without knowing what they had to drink, how much they had to drink, what food may be in their system. It's difficult to ascertain where on the uptake or the increasing or the metabolizing, the decreasing they may be. Is that correct?
That was sort of what I was asking. Yes, okay. I think that's what I was asking.
Right. If we don't have specific information on when an individual starts drinking, or how much, or there's a number of factors that influence uptake. If we're drinking, on an empty stomach, that uptake can be very quick. But if we don't have a large meal, that uptake can be very slow. But in this case, we do know, when the contact was and when the blood draw was. So I can state with a reasonable degree of scientific certainty where we were on that curve at the time of the draw.
Okay, fair enough. But maybe not at the time of contact.
I wasn't on the scene, so.
All right. I don't think I have further questions.
Thank you. You're welcome. Anything else?
Nothing at this.
Members of the jury, any questions, Mr. McDougall? We have one, two, maybe. Amy? Questions? You're going to go get them. No, they haven't written.
Go get the questions. So hypothetically, if our defendant, Mr. Woods, saw the cops coming and he opens up and he's completely sober, he's trying to change a tire, and he opens up his fifth of Jack Daniels, he does this little maneuver where he opens up his throat and he just pours it straight down his gullet. He swirls the bottle so it does a little.
We'll bring you into the jury room. I'll discuss the questions with counsel, and then we'll bring you back in.
He's sober because there's an uptake, because he just ate a Big Mac too, or like a whole Big Mac Happy Meal or everything. I don't think they do Big Mac Happy Meals. Then they test him a couple hours later. He's on the arc coming down at 2.1, but that doesn't mean that he was at 5.7. Sorry, 0.21. These would be deadly numbers.
These are very similar.
You smell what I'm stepping in?
So we have two questions wondering, why does it take the state toxicology lab 8 to 9 months to test blood? Thoughts of counsel on that question?
That's not going to be allowed.
Mr. Hulk.
I would have no objection to it being answered.
It's coming in.
The answer is backlog.
I know what the answer is.
Yeah, I think we all know what the answer is.
Ms. Moore, any objection to the
No
third?
objection to that being answered.
They're asking it.
We'll ask that question.
Okay.
And one of the jurors asked a follow-up question, which is the length of time in this case. Does that impact the test results? Any objection to my asking the question?
I would have no objection to it.
Ms. Moore?
I wouldn't really have a basis to object to it. I think that's reasonable.
Any more questions?
And then somebody else asked, what is the blood alcohol level for Washington State? What's a high level? What's the law say? And on that, I would say they're going to hear.
Yes.
I would agree.
Okay, so I will not ask that question.
Correct.
We'll ask the other two questions. As soon as we get Amy, we'll get everybody back in here.
Amy, go get them. Hopefully you're not talking to the jurors. We love this courtroom, but they have had trouble in the past with the clerks being chatty with the jurors. And if this is a new clerk and she doesn't even know that she's supposed to gather questions from jurors and things like that, I'm worried that she's just chatting it up, pulling a Becky. But you brought your own? Chug, chug, chug. Bottoms up.
Can have it on the table.
Oh. I won't introduce any new variables. Everybody hear me all right? Yeah, I can hear you.
The witness. Can everybody hear me all right? Now he asks.
I think almost every forensic scientist I've witnessed I've had at a trial has had a water.
All right, Amy, we're ready for them.
I'm sorry, they've all had
I
it.
just have had water bottles with stickers.
Oh.
What's the sticker say? Not alcohol.
Price?
It was this court where the clerk said go with the majority of the votes, and we got a decision that was not unanimous. That was a fun little trial.
Here he asks a total 6 questions. Of those 6, I will ask 3 questions, Mr. McDougall, and the other questions
were either duplicates
regarding what is the legal limit will be provided to you when we instruct you on the law to apply in deciding the case. So you'll hear from me on the instructions as regarding what the statute says. Mr. McDougall, to your best knowledge, why does it take a state toxicology lab to take 8 to 9 months to test a blood sample?
The simple answer to that is a backlog. We've got a lot of cases we're working through. I guess to dig a little more into that, there was a period of time where we were getting more cases and had fewer scientists working. So that just started slowly stacking. And then we started hiring more scientists.
Just talk to me.
Oh, sorry. Sorry. We started hiring more scientists to, combat this backlog. So we are working our way, but we have a surplus of cases for a while and not enough hands to do the work.
Mr. Holcomb, any further question on that issue?
Does the delay in the time of testing in this case, in your expert opinion, have any effect on the veracity of the results in this case?
That's the other juror question.
No, it doesn't particularly affect. The samples are preserved and stored, refrigerated for their preservation. If anything, over a long period of time, while under refrigeration, we may see a slight decrease in concentration, but we are, more or less confident in our results.
And by decrease in concentration, you mean the number would be lower, correct?
Potentially, correct.
Ms. Moore?
I don't believe I have any additional questions.
All right. So Mr. Holcomb asked the second question, which was the impact on test results, and Mr. McDougall answered the question. So Amy, we'll make these two questions, which were added
Okay.
as part of the record, and the question which wasn't as part of it. And any objection, Mr. McDougall being excused, Mr. Holt?
No objection, Your Honor.
Ms. Moore?
No objection.
Mr. McDougall, you are excused. Thank you.
Thank you.
That was our last witness from the state.
Mr. Holcomb?
The state rests, Your Honor.
All right, thank you.
Defense.
And Ms. Moore, are you ready to proceed?
If we could have a brief recess for bathroom breaks and
5 minutes. All right, folks, I'll send you back into the deliberation room. We're going to take a very short 5-minute break here.
Are you going to kill the stream again, Judge? Don't kill the stream. Just keep it up. Just keep it up. A bathroom break means we're probably not going to call any witnesses. We're not going to call Mr. Woods to testify and say I drank everything right after the cops showed up. No judgment of acquittal motion. I don't think. I guess you could preserve it for the record, but see, this was the court last time where we had a successful argument of a JOA. Dropped half the charges. Never seen a JO in a case like this. I wouldn't feel bad if she didn't ask for it, right? She's got some solid grounds for appeal, or some areas that are ripe for appeal, like if there's a conviction, specifically regarding how the discovery and the certification and everything went down. I think she's got some good work, groundwork laid there that's preserved. A JOA here, there has been evidence, direct evidence on every element presented. And we watched it on video. We've seen it 6 different ways. We heard it in testimony, watched it on the video. I'm okay with no JOA. Laura, the quick rundown on this. Up here in Washington, Mr. Woods was up on the side of the road changing a tire. He had pulled over to change a blown out tire, and the cops rolled up behind him. I'm like, hey, careful. You're right next to traffic here on this exit ramp. And he says, well, I don't have a problem with that if you don't, or something similar like that. And they're like, oh, how's your beverage consumption been tonight, sir? And he's like, well, I had a couple, and it went south from there. It went south. They ended up taking him to custody. He said some words that he now regrets, which YouTube doesn't like us to play. A couple hours later, in custody, blood draw, it comes back as 0.21. 9 months later, it comes back as 0.21. The cops say that's sufficient evidence to charge for DUI, because 3 hours after we had contact with you, it's reasonable to assume that you drove your car there and you drove it drunk, even though it was not crashed. It was parked correctly off the side of the road, carefully. There was a tire that was blown out, but that's not a sign of a drunk driver necessarily. And so we now have 3 officers who have testified, or 2 officers and 1 lab tech guy, scientist, forensic scientist, or whatever he is, that have all testified that basically are saying that he was drunk and that he was guilty. So he's charged with DUI and obstructing justice, obstructing an officer in the performance of his duties. And there's a good chance he'll be guilty on both of those, because the state's presented evidence, some pretty strong evidence. We'll see what the defense closing argument is, or if defense testifies at all, because he could still take the stand and say, I hadn't had a drop to drink until I was sitting on the side of the road for 2 hours with this blown out tire, Waited for AAA and they never showed up. I'm like, screw it, I'm going to do it myself. Got out the tire, tried to take it off, and it was just frustrating. I'm like, this is just terrible. Got out my bag of unopened alcohol and downed all of it. Then started working on the tire again, and the cops showed up. I didn't drive drunk. I was sober. I think that's the only defense that might work, or some version of that. The judge has said this is going to be a one-day trial, which means we expect the verdict tonight, probably around 9 p.m. I have to finish my goldfish crackers, sorry. Are we sticking with this until 9 p.m.? Great question. The only food I have in this room is goldfish crackers right now. And water. This has been an interesting case because the prosecutor, you see sitting at the table there with the one with the tissues, that's Mr. Holcomb. We saw him when he was just a baby lawyer, and that seems like it was just yesterday because it practically was. But here in Thurston County, the fresh starts, the young lawyers, end up practicing law in this court. And once they have one or two under their belt, they become a seasoned lawyer, as Mr. Holcomb has. We watched when he had his first day in court, and his dad was there to watch him try his first trial. I think he lost that one. Not sure. I think he's lost a couple. But he has interesting arguments, not necessarily well-rooted in law, like objection, Your Honor, he's not a legislator. That's not an objection I've heard before. He also made objections early on in the motions in limine. He made a motion. He said his motion was to move that the defense not be able to ask questions of the jurors. That's not how it works. So you always get just strange stuff there. Thurston County on Gilligan's Island. It's got to be somewhere strange. Has some weird stuff. Ryan Apple Snapple, good to have you here, man. How are things going? Let's see. We have to ask Bree Roz for a summary with emojis. Oh, Bree, can you put that together? I know those take work. In Thurston, for a case to go to jury trial, there are odd facts to the case. Yes, there are always odd facts. Odd fact here, right before trial, jury had been impaneled. We're sitting here waiting for them to come in. They've already heard the opening statements. And the prosecutor comes in and says this morning, so we've made an offer of a plea deal to the defendant this morning, just a fresh one. I got a new deal for him. And so if he wants to take that, then, obviously that would mean no trial. And if he doesn't, Judge, we might need to talk about something, an issue that's come up. Well, that raises the red flag in the defense mind, and they're like, hey, prosecution has an issue, and they're offering a plea deal to try to save face. Don't take the deal. They didn't take the deal. The issue was, here in the state of Washington, we're required to show that blood work, a blood draw for a DUI, was done by a licensed phlebotomist. It's like Dracula, but a profession. A licensed phlebotomist. And we just noticed in the file last night that we don't have the phlebotomist license. And we did some digging, and we have her current license. She's licensed right now, but it wasn't renewed till after this draw was. And we found her old license, but in the middle, and it's not reasonable to assume that she wasn't licensed. But we did some digging, some extra digging, and my staff has found, and they're getting me a copy. I don't have it yet, but they're bringing it to me. they found in another case file a copy of her license that would cover the time period when this blood draw took place. This almost, I say almost, I think it should have. This issue should have got the blood draw thrown out of this trial. But it didn't. The judge recognized the license, said that satisfies my curiosity as to whether or not this meets the legal standard to admit this as evidence. And yes, although it's a discovery violation of the day of court with a seated jury, it really doesn't change anything for you. So we're just going ahead. So, yeah. Emoji summary right here. It's Law of Life. Get some rest. Good to have you here. Thank you very much. He also did not say he'd shoot if he wasn't cuffed. Yes, if I didn't have these handcuffs on, I'd pop y'all. Prosecutor asked that point blank to the officer who did the arrest. And he said, no, that's not what he said. Nope, didn't happen. Okay, he says, and he just goes on. Okay. All right. Good night, Edith. Thanks for being here. Glad to see you in green. All right. We're waiting for the judge to... It's been about 5 minutes. I think we should bring everyone in now. Here's what I think is going to happen going forward. I think the defense is going to rest. I think they're going to say the burden is on the state and they haven't proven it. We're going to rest and we're going to have closing arguments, which will be maybe 10 minutes, 10, 15 minutes each. Probably defense take less than that. The prosecutor will probably take most of his. And then it goes to verdict watch, and we're going to be here for 45 minutes, is my call. 45 minutes. Sherry and Max, this is a nice calm day. Tomorrow it gets stressful again as we go back to the sentencing phase in that trial out of Florida. It's a death penalty trial, so the jury is going to decide if, now that they've convicted the defendant of 2 counts of first-degree murder, if he should be recommended for the death penalty. So it gets heavy again tomorrow. Red pen, here's my emoji summary. Okay. Car, pop, pin, pop, drink, 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 cops, blood, Dracula, newspaper. The time goes by. Nothing happens. There's the judge.
Good to discuss jury instructions.
Yes.
All right. So,
I mean, I've been looking at them. They look standard. I don't think I have any issues with them.
Okay.
are we on the record?
We're on
Okay,
the record.
we're back on the record. Ms. Moore has indicated the defense will formally rest when we bring the jury in, but while we're waiting, since they are out, we will review jury instructions. Defense is not submitted to me. They have reviewed the state's instructions, and I'll review I've reviewed the instructions, and I will finish numbering them and discuss those with counsel.
So at this time, Your Honor, I would be requesting just 2 additional minutes for closing arguments for both sides. And the reason for that being this involves both a refusal as well as 0.15 special verdict forms. So given those are an added...
You'll each have 17 minutes.
Understood. Thank you, Your Honor.
How much time do you want to reserve?
3 minutes.
Ryan, sorry, I did miss your previous text. just tried to reply. Thanks for the comments about the beard. I like it, but I'm about ready to shave it off. Like any day now, it could
instruction
happen.
number 2 is the reasonable doubt instruction. Number 3 is direct circumstantial. Instruction number 4 is the to convict on the driving under the influence of intoxicants. Instruction number 5, definition of under the influence or affected by. Instruction number 6, determining the accuracy or reliability of breath tests.
Does it say breath or blood?
Sorry, can the court back up a second? So number 4 is the to convict on the DUI over 0.08.
To convict, and it has both affected by and 0.08.
Oh, yes, it does.
And the instruction submitted by the state says breath test.
Can that be changed to blood test?
Can you change it?
Yes, I can.
Amy, Andrew will send you a new instruction here shortly. Make sure it's not a cited instruction.
Yes, and you just want me to send that. Huh?
Take out breath, put in the word blood.
Yes, and just send that instruction, correct?
Correct.
Printed out copy I have has blood.
One I have has breath.
Okay.
It may have been paint and cited versus uncited, maybe. I don't know. All right, I'll fix it.
To convict instruction properly has blood.
Okay.
Oh, okay. I see the one that Court and Mr. Holcomb are looking at, not the to convict instruction. It's the.
Yes, I'll send this over.
Okay, with the anticipation that they're going to rest, I've got a poll together. We're going to ask, is the defendant guilty of DUI and obstructing? I have 4 answers that should pretty much cover all the bases. Please read carefully.
I am.
Please read carefully before you
Reading
vote.
that document now, and I shall send it over to Madam Clerk as well as to Defense Counsel now.
I will note, though, that the to convict instruction I have for obstruction says City of Tumwater instead of Thurston County.
Oops.
Okay. Change that as well.
And it was a county thing, not Tumwater. It's not
Yes,
city.
indeed. Thank you, Ms. Moore.
Ms. Moore, you get an extra gold star on your paper. Thank you.
Yep, there it is. I will make that in the same document.
I know Mr. Pezderka and I are easily confused.
So now it says that any of these acts occurred in the county of Thurston, Washington.
And have you sent those documents to Amy?
I just finished correcting the error that Ms. Moore identified, so I am sending those over now.
Can you print those up, please? And 3 copies. 1 for me, 1 for Andrew, and 1 for Captain. Yes.
Sent them over.
Okay, thank you. So the instruction on determining reliability of a blood test is number 6. The to convict instruction on obstruction is number 7. Number 8 is the definition of willful. Number 9 is the definition of knowledge. Number 10 is the expert witness instruction. Number 11, the separate crime charge in each count. Number 12 is defendant not required to testify. Instruction 13 is duty of the jurors. Instruction 14 is the closing instruction.
Are you gonna print off the rest of them too?
What was that?
Are you gonna print off the rest of them too?
Oh, yeah. So, do you want me to print all of them right now?
No, I want them to have followed me, written their own numbers on there, but if they didn't do that, then you can print them up in this way.
I would deeply appreciate a printed off copy. I'm sorry.
You owe Amy then.
I do. It won't be far from the first time.
I have been trying, Your Honor. Mine were ordered in my binder in a different order, so I've been kind of flopping paper around, trying to find the version of each number.
So print one off for her too.
Yeah, the whole that I give you here in just a moment.
Oh.
So let's wait for the printer to do its thing. Just found what might be a deal killer on this encoder. Does 6 different streams at the same time, but it only does 4K at 30 frames per second, not 60 frames per second. Is that an issue? I think that might be okay still. Yes, we need to change the toner, run a test sheet, align the print heads, and then print these documents again. No, I think it's worth it to get multiple streams. Take 30 frames per second. As they should, Northwest. Washington should take speedy trial rights very seriously. Stacy. Tell you what, I'll get it ready. That's all I can do. I've got it queued up.
For the record, the state did submit 2 instructions, which are the definitions of the crime of obstructing, the crime of driving under the influence. I don't give those because they're redundant with the 2 convict instructions. It has the exact same information. So
that takes away one of my laugh lines.
you're not going to laugh at my expense, Mr. Holcomb. And since it's the state that almost always is the provider of the jury instructions, I'll point out that, I think this is my 33rd year doing jury instructions.
Wow.
And I use the same numbering sequence for 33 years. And the state keeps giving me their own numbering sequence. And so their counsel is in a difficult place because the instructions, the way you have them, are not the way I have them. Now, perhaps my colleagues number them differently. I don't know if they do or not because I've never looked at the jury instructions. If you want to take back the copy of the jury instructions to use for your staff when they're preparing them for your trials with me, feel free.
Yes, please number. Please use
that way, then you don't have
system.
You don't have to burn a whole bunch of more pages. You have them already in the order.
Yeah. The issue with me implementing that very well-founded suggestion is I don't typically find out who my judge is until I walk through the door.
Right.
So I can technically find out earlier, but I also
you have more important things to do, I guess.
I prefer the surprise.
I underestimated yesterday, Your Honor, when I said that you'd been hearing cases since Mr. Holcomb and I were both toddlers.
Yeah, I sat there like
underestimation.
I sat there and I was like,
it's been longer than that.
They're both in their 20s. They are baby lawyers. Wow. The judge looks like he would wear a cardigan and say, "It's a beautiful day in the neighborhood. Hi, neighbor." Yeah. Tossing his shoes across. Here comes trolley. He's been practicing for 5 more years than I've been alive, says Laura. And he's used the same numbering system this whole time. So if it ain't broke, don't fix it. Won't you be mine? I tried that. It didn't work. Yeah, you guys remember the trolley, right? "30 years on the bench, and he still has a cheap office chair." I think he has the same chair I have. I think he does. It's a very similar one. Daniel Tiger, the OG, not the new one. Yes. It's going way back. The creepy puppets. Okay, print it off already, ma'am. Amy, get that thing humming. The king had a scary face. Okay, but Daniel Tiger's home had tiger skin curtains. How do you explain that to the kids? I like Bob Ross more than Mr. Rogers. Happy little trees. Happy little trees. No such thing as an accident. Well, happy little accidents, I guess. Dot matrix printers were the best. The sound they made was amazing. I love them. I can't even do it. It's been so many years. And plus, if you're going back to dot matrix, you have to go back to the green bar paper with the punch fed. That's the real stuff. All right.
Keep them here much beyond 5:30. So don't be surprised if I send them home at 5:30 and have them come back tomorrow morning, even though I suspect we have a jury trial. I don't know that with any certainty, but I know we have cases scheduled, whether they're going or not. And I think you have a case with Mr. Smith. Am I right?
I think I sure do, Your Honor. So Mr. Holcomb and I will be here regardless.
Mr. Smith is the one who had one of his cases thrown out.
If we continue tonight, you'll need to come back tomorrow morning. If the jury doesn't have a verdict, we depart at 5:30.
There tomorrow morning is our lunch. Teresa, the fun thing about the punch feed paper, if it was perforated to tear the edges off, you could tear off like several sheets of paper, and then you take 2 of the strips and overlap them and fold them over each other, and you could make these big long springs, which are not useful for anything, but they're fun. His judge is going back on his word. It's a cheap chair. Look at that. You can see right through it. That's not back support. It's a screen from back door. Christmas decorations. Yes. Does the jury get Chick-fil-A? No, well, they're too cheap in Washington. Look, they couldn't even rent an actual room to hold court. They've got the hotel lobby. is the cheapest judge's chair we've ever seen. We've seen some good ones. There are a couple chairs. Judge Dad has a nice chair, but the back of it is just hammered. It's torn up. Probably from every time he jumps up out of his chair and sort of slams it into the desk as he storms out of the room. But see, I'm Captain Kangaroo, Grandfather Clock, and Mr. Green Jeans old. Anybody else? I haven't let them touch it yet.
Were the 2 instructions we were given, are those included in the copies that were printed off, or should we add these in?
Well, what the jurors are going to get is the exact one that I have.
Okay.
Stephanie
Hopefully
Barnes.
amended instructions.
Did they ever locate Mr. Farag? Thank you for all they do. No, this court is still looking for Mr. Farag. He went missing during lunch, during his one-day trial, and he has yet to show up. He's gone underground. It's gone dark. The courtroom looks more dispiriting than my high school, which was a converted office building. Oh. Howdy doody and Clarabelle. Results of the poll. Poll's still up right now. If you haven't voted on whether or not you think the defendant is guilty, now would be the time to do it. Because once the poll is over, it's too late. So let me just check. We've got only 153 of you have voted, 154 now. There are 550 of you watching, or at least 550 of you logged into the channel and forgot to turn it off. As the case may be with this case, as it drags on a little bit. I understand. I feel your pain. Let's see. You guys are listing things I just don't know. I don't even know what this is a reference to. It could be something awful, but I just don't know. Our detention class was nicer in high school. My in-school suspension classroom was, I think, a converted janitor's closet. It was all the way at the far end of one wing of the school. So if you had one period where you had to be in school suspension, which I occasionally had to do because of my escapades in college, in high school, it would automatically just make you late to your next class, which would then get you sent back to in-school suspension. So. Camilla. As long as he didn't put the small one on the bottom, that's a win. We were out of town Saturday and Sunday, and Saturday morning, right after we left, I got notification that a package containing my son's shoes arrived. And my son requires very special shoes because he does Ninja Warrior stuff, and they require. You can't have those cheap foam sole shoes. So he had these really nice shoes that were shipped literally just in the shoebox. So you could just see the brand of the shoes sitting there with the label on it. And luckily, they did not get stolen, as we've never had a single package stolen off our porch that we know of. And they were they put them behind a little pillar, so they hid them. We were able to find them when we came back 2 days later. High school had 4,400 students. Man, my graduating class was probably like 650, maybe 700, I think. Oh, he put one in front of the other? That's funny. at this point? It's late. It's 6:30. What?
Just to make sure, I believe all of the admitted documents and evidence is there, correct?
Should be. There are 5 exhibits outside of the flash drives that are going to the jury. Yes, they're all here.
Excellent. Thank you.
Yes.
I don't know what we're waiting for. Here's what I'm going to try to do. We're going to stick around for the closing arguments and then record, Kelly. I'm going to try to record the verdict, and we'll play that first thing in the morning before our case starts. Does that work? If there is one. There might not be one. Printer hasn't warmed up yet. Soon. It's getting there. Give it a minute. My Amazon is delivered at different doors, if it's mine or my husband's work. I get FedEx at the back door and Amazon at the front. I don't know why that is, but it's just always been that way.
Ms. Moore, any testimony?
Your Honor, the defense, yes.
All right, thank you. All right, folks, the defense is rested.
And in the poll.
Actually, we knew that. That's why you now have in your hands the jury instructions on the law. That's what took so long. Ms. Moore had indicated to me that she was going to rest. So we then went through all the jury instructions. You now have them. So there's going to be no further testimony. You've heard all the testimony in this case. And I'm now going to instruct you on the law that you're to apply in deciding the case. That's contained in those instructions that each of you have. I'm going to read them, and you will be able to take your copies of the instructions with you back into the deliberation room. So you're welcome to just sit there and listen, or you can read along with me as I read. That's up to you. It is your duty to decide the facts in this case based upon the evidence presented to you during trial. It is also your duty to accept the law from these instructions, regardless of what you personally believe the law is or what you think it should be. You must apply the law from these instructions to the facts that you decide have been proved, and in this way, decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during deliberations consists of the testimony that you've heard from the witnesses, stipulations, and the 8 exhibits that have been admitted during trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the clerk and given a number, but they do not go with you to the jury room during deliberations unless they have been admitted into evidence. And as I told you early on, that will be the case for the flash drives. They do not go with you for continuing review in the deliberation room. See them, and that was your opportunity to see them. The exhibits that have been admitted, the written documents, will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during deliberations about the reasons for my rulings on the evidence. If I've ruled that any evidence is inadmissible, or if I've asked you to disregard any evidence, then you must not discuss that evidence during deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that has been admitted that relates to the proposition. Each party is entitled to the benefit of all of the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things. the opportunity of the witness to observe or know the things that he or she testifies about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statement in the context of all the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The attorney's remarks, statements, and arguments are intended to help you understand the evidence and to apply the law. It is important, however, for you to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in these instructions to you. You must disregard any remark, statement, or argument by counsel that is not supported by the evidence or the law as stated in these instructions. You may have heard objections made by counsel during trial. Each party has the right to object to questions asked by another attorney and may in fact have a duty to do so. These objections should not influence you. Do not make any assumption or draw any conclusion based on the objection of counsel. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express by word or conduct my personal opinion about the value of testimony or other evidence. I have not intentionally done this. If it appears to you that I have indicated my personal opinion in any way, either during trial or in giving these instructions, you must disregard this entirely. You have nothing whatever to do with any punishment that may be imposed in case of a violation of the law. But you may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the attorneys may properly discuss specific instructions. During deliberations, you must consider the instructions as a whole. As jurors, you are officers of the court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. The defendant, Mr. Woods, has entered a plea of not guilty as to each count. That plea puts in issue every element of the crimes charged. The state is the plaintiff and has the burden of proving each element of each crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists as to these elements. A defendant is presumed innocent. This presumption continues throughout the entire trial, unless during your deliberations you find that it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all the evidence. If from such consideration you have an abiding belief in the truth of the charge and you're satisfied beyond a reasonable doubt. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in the case. One is not necessarily more or less valuable than the other. To convict the defendant of the crime of driving under the influence, each of the following three elements of the crime must be proved beyond a reasonable doubt. Number one, that on or about November 30th, 2023, the defendant drove a motor vehicle 2, that the defendant at the time of driving a motor vehicle, A, was under the influence of or affected by intoxicating liquor, or B, had sufficient alcohol in his body to have an alcohol concentration of 0.08 or higher within 2 hours after driving, as shown by an accurate and reliable test of the defendant's blood. And 3, that this act occurred in the state of Washington, county of Thurston. If you find that the evidence has proven the elements 1 and 3 and alternative elements 2A or 2B beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. To return a verdict of guilty, the jury need not be unanimous as to which alternative, 2A or 2B, has been proved beyond a reasonable doubt, as long as each juror finds that at least one alternative has been proved beyond a reasonable doubt. On the other hand, if after weighing all of the evidence you have a reasonable doubt as to any of the elements, 1, 2, or 3, then it will be your duty to return a verdict of not guilty. A person is under the influence of or affected by the use of intoxicating liquor if the person's ability to drive a motor vehicle is lessened in any appreciable degree. It is not unlawful for a person to consume intoxicating liquor and drive a motor vehicle. The law recognizes a person may have consumed intoxicating liquor and yet not be under the influence of it. In determining the accuracy and reliability of a blood test, you may consider the testing procedures used, the reliability and functioning of the testing instrument, maintenance procedures applied to a testing instrument, and any other factors that bear on the accuracy and reliability of the test. To convict the defendant of the crime of obstructing a law enforcement officer, each of the following elements of the crime must be proved beyond a reasonable doubt. 1, that on or about November 30th, 2023, the defendant willfully hindered, delayed, or obstructed a law enforcement officer in the discharge of the law enforcement officer's official powers or duties. 2, that the defendant knew that the law enforcement officer was discharging official duties at the time. And 3, that the acts occurred in the county of Thurston, state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if, after weighing all of the evidence, you have a reasonable doubt as to any of the elements, then it will be your duty to return a verdict of not guilty. Willfully means to purposefully act with knowledge that this action will hinder, delay, or obstruct a law enforcement officer in the discharge of the officer's official duties. A person knows or acts knowingly when he is aware of the fact, circumstance, or result. It is not necessary that the person know that the fact, circumstance, or result is defined by law as being unlawful or an element of a crime. If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted, but not required, to find that he or she acted with knowledge of the fact. When acting knowingly as to a particular fact is required to establish an element of a crime, the element is also established if a person acts intentionally as to that fact. A witness who has special training, education, or experience may be allowed to express an opinion in addition to giving testimony as to facts. You are not, however, required to accept his or her opinion. To determine the credibility and weight to be given to this type of evidence, you may consider, among other things, the education, training, experience, knowledge, and ability of the witness. You may also consider the reasons given for the opinion and the sources of his or her information, as well as considering the factors already given to you for evaluating the testimony of any other witness. A separate crime is charged in each count. You must decide each count separately. Your verdict on one count should not control your verdict on any other count. The defendant is not required to testify. You may not use the fact that the defendant has not testified to infer guilt or to prejudice him in any way. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence in these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors. Nor should you change your mind just for the purpose of reaching a verdict. When you begin deliberations, you should first select one of you to act as presiding juror.
It's almost done.
The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 6 of you are present. You are all officers of the court and must evaluate the evidence with an open mind, free of bias or prejudice. If during deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During deliberations, you may discuss any notes that you've taken during trial, if you wish. You've been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories and notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during deliberations. If, after carefully reviewing the evidence and instructions, you feel a need to ask the court a legal or procedural question that you've been unable to answer, write the question out simply and clearly. And you may use the notepads that you have. In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to Amy. I will confer with the attorneys to discuss what response, if any, may be given. You will be given the 5 documents that have been admitted as evidence, these instructions and verdict forms for recording your verdicts. Some exhibits, including the flash drives and some of the exhibits that were not admitted, may have been used in court but will not go with you to the jury room. The 5 exhibits that have been admitted into evidence will be available to you in the jury room. You must fill in the blank provided in the verdict form, the words "not guilty" or the word "guilty," according to the decision you reach. Since this is a criminal case, all 6 of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict form to express your decision. The presiding juror must sign the verdict form and notify the clerk, and Amy will then bring you into court to declare your verdict. You will also be given special verdict forms for the crime of driving under the influence of intoxicants. If you find the defendant not guilty of driving under the influence, do not use the special verdict forms. If you find the defendant guilty of driving under the influence, you will then use the corresponding special verdict forms and fill in the blank with the answer yes or no, according to the decision you reach. In order to answer a special verdict form yes, you must unanimously be satisfied beyond a reasonable doubt that yes is the correct answer. If you unanimously agree that the answer is no, you must fill in the blank with the answer no. If, after full and fair consideration of the evidence, you are not in agreement as to the answer, then do not fill in the blank for that question. Members of the jury, if you please give your attention to Mr. Holcomb for his closing argument. Mr. Holcomb.
Thank you, Your Honor. I'm just going to adjust the podium and get my timepiece ready.
He goes off the screen. His timepiece.
Okay. You know the drill from openings. I'm not texting anybody, just making sure that I'm muted and getting my timepiece set to go. All right. Once again, I just want to thank you all for being here. The system only works when jurors like yourself show up and pay attention throughout the trial. And I really appreciate all the attention that you've shown to this case and for returning today. So I appreciate you being a part of the process. So we're at the part of the trial where we've heard all of the testimony. And I said earlier in the opening that we're at the part where I tie all of the evidence to the elements of the crime. This is the first time you've seen the elements before. I don't believe anyone here is an attorney or has looked at jury instructions before. So you're looking at them cold. So my goal is to go through those and match the evidence up with those so that I can show that the state has met its burden to prove each element of the crimes beyond a reasonable doubt. So first, we're going to look at really just the defendant's standpoint in this case, which I think was demonstrated over the videos. You didn't see it, it didn't happen. Basically, the common line throughout the videos and arguments that's been made by defense is essentially officers did not see the defendant driving, therefore, no crime. I think earlier we talked about the idea of circumstantial evidence. That's the snow outside. Did you see the snowfall? I gave an example earlier where you're in an apartment, you look outside and there's snow all over the ground. And pretty much everyone agreed that it snowed outside. We had some creative answers, but we just knew it snowed outside. You didn't see the snowfall outside. You didn't have video of the snowfall outside. You didn't have a weather report, et cetera, but you knew it snowed outside. Why? Because you saw the result. You saw the result of what happened. That is circumstantial evidence. And there is common belief that circumstantial evidence isn't as good as direct evidence. So let's address that right at the top. So if you go to instruction number 3, it talks about circumstantial versus direct evidence. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in the case. Direct evidence directly precedes something at issue in the case. We don't have direct evidence of driving here. None of the officers saw the vehicle driving. It was parked on the side of the road. But what we do have is circumstantial, which refers to evidence from which, based on your common sense and experience, you may reasonably infer that something that is at issue in this case. And then it specifically says the law does not distinguish between direct and circumstantial evidence. So what does that mean? It means that if you have sufficient circumstantial evidence, direct evidence is not required, because you don't have to have direct evidence. Circumstantial evidence is just as good as direct evidence. So what is the circumstantial evidence that we have here for the crimes alleged? So the two crimes alleged in this case are driving under the influence and obstruction of a law enforcement officer in their official duties. So firstly, let's go to the charge of DUI. So if you go to instruction number 4, this lists out the elements of the crime of DUI. So elements are the building block of the charge. I have to prove each one of these elements beyond a reasonable doubt. If I don't do that for any one of these 3, then the verdict is not guilty. But if the state is able to prove each of these elements beyond a reasonable doubt, then the result is guilty. The instructions specifically say that it will be your duty in that scenario to give a verdict of guilty. So let's go through the elements. So first, that on or about November 30th, 2023, the defendant drove a motor vehicle. There is no dispute that that is what happened in this case. There is no dispute that this happened on November 30th of 2023. Both of the officers said, yes, it happened on November 30th of 2023. The defendant said that he drove a motor vehicle. The defendant had keys on his person. The vehicle is registered to him. There were no other all of the seats in the car were covered with items, making it impossible for anyone else to be in the vehicle other than the driver. So, and again, the defendant multiple times on camera says that he was driving. So that element has been met, and in fact is not in contention. So number two is the complex one. So we're going to come back to number 2. Number 3, that this act occurred in the state of Washington, Thurston County. This element is in both of the charges. I have to prove both of these happened in Thurston County. I also have to prove that both of these charges happened on the date. Again, this is not in question. The trooper Murray specifically said that his job requires him to know about the boundaries of Thurston County, and he said this did happen in Thurston County, and he gave us a location which is located in Thurston County. So that is met. Now let's go to number 2. That the defendant was under the influence of or affected by intoxicating liquor. For this piece of instruction, and it is important that there's an or in the middle of number 2. After letter A, we have or had sufficient alcohol in his body to have a alcohol concentration of 0.08 or higher within 2 hours of driving, as shown by an accurate and reliable test of the defendant's blood. So let's just go to affected by first. If you turn to instruction number 5, it tells you what it means to be affected by. A person is under the influence or affected by the use of intoxicating liquor if the person's ability to drive a motor vehicle is lessened to any appreciable degree. Any appreciable degree. That means it's noticeable. It's like you can tell that alcohol affected this person's ability to drive, but we did not see the driving. So we don't have any direct evidence of driving. Aha, says defense. But actually what we have here is circumstantial evidence that he was impaired. Why? Because if you can't stand straight, if you can't see straight, if you can't express your words clearly, if you are falling over yourself, if you're cursing at law enforcement, you're under the influence of alcohol. And if you're under the influence of alcohol, that's going to affect your ability to exercise fine motor skills. The toxicologist specifically talked about fine motor skills. One of those is maintaining balance. Essentially what I say to you is that if you can't stand straight, you probably can't drive straight. So what we have here is an appreciable degree. Do we have enough evidence beyond a reasonable doubt that if you put that person behind the wheel of a car, that would appreciably affect their driving? If it does, then that element is met. And then it specifically says it is not lawful for a person to consume intoxicating liquor and drive a motor vehicle. The law recognizes that a person may have consumed intoxicating liquor and yet not been under the influence of it. So what that means is consumption by itself isn't enough. You can't just have evidence of consumption, but we have evidence of both consumption and of impairment. The evidence of consumption is that he told us that he drank alcohol, his breath smells of alcohol. The evidence of impairment is all the things that I described earlier. The fact that he had difficulty maintaining his balance, the fact that he kept walking into the middle of a busy exit off the I-5. He had to be told 2 or 3 separate times by law enforcement telling him, hey, you're standing in the middle of the exit. Hey, those vehicles take this exit at 80 miles per hour. Hey, you should probably get out of the exit. That was said multiple times to the defendant, yet he continued to wander into the exit lane. So we have evidence of affected by here, especially to the point of any appreciable degree. So let's go down to the issue of the per se limit here. And this is where the toxicologist comes in. This is where the blood draw comes in. And there was an important question that was asked by one of the jurors talking about, hey, what is the effect of the time? Because we do have quite a bit of time between the blood draw and the initial encounter of law enforcement. So what do we know? We know that law enforcement encountered the defendant at roughly, I believe it was 6 or 7 o'clock. We know there was a 3-hour gap between the initial encounter and when the blood was drawn. So we know there was the gap there. And we know that the defendant was in custody the entire time between the time he was encountered on the side of the street to the blood draw room. He was in law enforcement's hands the entire time. What does that mean? It means he didn't consume alcohol between the time of the encounter and the time of the blood draw 3 hours later. And the toxicologist said, we know to a scientific reasonable degree of certainty that the blood alcohol level that was in the blood sample taken 3 hours later would be lower than the one at the initial encounter. And we also know this from common sense. The instructions specifically talk about common sense. Do not remove your own experience. What happens when someone consumes alcohol and waits for a period of time? What happens? They become progressively less impaired, meaning the BAC becomes progressively lower. So if anything, if there's anything about the accuracy of the blood draw that is off, it is to the defendant's favor because it is lower than what the BAC was at the time the defendant was pulled over. So the BAC limit here is met. There's a special instruction specifically in the jury form that talks about above 0.15. This element says 0.08. There's another special instruction that says 0.15. And I specifically talked to the toxicologist. Okay, what's the plus minus sign on the toxicology sheet here? He said that's the error ratio. And he said that the error ratio was 1 of 2. And the BAC in this case was a 0.21. So what that means is if we give the benefit of the doubt to the defendant, the lowest BAC possible from the toxicology result would be a 0.19, which is well above 0.15. And again, that result is lower than it actually was at the time the defendant was pulled over. So we have that. We have elements 1, we have the date, we have element 3. Yes.
Objection, misstatement of facts. He wasn't pulled over.
Thank you.
At the time of the stop. Okay, so we have elements 1, we have elements 2, and we have elements 3. This happened in Thurston County. This happened on this date. The defendant was clearly affected by intoxication, and he also clearly had a BAC that was above 0.08 and, in fact, above 0.15 as well. So those elements are met. There's also a special jury instruction that talks about refusal. The Trooper Murray explicitly said, yep, the first half of this was getting him into the BAC instrument room. I got him in the room. I asked him if he was willing to provide a BAC sample, and he refused. So we have a trooper under penalty of perjury saying, yep, this is what happened. And frankly, we don't really have to take his word for it. We have video of how he was acting throughout the night, taken from different time periods in the night. That video is not of someone who is willingly going to provide a breath sample at the room. And Trooper Murray's testimony under oath, both in this courtroom and on the sheet that he filled out, which has been presented today, both indicate that the defendant refused to provide a breath sample, which is what necessitated the blood draw. Now we're going to the issue of obstruction. So if we turn to obstruction, that is instruction number 7. So number 1, date. The defendant willfully hindered, delayed, or obstructed law enforcement officers in the discharge of the law enforcement officer's official powers or duties. There was a phrase that really stuck out to me in the video. It was at the very beginning of the third video. The defendant said, "Round 2, huh?" And then the officer was like, "Well, hopefully not." And the defendant talked about how the fact that he had to get put on the ground, law enforcement, both Travis and Murray talked about how the defendant multiple times physically moved his body and said things that impeded the investigation. They had to completely change their plan as to where they were going to ask him for the breath sample because he was being so disruptive that they believed they needed backup to de-escalate the situation. So from that point on, and we see video footage of them making threats at law enforcement, we have testimony that he physically moved against them, but for them taking corrective action, they would not have been able to successfully conclude this investigation. The officer also indicated that this took a much longer time than it normally does. He said a blood draw with similar facts such as these, absent the defendant's behavior, takes roughly 1 to 2 hours. In this case, it took over 3 hours. So we know that that hour of added time was largely due to the defendant's obstructive behavior. So moving down to number 2, the defendant knew that law enforcement was discharging official duties at the time. They're in full uniform. They're in patrol vehicles. You know this is an officer. You know that you're under arrest, and you know that you're going through the process of the DUI arrest. So he knew they were discharging their official duties, and again, that this happened in the county of Thurston. There's no dispute as to that. So
1 minute, you move into your 3-minute reserve.
Thank you, Your Honor. So then we're going to the instruction of willful and knowledge. If you go to knowledge, it specifically talks about a reasonable person. So we weren't in the defendant's head. So the question is, a reasonable person in the defendant's shoes, when he was acting in that manner, would that person know that they were impeding the investigation? Was it willful? If you go to instruction number 8, it says in order to act willfully, you have to have knowledge or reason to have knowledge in order for it to be willful. So we have willful obstruction here of the law enforcement and their official duties. We also have all the elements for DUI. Those are also met here. So the state would ask you to find the defendant guilty on both counts, as well as to fill out the answer yes on both the DUI refusal, the BAC refusal, as well as the BAC being over 0.15. Thank you.
You have 3 minutes left in your time. Ms. Moore.
Stalling does not help any. The timer has started. Here we go.
It is not illegal to swear. It is not illegal to swear at a cop. It is not illegal to yell at a cop, and it is not illegal to call a cop stupid. Among the evidence you've received from both the state and the defense, the state has presented a lot of evidence in video form and in testimony about how Mr. Woods talked to law enforcement after he was in custody on November 30th, 2023. I want to get out the gate here by saying I am not asking you to like that behavior or to agree with anything that Mr. Woods said to Trooper Murray on video and on audio. You don't have to like it, agree with it, or even forgive those words in order to find him not guilty today. Mr. Woods is charged with obstructing law enforcement. Mr. Woods is charged with DUI. You are charged with considering the evidence and the law. What Mr. Holcomb has said is not evidence. What I say right now is not evidence. The evidence is what you have seen and heard from law enforcement, from the toxicologist, Mr. McDougall, and from Mr. Woods himself on video. What Mr. Holcomb and I say isn't the law either. The law is what you've been instructed on by Judge Buckley. I want to focus on those instructions as well. I want to go through them with you and show you, in contrast, why you must deliver a verdict of not guilty. To convict Mr. Woods of obstruction of a law enforcement officer, you would have to find that the state has proven beyond a reasonable doubt that Mr. Woods willfully hindered, delayed, or obstructed law enforcement in the course of their duties. The state's told you, Trooper Murray's testified, that Mr. Woods' behavior was a factor in the length of time this investigation took. But you also heard from Trooper Murray that changing course from LPD to TCCF was a choice he made because he wanted more law enforcement presence. More law enforcement presence to restrain a man who was already upset to be in custody with any law enforcement presence, who had every reason to fear them. Trooper Murray said that more law enforcement helps de-escalate sometimes, but clearly this was a situation where that was the wrong call. Trooper Murray said that the nearly 3-hour length of this investigation was unusual, but he also acknowledged that after the blood draw warrant was issued, it took 40 minutes before it was actually effectuated, before blood was actually drawn. That's a pretty big chunk of that 3-hour length of time, but it is not remotely Mr. Woods' fault. Trooper Cadet Travis, also said Mr. Woods was cooperative up to the point where he was arrested. She mostly described name calling. She said at one point she saw Mr. Woods move in a way that seemed like lunging towards Trooper Murray. Trooper Murray and the correctional officers at the Thurston County Jail intervened to prevent him. I want to highlight that again. 4, maybe 5 law enforcement officers in a room. 1 man in handcuffs who has the power in that situation. They were worried he might slip his cuffs, but Trooper Murray said that's happened once in his 5 years on the force. Was Mr. Woods' behavior admirable? Maybe not. But was his intent to hinder or delay? Or was he just a guy in custody for something he didn't do, sick of the system, subject to treatment by law enforcement that necessitated a use of force memo being filed, and afraid for his own safety? The state has not proven that Mr. Woods, while in custody, obstructed law enforcement beyond a reasonable doubt. But we also need to talk about what he was in custody for, the thing he didn't do in the first place. Let's talk about the DUI. To find Mr. Woods guilty of DUI, you would need to find that the state has proven beyond a reasonable doubt that he, first of all, was driving. That's the first element. It's the first element that the state has had an uphill battle to prove just to begin with. I told you yesterday, law enforcement had to make some big assumptions to make this charge make sense. Now we've heard from Trooper Murray and seen the video, and in context, it might make sense why in the heat of the moment he made those assumptions. The state is now asking you to follow those same assumptions to fill in the gaps. And the state's burden here is very different from Trooper Murray's burden when making an arrest. Law enforcement never saw Mr. Woods driving. We all agree on that. Trooper Murray thought the car was still warm, but he can't say how long it might take for a car to cool off. That was just sort of his sense. We didn't hear anything from Trooper Travis to suggest the car might have been recently driven. Even if we accept, though, that Mr. Woods was driving when the car came to be where it was, I want to bring you back to that video. That's a car that was parked cleanly and safely on the shoulder, especially considering it had a busted front tire. That's not a car that was parked by a drunk person, because at the time Mr. Woods parked it, he wasn't drunk. Trooper Murray doesn't think this could possibly be the case. He told us that he saw that exit maybe an hour before this encounter started. He doesn't think that car was there at the time. But he was on his way to a collision in another county, and he doesn't remember that collision or the circumstances. He didn't remember if his lights were on, if he was on the radio with dispatch, what lane he was even in to be able to see the off-ramp through traffic. You should consider the reliability of his memory there. He doesn't know. The car may have been there and he just missed it. Obviously, the car got to be where it was somehow. Mr. Woods acknowledged it was his car and that he was driving it when the tire popped. But law enforcement, Trooper Murray, made no attempt to ascertain when that was. He didn't ask a lot of follow-up questions, even at that point, as both law enforcement officers acknowledged Mr. Woods was perfectly cooperative. I think we saw that on video as well. He had no reason not to be because he wasn't doing anything wrong. It's not illegal to change a tire, even if you've had a few drinks. The second element you have to find the state has proven beyond a reasonable doubt, or that the second element the state wants you to find they've proven beyond a reasonable doubt, is that Mr. Woods was under the influence at the time that he was driving. And that's where the state has completely failed to meet its burden because it cannot. Here's what we know about the two ways that the state has offered you to try and find that. One, under the influence in general. We call it the affected by prong. That would require maybe the most assumptions of all, because there is, the state's offered you circumstantial evidence of Mr. Woods' physical condition at the time law enforcement arrived, but they didn't see him driving and they don't know when he was driving. We have no idea. There's no driving behavior to look at to suggest he was driving after he drank, or even badly. What does the state have? Again, the car's location and the assumption that if the car was there and he was there, then he was probably driving recently-ish, right? We don't know, but we can assume. But that isn't the state's burden. The state's burden is beyond a reasonable doubt. If anything, and there is room for reasonable doubt. If anything, again, the manner in which the car was parked relative to the road and the guardrail would be just as much evidence of a driver who wasn't impaired, who was driving safely. The other way the state's trying to bring this case is what we call the per se limit. To find Mr. Woods guilty under that prong, you would need to find that the state has proven beyond a reasonable doubt that Mr. Woods' blood alcohol content was over 0.08 within 2 hours of driving. And we don't have that at all. Let's talk about the timeline. Here's what we know. About 6:58, 7:04, so about 7 p.m., Mr. Woods was on the side of the road changing his tire. Not in the middle of the off-ramp, it should be said. On the side of the road, he was out of the way of traffic until law enforcement showed up and flanked him. You saw the video of that interaction and heard from Trooper Murray. That was about 7 p.m. Again, wasn't driving at 7 p.m., out of the car, turned off, in fact, nigh undrivable, given the state of the tire and that he was trying to change it. So then he's in custody. You heard from Trooper Murray. The blood draw warrant was signed at about 9:14 p.m. So about 2 hours-ish after the point when he was arrested, maybe a bit less than 2 hours after the point where the arrest actually occurred, which again was not because he was pulled over. He wasn't driving. It then takes Capitol Medical Center another 40 minutes, getting us to nearly 3 hours when the blood was taken. The state has presented to you that because of the way that alcohol works in the body, the state wants you to believe that means that it's sort of just a flat incline or a flat slope going down from a higher point. It means his BAC must have been higher than 0.21 when they stopped him, let alone when he was driving. But that's actually not what we got from Mr. McDougal. Mr. McDougal, you heard Mr. McDougal say it is more of an arc. When we have no idea when he was drinking, we don't know when he was driving. The state has not proven with evidence a nexus to connect those two separate aspects of this. And that's why they simply cannot meet the burden to show that he was actually driving under the influence.
JMS, you just got a gifted membership right before you gifted a super chat. Thank you so much.
There are 2 points in time where someone's blood alcohol level is at a level at a point in time. And there was another point in time 3 hours earlier. We have no idea if the alcohol was still building up in his system, and it might have been lower than the 0.21. There's so much that the state doesn't know. There's so much that you don't know. And a reasonable doubt I'll remind you, it's in the instructions, is a doubt for which a reason exists. And that reason can be evidence or lack of evidence. There is so much here that we don't know. And the state is asking you to fill in those gaps by making assumptions. I want you to really think about whether those assumptions are ones that you can reasonably make. I contend they're not. And I would put to you that because the state hasn't proven its case, and frankly, because Mr. Woods did not drive under the influence, you must deliver a verdict of not guilty on this charge as well. Thank you.
So she took less than 10 minutes.
And Mr. Wolfram, you have 3 minutes left in your time.
Thank you, Your Honor.
Sherry and Max, thank you for contributing to the overtime fund. We're winding down here.
Assumptions. It's an assumption that when you see snow all over the ground outside, that it snowed outside. This is what defense is contending here. I would submit to you that it is a reasonable inference. If you go to instruction number 3, it explicitly says the term circumstantial evidence refers to evidence from which, based on your common sense and your experience, you may reasonably infer something that is at issue in this case. What does that mean? It means you're not just being given information. You are to apply your common sense and your experience to that information to make reasonable inferences. If that process doesn't happen, then circumstantial evidence means nothing. If that process was not allowed here, then by definition, you couldn't use circumstantial evidence, because circumstantial evidence is the result of something. You're looking at the snow outside and you reasonably infer something you didn't see and that no one else saw that you talked to. All the information you have is you look outside and there's snow all over the ground outside. It's December, you look out there, that's enough. That's circumstantial evidence, reasonable.
Minute 20.
Doubt. All right, now let's go to reasonable doubt. And we're going to the end here. Instruction number 2, last paragraph. It says a reasonable doubt is one for which a reason exists that may arise from the evidence or lack of evidence. It is a doubt of which exists in the mind of a reasonable person after fully, fairly, and carefully considering all the evidence or lack thereof. And this is where the key phrase is here that I want you to focus on. If from such consideration you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. That means, are you sure? After you have considered all of the evidence, are you convinced? Has the state convinced you? That's all what beyond a reasonable doubt means. After fully and fairly considering the evidence, has the state convinced you? I don't have a weather report. I don't have video of the snow falling outside.
Seconds.
What I do have is snow outside. We don't have evidence of the driving here, but what we do have is it's his vehicle. He said he was driving. Keys were in his pocket. Vehicle is warm. There's nothing else. There's no evidence whatsoever indicating that he left the vehicle there and then came back at some point to fix the car. There's no evidence that he was dropped off. I specifically asked the officer, was there anyone else nearby? They said no. There was no one walking nearby. There were no vehicles stopped nearby. So what we have here is sufficient circumstantial evidence to establish the driving, and we have a plethora of evidence for all of the other elements. And because those elements have each been proven beyond a reasonable doubt, I would ask you to do your duty and to render a verdict of guilty. Thank you.
Thank you, Mr. Walton. Members of the jury, you'll now retire to the deliberation room. Before you do, juror number 7, you're going to be excused because your job is not to participate now, because we have 6 jurors, 1 through 6, who will be the jury in this case. And I want to thank you very much for being here. But don't leave just yet.
wait.
I will excuse the other 6, and then I'll chat with you briefly before you depart. Folks, you first select one of you to act as presiding juror. You have the instructions with you. Amy will bring you the 5 exhibits here and the verdict forms that you will need. When you have a verdict, just let us know. No, not those.
All right.
There we go. And you have the verdict forms.
So in the next 5 minutes, when you have a verdict, just tell us. Just make it known. Is my keyboard not working here? Because I'm on the wrong keyboard. That's why.
Adjournment number 7. You've been we hold you back as our reserve for safety purposes in case somebody can't make it all the way through the trial. And so I want to thank you because you've given all the time that the other jurors had. The only thing you don't get to do now is participate in a discussion on the decision. But it allows the other 6 to go back and have a 6-person jury. So thank you very much for serving as our alternate today. I will, if you leave your cell phone number with Amy, I'll make sure she gets in touch with you to let you know what the verdict is. Because you spent all the time with us, you're entitled to know that.
We all are. It's public information, Judge.
As soon as she comes back in here, because she's not going to stay in there with them while they deliberate. Yeah, she'll be back in just a moment. Get you your cell phone. You'll then be free to go. While you're waiting, do you have any questions for me about any of the process?
Yes, can I go? Jeannie G.
I'm sure they don't like hearing you say that.
No, I mean, I've been, this is my 3rd time.
Okay.
2nd time to actually be on jury. 3rd time. I mean, the 1st time, this time.
We're just chatting with the juror.
You want to tell us who the other lawyers were? All right.
The milliseconds is too much.
Yeah.
Yeah, it's gonna go away in just a minute.
They don't hear that enough, so it's nice for them to hear that from somebody who spent 2 days watching them work.
Jeannie G, thank you very much. 6 months. That is just absolutely awesome. Appreciate your support. You'll get to OG status here before you know it.
It's very complimentary. So as soon as Amy comes back, we'll get you your cell phone, and when you're picking it up, if you let her know your cell number, and she can let you know the result of the verdict. And it may come tonight or it may come tomorrow morning. So if you don't hear from her tonight,
can I get on that same
jury
list?
has to come back tomorrow morning to finish its deliberation. Depends on how fast they go.
Let me crop the box down so you miss the circle as well. How about that?
And we'll make sure you get on the jury list for the next trial.
She's been called 3 times already.
Being called 3 times, you kind of think you've done your duty, huh?
Yeah. We are officially in verdict watch.
Well, you've done it with good spirit, and I appreciate it.
Should we start the verdict music and just guess?
Do they? So somebody like you and like me wouldn't be called for jury duty? Well, I don't know.
Limit for judges.
Well, I have been called as a juror. I've never sat as a juror, but I have been called. But not recently. So maybe they put me on the old guy list and they're not going to call me. I don't know.
Your Honor, do you know what happened when Judge Meyer had jury duty earlier this year?
Same thing. He was not selected.
Yeah.
Attorneys very rarely are.
Yes.
Particularly judges.
Yep. They don't want to be second guessed.
Yep.
Anything about the process that you've just gone through the last 2 days that you think we could make better for you? Yeah. Mm-hmm.
Maybe the prosecutor could talk less.
Yeah. Unfortunately, there are conversations that the jury can't be, listening to, that we have to work through, and sometimes the issues can be. We started the trial. We had a long conversation that had to happen before we could bring the jury in. Juror number 7 would like the phone.
Yes.
Yes, and she would like to.
She would like to go home now.
Write her phone number down?
Yes. Give her a call when we have a verdict. So once again, thank you very much. And thank you for your kind words to the attorneys.
Should probably.
So it's 4:30 up there, right? The judges said 5:30, we're kicking him out. They don't know that. 5:30, we're kicking him out. We're sending him home. We have an hour for the jury to come back for a verdict tonight. And if it's a 5:20 verdict, we're sticking around for it. I mean, the judge will. I'm not sure if we will.
Oh, yes. That door to your left. Thank you. Have a nice evening.
See you, ma'am. We are still here. We're pushing on this live stream alone 7.5 hours, which is long. Normally we try to keep it under 6, but this time we just rolled with it. Took an early lunch, worked through their lunch.
All of the exhibits, right?
Cool. Hey, sorry, you going to bed? I love you.
Yeah. Are you just?
So we were just talking about dinner. For dinner, what was that called, Jen? Hey, bud, do you know what dinner was called? What's the name of it? It's like mini burritos, but they've got like black beans, a fried egg, grated cheese, guac, and salsa on them. I'm not sure what it is. Not sure if that might be called something or not. But the tortillas we used, for some reason, when we cooked them, they became very sturdy, and I could not bite them successfully. So I just ate the fried eggs off the top, and most of the rest. It was good. Did Ari just shake his wife's hand good night? No, I just reached out to her to say, hey, wait, don't go. What was dinner called?
Huevos rancheros.
Huevos rancheros. Has words. I don't know what those words are. Huevos? Cuevas? Huevos.
There's no Q.
The judge just killed the live stream. Huevos. Huevos? Can you say it in the mic over there? Say it.
Huevos rancheros.
Well, that's different. That's something different than I've been saying. So.
Yeah, you were like, put a Q in there.
I heard a Q. So.
What are you doing at this hour? What is happening?
Well, we were watching court until a minute ago, and then it quit. And
they said, it is bedtime. Let us be done.
They have an hour to deliberate. And so I have to refresh.
Before the sun rises? What is going on?
No, it's in Washington. It's a West Coast trial. This is why we don't follow them. This is terrible. But we're diehards. We're down to we're down to numbers where I could probably do a roll call. Right now. Everybody's gone to bed. Everyone's gone to bed. It's 7:30 p.m. Eastern.
Yeah, that's almost my bedtime.
Everybody's saying hi to you, by the way.
Hi, guys. It's been a minute. How are you guys doing?
Hey, did you see Paul Mex, the puppy she made for me?
Yeah. That was really cool.
I thought so as well.
I thought that was just really sweet and really, wow, what a talent. That's amazing.
Yeah. I don't know how to speak Spanish. Well, huevos, huevos. I don't know. Anyway, they were saying that, did you just shake your wife's hand goodnight?
Yeah, pretty much.
Yeah.
Like we do a quick wave. Hey, see you tomorrow.
You know,
we've been married that many years.
It's that physical contact that just cements the relationship.
Still committed. Yes, I am. Good night.
Yeah, I'll see you tomorrow. Lunchtime when I come out of the office.
I'm so tired. I have no idea what you guys are doing, but I'm just going to talk. My kids are just, all of them are studying all the different subjects. And so today we learned about the different planets' distance from the sun. We read the 5,000-year leap to learn about government and the proper role of government. I learned about different communication techniques inside families and biology, some pretty advanced biological stuff that I was like, ooh, I think I learned about that in college. Apparently, electron shells are not the proper form of of cell, or not cells, what are those called? Elements.
You're asking the wrong person.
That's what I was taught in college, that electrons come in different shells and then they just hang out in those shells. But no, I guess quantum physics says that they just sort of hang out in this area and then they disappear 5% of the time. We're not sure exactly where, but somewhere not in one of these little blobs of area. And it's just so much. By the end of the day, I'm tired. I'm making you sleepy. Me too. I'm tired. What? What you doing? Do you need my license and registration? What are you doing?
I'm lighting you.
Okay.
There we go.
Oh, yes. That's
So
awesome.
so you can
Thank
see
you.
You're welcome. This is so bright. Look at this. Sorry. Can you see now?
No.
Oh, okay. We learned about gas chromatography today.
Nice.
That was good.
I have no idea what that is. I mean, I know what chromatography is, but I don't know what gas has to do with that.
Well, I don't know either anymore.
Oh, it's after 7.
I failed the homework. So, yes, Mrs. R.A. saying that we were doing quantum physics in homeschool.
No, not me.
Okay.
My college kid was learning about the quantum mechanics that had to do with on an element on the atomic level of where you're going to find the electrons at any given moment. They're just probably here and probably there. 95% of the time they're in either of these areas, but the other 5% of the time they just disappear and we don't know where they are. And I was like, okay, I feel like let's just go back to the shelf thing because that made sense. I understood it. I knew how many electrons were on each shelf. It just made sense, but I guess that's not how it is anymore.
Yeah. Sorry, I'm adjusting the time, so we have the timer in the corner.
It's not late anymore.
It's late. I don't know if we're going to get a verdict.
It's guilty. It's always guilty.
This one, I really thought they were going to throw it out. It was so close.
What's this one about?
DUI and obstruction. It's a
Why
one-day
did you
trial.
think they were going to throw it out?
Because there was a discovery violation, and the discovery violation involved the failure of the prosecution to prove an element that the judge needs to allow the evidence into trial.
Oh, that should have been JOA.
Well, you think so, but the judge is like, well, but he was
I
able
don't
to prove
like
it
you.
after the fact this morning. Now that the jury's already seated and already heard opening arguments, you bring in new evidence. And since it's valid, I'm gonna rule that it is okay and it can come in. And since now,
Wait, why was it
now
valid?
Now it's just a discovery issue. It really wouldn't change anything for you if we gave an extension. So we're just going to go ahead with court and.
And wow, we just walked right around your constitutional rights. Stomp, stomp, stomp.
It was like that.
Wow.
Whoever, by the way, who is a scientist, like a real one. Says,
not like me.
Yeah. Gas chromatography is where they heat a sample up and the machine generates a graph that tells you which elements are in the sample, and from that you can tell what's in the sample.
Oh, yeah. So they do that. They do chromatography with different elements. I didn't realize that they did it with gas. Okay. That's cool.
I was thinking you could do it with like hyperspectral stuff. Turn on our sounds. Are the sounds not on? I've had them on. They're just low.
You guys, if you just yell at us, we cannot hear you.
Hang on. Let me do a quick check. It's possible the sounds went to sleep.
Because he's the guy.
No, they're working. They're here. So you heard it.
Hush. Now I'm trying to have court. You don't raise your voice
Hush.
again.
Did you just tell them to hush?
In front of the Walmart.
No, that's the judge. These are the sound effects.
You just told everybody to hush. I'm like, you need to be done. You can't be doing that.
Catch a whooping.
Yeah. Here's the problem. Court may come back with a verdict, and I just won't know.
I'm not going to argue about semantics here.
I don't think I can ask any of my mods who've been working all day to look for this, to watch for it.
They may not be here anymore. Are there even any mods still here?
You don't put a diplomatic plate on a hoopty.
Red's here. Josh is here.
Oh, you guys, you are amazing.
With more experience.
Amber's here.
I don't like
You do make me look bad. I do not have nearly. I do not provide the dedication to Scott's channel that you do. You are amazing.
Yeah. Paul and Max here. I'm here and we promise to behave. I was sharing with them that I'm trying to do this multi-stream to multi-channels. That's the next step. I'd like to grow the channel a little bit. And the idea came that we're going to need some mods on those other channels as well.
The idea came to you?
No, to chat. I didn't even think about it. It's just like, we'll just start streaming other places. What could go wrong?
You're right.
And
you're right. That would be
the suggestions for who would mod on different platforms have been quite entertaining.
Yeah, I think it would be fun to be like, this channel over here, we want this kind of mood. Which kind of mod would work best for that mood?
Yeah. So people are like, well, on this platform, you know, Ayden would be a great,
yes,
a great mod. Hang on, let me do a quick sound effect because somebody asked for it, Katrina.
Because we here in Canada hate you and hope for bad things for you because we hate you.
There you go. I haven't got that set up for you guys yet. It's just one that I can control. Quantum mechanics is not real. Time can't exist in two materials at the same time. Time doesn't have its own gravity. I'm going to take your word for you on that one. Can you ask the missus about when the next cooking stream is?
I got to say, the last couple of cooking streams we've done have really been Scott's, not really mine. So you should ask the mister.
I think we should cook up some Panda Express. Tomorrow for lunch. I'll handle the DoorDash part. You can plate it. You can plate it.
That's amazing. Thanks for letting me be a part of that.
We need cinnamon rolls. Everyone's asking for cinnamon rolls for a long time. It has to be Mr. and he doesn't answer. The jury should be about done. I agree. I just wish they'd tell us when they are. And
how long have they been talking?
16 minutes.
They should be done. That's plenty of time.
You know, if they can reach an agreement, that's enough. That's enough time. But let's see. Tell us about grandbaby.
Not here yet, but coming, and we're pretty excited about it.
We agree. Oh, we hit 67,000 today.
Did you really? Good job. Good job, everybody. That's awesome.
We've been like bumping up against that boundary for
I know, up
a
and
month.
down and up and down.
And today it happened, so that was really cool.
That's awesome.
Let's see. Still can't believe they hung on that other trial up here the other week. I know. Thurston County is just wild.
Who hung?
Thurston County.
Sorry, what did they hang on?
I forget what it was. I know one of the charges was dropped through or dismissed through JOA.
And then they hung on the rest?
It was. Can't remember. Tim, thank you for the congrats. I'm super excited about that as well. I love this job. Love what I do. Love that I'm able to do this and provide for my family this way. Let's see. RA got a 67K. Amber got an award at work. Selena will walk again soon, and Alicia's 5 years cancer-free. Red Pen,
wow.
That is the best summation of the day ever. And I notice you did not mention any of the court we watched today, which I can understand because this is a slower day.
And Red Pen, I know you've got big things going on in your life as well. Well, honestly, everybody does.
Yeah, Red Pen got drywallers lined up.
Girl, that is so...
Throw that in there.
I mean, I'm glad, but it's such a pain. It's such a thing.
But it is so relaxing to watch drywallers work. First of all, I love to watch anyone do a job that I would have to do if they didn't do it. Okay? it just the enjoyment level just hits that exponentially next level when that happens. But watching a drywaller work, there are very few people that work as fast as drywallers. It's like they hate their job and they want to do it as little amount of time as possible, but they're really, really good at it.
Yeah.
And they can throw drywall up in a room where you're like, man, it's going to be years before I have walls. And the next thing you know, it's like, well, I guess we can paint now.
Yeah.
It's just like that. You're a sick man. No, I'm just, they're just so messy.
In the air.
They're fast. But make sure they're in there on the stilts because it's always better if it's like the circus when they're on the stilts.
Our walls are really
use
tall.
ladders, I would complain and ask for a refund because you're not getting the full experience that you're paying for. Let's see. Did I hear my name or am I just dreaming? Josh went fishing. Andy took a nap.
Nice.
Pretty much that's all of his day for him. That was pretty much all day. And he did a couple pins and birthday stuff. Chatting on screen. Thank you very much.
He's cooking on them. I can see him. Not the screen.
You can see them too right here. They were just hard to read because my laptop. Ooh.
Oh.
Okay, we fixed it. It wanted to lean on me. Okay. I can't pin pins and sleep. Be glad you don't have popcorn ceilings. That's an interesting thing we learned from today.
Ooh.
That was good.
I had friends who had to take down popcorn ceilings, and it was, not a fun job. She's pretty amazing.
My mom did it. Took it down from her. Our front room used to have that.
Really?
It's terrible.
It is terrible. Why did we do that? That was a bad, bad plan.
It was a dark age.
We're still recovering.
It's like there are parts of the human history that we don't like to recall, and that was one of them. Whoever invented popcorn ceilings. And I say that as somebody who had to paint a house with popcorn ceilings. Laura says I'm staying quiet because I love our popcorn ceilings.
You do? I do not like them.
Have you ever tried to just dust it?
Just have a helium balloon. It's all joy is gone.
Kids hate them. Kids hate them. Helium balloon, gone. Even a regular balloon, you can't bounce it. Hits the ceiling once, boom. Wah! Just like that.
It's generally me saying, wow.
Unless, of course, you don't like balloons. And then you're just a...
You're just a hater. I mean, my goodness. Who doesn't like balloons?
You're eating popcorn as you speak. That's called popcorn floor. That is different. And as long as it doesn't get to like movie theater level, it's perfectly normal. Let's see. How sharp are your popcorn ceilings? Maybe the ones we have in Ireland are different, but it's barely noticeable. Okay, yours have a light texture where they put some mud on the ceiling and then they smooth it for the most part. That's different.
Ours
That's
are like
okay.
Stalactites.
Yeah, we have like think of like if you were caving 10,000 years growth on the ceiling from the coming down, and it ends in a spike. Like it's sharp. That's the sound it makes when the balloon hits it. Yes, stalactites. Today, my husband learned a quarter sheet cake is more than 4 pieces of cake. He came home with 2 pre-ordered quarter sheet cakes.
No.
We have more cake than we know what to do with.
A quarter sheet cake is the size of a regular cookie sheet. Well, it's our cookie sheets. Some people have smaller cookie sheets.
Well, Legally Blonde, happy birthday. You get to celebrate. And did you see Legally Blonde? Let's see, I'll show you. She went to Waffle House. If I can find it here.
You okay?
Yeah.
I mean, Waffle House.
Look, I'll go. Program.
I
There we go.
see that.
She got her birthday waffle.
Nice.
And they wouldn't give it to her for free.
They don't.
So we're taking them off the list.
Yeah, I was going to say, stop saying that they do that then.
Yeah. So there's that. What else happened today? Yeah, I'm refreshing on the computer. That seems
We
to be
learned about
better.
Archimedes and Pythagoras.
Like Pythagorean's theorem? Pythagoras?
Yeah. Somebody wrote
Never heard of
this
it.
child's book about what's your angle Pythagoras. And it is I read that book to my kids and I was like, oh my gosh, that's why we call it squared, because it makes a square. I was like, I did not know that. If you take the square of one side and the square of the other, you turn it into a square, then you add those 2 squares together, you get the square of the third. I did not know that.
We got a puppy today. Got a new dog.
Yep. I love that she did it so that the words are on the side.
That is just awesome. It is so cool. I mean, the shape is just incredible.
It's a dachshund. I had a dachshund growing up.
It didn't say Recovery Addict on the side, did
It did not. It was the old model.
It's the new model. Did I miss the naming? No, I'm going to ask my kids for input as well.
What are you naming?
Well, it's either going to be Buffer, Bailiff, Justice.
What are you naming?
Red Pen says name it Buffer. And she did the Buffer commands to... We're naming the dog.
Oh, okay.
Oh, I thought you said, what are you naming it?
Oh.
That's it. Okay. The dog needs a name.
Oh, yeah.
You can't just say, here, dog.
This is what I do. But yeah, you're right. It would be better to have a name.
Let's see. It needs to have a shock collar. Perhaps I could fashion it out of a tail light.
Oh my goodness.
What do you think?
So I just announced to Scott, I was like, I'm going to put the books back on the shelf. So how about you give me access to that shelf again? And he flat out said, sorry, no. Like, okay.
Do you realize I had to have all this stuff on my lap before. Now I have a full bookcase that's empty that I can put all my things on within arm's reach.
You have to sleep sometime.
And this is why we have divorce attorneys, guys.
Oh, them's fighting words.
It's her bookcase. I know I have to give it up, but I'm making a strong defense right now. Okay. The taillight eats up. Maybe we should start just giving stuff away.
Let's do that.
Do like a contest.
But there are a couple books still left up there. Let's not give those away.
We could do one. The person who gives the biggest super chat gets the
Taillight.
taillight. We have to do that one because it's going to cost like $70 to ship it.
And it's huge. It is so big. It's taking up all the space.
Let's see. Maybe we can ask Rob. Rob's in Virginia, right? He could make us a bookshelf. He can make me like I could tell him to get out in the shop, and I can't tell him anything, but I could ask him nicely.
It's not the woodworking that's the issue. It is the space.
I know. I'd have to move the whole desk forward, and then we couldn't get in that closet.
This is true.
Yeah.
Bigger house time. Our house is actually really big. It's just that Scott's stuff is quarantined to this room. And
I've never had that before. I've never been limited to just one room. And it's difficult. It's hard to contain. Because
this used to be now it's an office, but originally this was called the library because it had all the books in it. And now I have to just move around you to get my books. And now it's just the office.
We are blessed. We have a beautiful, we have an old house. I'll say that. We have an old house.
Yeah.
That was beautiful.
It's still beautiful.
It was beautiful back in the day.
It's currently not falling apart, so it's in my good graces for the moment.
Yeah. All right. Still no verdict yet. We're approaching 30 minutes. I'm watching. Limited to one room. I will tell you this, that if for some reason we were able to upgrade the channel, and I still have the boxes most of this came in, so we might be able to sell something and apply that to the upgrade. Or what would probably happen is I buy it and then part with the old one and sell it to pay for the upgrade that I just bought. Or I could get a Sprinter van. Are you nodding?
Yeah, I'm choosing silence. I think it's the nicest way to go.
Yeah. I think it was nice having you in here for a little while, Mrs. R. So thank you. Oh, no. It's been a long day. We're coming close on 8 hours of deliberation. And still no verdict. It's almost 8 p.m. Hey, mods, you can go to bed. Honestly, you're okay. I got it from here. I can handle this.
What could go wrong?
Yeah.
All the mods leave.
I can handle this level. If you get a van, they get the whole room back. There's
yeah.
that. Everyone's going to be good. So, let's see. A muck Northwest. Is that correct? Tell you what. It's been half an hour.
Alex stole it as well.
What time
In
is it
one
there?
more half hour. If we can stick it out for one more half hour.
Oh, pass the popcorn.
We're past the Mountain Dew. If we can stick it out for one more half hour. The judge is sending the jury home.
I saw a chicken.
Because it's 5 o'clock there.
Yeah. Oh, I just made something go away. That was the timer. I don't know where it went. It's back.
I'm not a cat.
Okay. Don't yawn in my ears, because then I can pass the popcorn ceiling. Is it Tuesday yet? It's Tuesday. Tomorrow's going to be hump day. We're almost there already.
I think it was last week you came to me and you're like, we're almost done with the week. We can do this. I was like, It's Tuesday.
Yeah, that was a bad day.
That was bad.
Still clicking refresh. At 5:30, the judge kicks the jury out and says, "You're going to have to come back tomorrow. Put on a pre-run for us. We need a simulation." Okay, we can do that because there's a good chance I'm not going to make another half hour. But I'm also so exhausted, I'm not sure if I can even sum up this case quickly in a fun and interesting and energetic way. So you get what you get, and you don't throw a fit. I will just say, we'll preface this with a beep. The verdict music you're about to hear is a test, and is only a test. That's it. The verdict's music is working. It's working. It's working. That's it. We were just doing a little test. Had this been an actual verdict, the music you just heard and the terrible drumming that went along with it would have been followed by a brief, witty, and complete summation of everything that happened in the trial to this point. But this is just a test. We now return you back to your regularly scheduled programming. There we go. That was it. That was just a test. We were just other Jules. I do apologize. I apologize. As chat goes wild. What? Verdict? What? No. In a moment of weakness, I got convinced to push the button when it was not actually a verdict. But test it out again, Stacy. What?
Is that the jelly bean, Stacy?
It works. They're back. They're back. Hold, please. Here we go. Here we go. Are you serious? That was our actual verdict music? Here we go. Holy smokes. I don't know. Is it a question? I don't see the defense here. What just happened? Let me turn that down, and this up. We have the prosecutor and the defense attorney there. No judge. I think this is a false alarm. Should have played it 10 minutes ago, says Josh. They were waiting for me. Oh, okay. I didn't realize that's how it worked. Okay, here we go. Here we go. Who are we standing for? Laura M says you're welcome. I think they were talking to the clerk. They can't start without the defendant. He's probably out changing a car tire right now. They can't start without him. Stacy, thanks for the super sticker. Oh, I think it was a super chat. Super chat. Thank you very much. Restart the music. This has got to be a question. It's got to be a jury question. Do you think the defendant pulled a Mr. Farag? Since we didn't see the videos, I would have to say not guilty. End of the day is 5:30. Let me switch this back so we can see the timer. Okay, there we go. 35 minutes, still going strong. Judge not here yet. Defendant's not here. If the defendant shows up, we're going to hit the button. How about that? And then if it turns out not being the verdict, I'm just calling it for the night. We're like, it's out. I'm done. Because if it's a question and they go back right now, Just kill the stream with no warning. At least they remembered to stream it this time. Yes, it's been worse. Other times they've skipped out on the last part of the trial, meaning the verdict. What was the final OK count? We stopped at just over 200. But there were at least 100 more after that. What if they get dinner too? I don't think they do. No free dinner. They're just sent home. Deal with it, says the judge. Can't sleep tonight if there's no verdict. Meg says, I've been gone 9 days. Scott, did you get glasses? I missed you all so much. Meg, I did get glasses. I got 2 pair. They're blue blockers, just blue blockers only. They're supposed to help with headaches. When I remember to wear them, they work quite well. I think pretty much
the security will stay for forever. Until we're done.
That doesn't sound like we have a verdict. That didn't sound like, that wasn't verdict type confidence from the prosecutor there. Security will stay forever. I would speak for yourself, Mr. Prosecutor. These guys, they're not getting paid the top dollar that you are. They have families that want to go home. Doubt the jury gets their meals paid for, considering they use a Zumba room for court proceedings. Okay. All right. This is a start. Now we just need the judge. They don't look nervous. They don't look expectantly at the juror door. They look like they're just doing homework, filling out their billing hours or something. I like the white, innocent white look on the shirt and tie combo. White shirt, white tie. I need more water, and I keep asking my kids for it, but they keep pretending they can't hear me. I think they're ready for me to be done for the night. Jen says, I moved for the puppy's name to be Jim. Already has the correct last name. Jim is on the run. That's why you think the puppy should be called Jim. All right. What do we have here? Question?
Understanding we have a verdict. If you will bring the jury in.
With less than 40 minutes on the jury deliberation clock, the jury has reached a verdict in this case out of Thurston County, Washington, where Mr. Woods is charged with driving DUI. He says, I didn't do it. The only thing you have on me is that I was changing my tire while drunk. Well, we have video that might say otherwise. As the jury comes in and brings their verdict with them, they might have said, The only thing we were missing in this case was a "that was easy" button, because this one was quick. This one was quick.
To the jury, it looks like you have reached a verdict. And juror number 4 looks like you're the one holding the paper, so I'm guessing you're the presiding juror. Is that correct? Okay, if you would rise, please stay right there and read just the narrative portion of the verdict forms.
Loudly.
So we, the jury.
As charged in note 2.
The suspense is killing me. The judge will make this right. He'll tell us. But I'd really like to hear it from the jury too. There's no mic. Prosecutor seems okay with this. Defense has his head down. Looks like it's guilty. I'm going with guilty on this one. Guilty across the board. With any additional aggravators as proven. Did they hit mute? Yeah, his head's down. Did the court mute us?
All right, the verdict forms appear to be in proper order. I'm going to ask each of you 2 questions, and if you would each answer those questions, please. Juror number 1, do the verdicts on these 4 different verdict forms reflect your personal verdicts? And also the verdicts of the jury. Juror number 2, are these your verdicts? And the verdicts of the jury? Juror number 3, do these reflect your verdicts, as well as that of the jury? And juror number 4, are these your verdicts? And the verdicts of the jury? Juror number 5, are these your verdicts? And they're also the verdicts of the jury? And juror number 6, do these reflect your verdicts? And they also reflect the verdicts of the jury. All right, thank you very much. I will accept the verdicts of the jury. And Amy, you'll need to, give me some.
He needs to sum this up somehow. Put a bow on it for us, Judge.
Let's see here.
I'm developing an ulcer.
It coming up.
Come on. He's going to adjudicate him guilty or say you're not guilty, you're free to go. One of the two. Don't make me call this court. This is terrible. Sealed verdict. It's like reverse of a grand jury. We seal the verdict. It's 8 o'clock at night here, Judge. Help a fella out. Are you guys getting the message? I'm not getting it. I'm not getting it. all day. I'm about to bust out the swear jar. You can say that again. Prosecutor's just like still playing Minesweeper, like nothing happened. What are they doing? You know it's bad when the mods use all caps. Amber? No, they're not frozen. They just... Like the judge's computer is acting up. And now he's like re-logging in or creating usernames and passwords. I don't know what he's doing. But... They've muted us because we're not on the record. Need smoke signals. Can we just have a bailiff walk in and arrest him or just cuff him if he's guilty? And maybe somebody give him the keys to the car if he's not, just so we know.
Mr. Holcomb, the state's sentencing recommendation, please.
Your Honor, firstly, I would indicate that the defendant has no prior DUIs in the state of Washington, nor do I have any information that leads me to believe that he has out-of-state DUIs. The defendant does have some out-of-state criminal history, although the most recent out-of-state criminal charge was in 2009, so that's not going to play a factor in my recommendation to the court today. Given the facts that occurred in this case, as well as I would add the defendant's behavior while on pretrial services. There were multiple scram violations while on pretrial services, and in fact, it led the court to resort to taking the defendant into custody due to the repeated scram violations. The state believes that 60 days jail is an appropriate sentence, with all other time suspended for 5 years on the DUI. And again, this is a first DUI offense, and it is usual for this court to have 2 years probation on first-time DUIs as opposed to 5. I would just note that the BAC was high in this case, and the defendant's inability to comply with the condition of not consuming alcohol indicates to me an ongoing struggle with alcohol that may further endanger the community. I would ask for, as to the obstruction charge, I would just ask for all time to be suspended for a period of 24 months with the conditions of no new law violations and the standard DUI conditions.
And that's a gross misdemeanor?
Yes, Your Honor. Both are gross misdemeanors.
Scram
and my
violation.
understanding from the sentencing grid is that given the jury's decision regarding the above 0.15 BAC, as well as the refusals that implicates mandatory jail time. I've got the grid up in front of me now. The BAC result above 0.15, the mandatory minimum jail time is 48 consecutive hours in jail for no prior offenses. As to the refusal, looking to see where that is listed.
I don't think there's any mandatory on the refusal.
Yes, on the refusal. It looks like it's the same as the BAC result. So it looks like either would result in the mandatory jail time.
Thank you.
Of 48 hours.
Ms. Moore.
Your Honor, in this court, we rarely meet people in the context of their best days. I think this case exemplifies that. Mr. Woods, I think, would fully own that he did not behave well that night. He was drunk and he was upset. But unlike a lot of folks who do come before this court, I think we can rest assured, given his history and lack thereof, that this does not actually reflect sort of the course of his general life. He has no history of DUI. He has no criminal history in Washington at all. He has really cleaned up his act in adulthood. He smuggled as a young person, but has done better for a long time. He has also stayed out of trouble in the intervening nearly 2 years that this case has been pending, dismissed, then pending again. He no longer drives. His license is suspended. His wife drove him here today. She's present in the courtroom, and he otherwise relies on ride shares. This is also not a case, as the court now is well aware, where driving behavior was at issue. As such, driving, I think, is not a public safety risk in the way that it often is for folks who've been convicted of DUI. All of these facts, I think, are strong mitigating factors that I would ask the court to take into account. And defense's request is for the mandatory minimum time. Mr. Woods has spent 24 hours in jail, but not 48. I would ask the court to take that into consideration and impose either just 1 more day of jail time or EHM mandatory minimums on the court's discretion. The reason for the request for EHM is that Mr. Woods needs to be able to keep his job. He supports himself along with his wife. He also has a 10-year-old son who he does not have custody of at this time. He's lived with him previously, but currently staying with his mom in Texas, but he does pay child support. And in order to keep the amount of jail time that the state is asking for would destroy his life. That's not really, that's not hyperbole. I would ask the court to impose any time above of mandatory minimums that remain or above mandatory minimums on EHM, which is, I know, within the court's discretion. As to the obstruction, we would be asking for 1 day credit for time served and to close that case. I will defer to the court as to length of probation on the DUI.
Thank you. Mr. Woods, anything you'd like to say?
Just overwhelmed.
I'm sorry.
I'm overwhelmed.
Yeah.
I'm just overwhelmed with everything. So I'm kind of like spaced out. It's definitely not what I expected. Still.
So I'd like to hear from Mrs. Woods. Is her last name Woods?
Yes.
She's also present in the courtroom.
Okay. So, Mr. Woods, if you don't mind, I'm going to ask you a question.
Yes.
The person I saw on the various videos that we watched today doesn't appear to me to be the same person I've seen over the last 2 days. So tell me about that.
The incident?
No. Just tell me, which person are you? The one I saw in the video or the one that's been extremely courteous and professional and on time here in court?
And I'm this person 24 hours of the day, 7 days of the week. I will say I was provoked. And hence why I was only focused on one officer, not a ton of them. I wasn't combative with them. If anything, I was being roughed up. I have a broken arm here that was healing. And my only thing was they were, like manhandling that arm. And so a lot of the yanking was because of my arm. A lot of it was, hey, listen, I was letting them know a lot of the things. I was trying to be cooperative as possibly as I could. I refused to be AC because that was my right. That was just it. My whole thing was just try to get home. Going to change the tires, going to call my brother and wait for him to come help me out with the car. I had someone drop me off there, and I decided to start changing my tire to get home. my brother, he was going to pick me up and help me out to get me home because I was drunk. But I just needed my tire fixed so I can come back and get my car the next day, and that didn't happen.
Okay.
Should have testified.
All right. Thank you.
His answers were bad, but tell the jury a reasonable story that could have happened, and that might have been room for doubt. He says somebody dropped him off, and he was just there to change his tire. He wasn't going to drive home. But the car was warm. Was that in the reports? The car was warm.
There's more. I'm assuming the affirmative probationary conditions have not been attended to yet.
Your Honor, no.
Okay, thank you.
You know that I don't know how the court wants to proceed, but Mr. Woods has indicated he's pretty overwhelmed. If the court would like to hear from his wife, sometimes our best advocates are not ourselves, but our family members.
All right. Thank you.
Yeah, the court doesn't want to hear from her.
Would you like to say something?
You'll have to.
She's like, no. Nope. Guilty's across the board here. Got 8 more minutes before it's nighty-night time for the judge.
If I could just briefly comment, Your Honor.
No, you've already commented.
The defendant just lied to this court, saying that he was not the driver. You asked him if he's a new person now, and he was in the video. He says that his behavior was provoked. The state is seeing zero remorse in the opportunity that was given to speak to the court.
Object.
All right. Thank you.
He didn't say he was not the driver. He said he wasn't going to drive it there. He drove it there, got a flat tire, and needed to fix it. He says he left this part out, but he said that he had someone bring him back there, drive him there. He had to change the tire. He was going to wait to get someone else to help him. He was going to change the tire and then have his brother drive the car and help him with his car to get it home.
Mr. Woods, you have no criminal history other than this. I'll wait till you're done. You had no criminal history other than this case. What I saw in the video was disturbing. We don't want to. I wasn't there, but we don't want to treat anybody the way you treated them for a prolonged period of time over that evening. And I heard what you said, that you felt like you were being abused by them. I didn't have that impression, but I wasn't there. But regardless, I think you made your situation worse by the way you responded. It could have been something less than that if you hadn't responded in that way. I am hopeful that you might reconsider your view of that evening and decide that maybe a reaction that way isn't going to serve your best interests. I'm going to impose 1 day in jail for the obstruction charge, give you credit for 1 day served, 363 days, remain suspended for the next 2 years on that case, on the condition you have no criminal law violations. On the DUI charge, that is a big number that came back from the blood draw. It shows fairly high level of intoxication, which when I saw the blood draw number, I assumed that was the principal reason for what I saw of you on the videos, was that a high level of intoxication had you being an entirely different person than when you are here today. So hopefully for you, that's something you also take in mind, which is
0.21.
Alcohol can set people off that way. I see lots and lots of that. And I hope you recognize that and make your own personal decisions about the use of alcohol, understanding how it impacted you on the 30th of November 2 years ago. So on that case, based on the conviction and the findings, you have a mandatory minimum of 2 days in jail. I'll give you credit for the 1 day that you've served. On the other day that you have to serve, I will allow you to serve it on 15 days of electronic home monitoring so you can keep your employment and meet your obligations as a father. I'm going with the mandatory minimum here. The state makes its argument as to why they think I shouldn't do that, and I've heard their argument. But I'm going to decide that the Dewan Woods that I've seen is going to be the Dewan Woods going forward. And so I hope you understand that. I'm only imposing them the very least that I can. And I hope, understanding that, you make a commitment to yourself that this isn't going to happen to me again. And if I'm ever stopped by law enforcement, I'll just be yes sir, no sir, yes ma'am, no ma'am, whatever it is. And hopefully you're not stopped by law enforcement. Hopefully you don't do anything to bring yourself to their attention.
There you go.
All right. And I want you, as a requirement of this conviction on the driving under the influence charge, you are required to get a chemical dependency evaluation and comply with any treatment recommended. You can do that up in Tacoma. That's fine. And attend a DUI victims impact panel. Likewise, you can do that up there, but we're going to need proof that you've done that. And I want you submitting proof to this court no later than the 23rd of November. So I'm giving you 2 months to come up with the funds to do that and to make arrangements to get it scheduled. And you'll have to comply with any treatment. You'll be on monitored probation down here. The documents will be sent to Thurston County District Court Probation. Ms. Moore can remind you of that. And you'll get a text reminder from us as the 23rd of November approaches, reminding you that we need to have those documents with the court so we don't bring you back into court to say, where are they? What's going on with the treatment? Do you have any questions for me?
I have one question on the logistics, Your Honor, which is that's 348 days remaining suspended for what period of time?
2 years.
2 years. Thank you.
I'm treating Mr. Woods like this is his first DUI.
Thank you, Your Honor.
Because it is.
And Amy, if you'll print up the judgment and sentences.
Legally Bond, the good news is you get to do all that cake again tomorrow, too.
The forms that I've just signed are being printed. I'm going to advise you of your appellate rights. You have the right to appeal your convictions. You have the right to an attorney on appeal. If you can't afford one, you can ask the court for an attorney to be appointed to represent you at no cost. To appeal, you must file a notice of appeal with Superior Court within 30 days of today's date. You must immediately serve a copy of the notice of appeal on all other parties. You must pay for the cost of preparing the record within 10 days after the clerk notifies you the record is ready to transmit. If you're indigent, you may be excused from paying. If you fail to file and serve a notice of appeal within 30 days of today's date, you have forever given up your right to appeal. And any form of post-conviction relief other than a direct appeal must be filed within 1 year from today's date. Mr. Holker.
Your Honor, given the pretrial services history here, as well as the high VAC, it would be the state's request for SCRAM to remain on until the defendant is able to submit proof of engagement in treatment.
Is the screen device still on?
Yes.
Yeah, on that one, I'm going to agree. Ms. Moore, once Mr. Woods is enrolled in treatment, then you can present an ex parte order to the court to have the screen device removed.
Thank you, Your Honor.
Okay. All right, and you have the documents?
Yep. Guilty on both counts.
Okay. All right, we are concluded for today.
Thank you.
Thank you. And folks,
Thurston County.
Thank you all for the time and attention you gave this case. I know it's not easy to sit in judgment of another person. I appreciate your diligence in doing so.
He kept the jury through sentencing.
I'm sure as jurors, it's not an easy job, and we all recognize that. So thank you all. You've been through the sentencing here today. Sometimes jurors don't remain for sentencing, and I appreciate that you all did. Do you have any questions for me about any of the process?
You didn't give them an option to leave, Judge.
The lawyers frequently like to hear your thoughts on how they presented the case. If any of you are willing to stay, that would be great, but you have no obligation, and you are finished your current term of service. So once again, thank you all. And if you choose to stay, the attorneys will just stay here and chat with you. But if you choose to depart, that's just fine. And Amy will get your phones back. So
all right,
we don't have them for you. Amy, go ahead. And court will be in recess.
There we go. All right, get out. Go home. We're hungry. All right, there we go. That finally wraps it up. Mr. Woods found guilty on both charges, both DUI and obstruction. Got sentenced to the bare minimum. The minimum the judge legally could give him, he did. And even in those 48 hours that he's required to serve, he gives him credit for 1 day time served and lets him serve the other in home confinement. So you can't get a lighter sentence than that with a guilty verdict on these charges in the state of Washington. So interesting. And it's been a long day. Oh my goodness. Looking at this. We are 8 hours into the live stream, and that's part 2. So let's go to bed. We've got a long day tomorrow. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning. I think about 8:30, we have the sentencing phase of that Florida trial, where it's a death penalty case. The jury has to decide if it's going to be death penalty or not. So it's going to be good. You guys have a wonderful night. Be good to each other. Thanks, you diehards, for sticking around. Maybe you've all fallen asleep and I'm just talking to your dogs. That can happen as well. So good night. Have a good one. We'll see you tomorrow. Bye-bye.
There's nothing in the order that restrains you from talking to cats.
Thank you.
Hush! Now I'm trying to have court. You don't raise your voice again.
Because he's the guy.